Hi, Manveen. Just wanted to quickly update that Professor Charles is yet to arrive. So the minute he comes, we'll get him over. Just keep an eye out and we'll drop you a one-line email.
Hello, and a very warm welcome to all our viewers who've joined us today for day 2 of the Global Law Schools Summit 2021. It might be a very good morning in India, and it could well be a late evening in North America, just about afternoon in Australia and New Zealand, and probably a bit more early in Europe. We have today with us 4 highly distinguished panelists for this session 8 of the summit, that is transforming the text, changing themes in legal publications. In no particular order, I would like to introduce the panelists for this session. We have with us this morning Professor Dr. G.S. Bajpai, the Vice Chancellor of Rajiv Gandhi National University of Law, Patiala, Punjab, India. Professor Dr. Donna Negi, Acting Executive Associate Dean, Indiana University, USA. Professor Maria Isabel Aninat Sahli, the Dean of Law School, Universidad Adolfo Ibanez from Chile. And we'll soon have with us Professor Charles Maimula, the Deputy Dean, Faculty of Law, University of Pretoria, South Africa. The theme of this session is quite inherent in what we as legal persons or legal scholars carry out in our day-to-day lives. More specifically, in academia, research, and writing. Early days of globalization witnessed a big epistemological movement in the pages of law journals, as well as law reviews and monographs. There was an unprecedented turn to legal studies, as scholarly anxieties on the nascent world order occupied the pages of law publications. Most of those writings pertain to the fall of modernity, loss of professional and disciplinary exclusivity, new subjects, critique of orthodoxy, autocritiques, self-reflections on professional convictions and sensibilities, and new movements and approaches. International, comparative, and transnational law became the predominant themes of reflection. Methods, styles, language, materials, and intellectual traditions were either celebrated or critiqued. The predominant mood was gloom and melancholy. The postmodern anxieties, as article or book titles, bore expressions like death, fall, decay, doom, limits, apology, despair, nihilism, and ambivalence. However, with the passage of time, 2 decades into the new millennium, a new hope began to rise as alternatives became the central theme of discourses. There permeates among voices of discontent a hope of being in the opportune moment to rebuild the world, if not to adopt and be resilient. Yet, at the same time, one cannot completely ignore the inherent reluctance on the part of a section of scholars to switch to these alternatives. Now, whether it is down to philosophical allegiance or a plain rejection of the change in the status quo of legal scholarship. Furthermore, research and writing with alternatives as their central theme are to a large extent dependent on academic freedom afforded to scholars and researchers by academic institutions, meaning thereby that the role of higher education institutions becomes extremely crucial and important. And it is against this backdrop that we are going to throw some light on how legal research has changed, more predominantly, how the text has changed in the writings over a period of time over the last at least 2 to 3 decades. So without further ado, I would like to ask my distinguished panelists the first question. And that is, this language of alternatives has been quite prevalent in legal publications in early 90s. To the extent that there were even journals and books named or carrying the tag alternatives in their titles. It also appeared that there was a renewed courage and confidence on the part of the authors to speak about alternatives. Interestingly so, this was ubiquitous across all branches of law. It raises a question. Does this indicate that there was a collective discontent with the past or present epistemologies? And if that is the case, how would our panelists today perceive the rise of discourses on alternatives in their respective areas of interest? Is there any pattern to be observed in such discourses? Where have we come to? Where have we reached today? Where have these alternatives taken us to? So I would like to ask the panel as to their thoughts on this particular aspect of alternatives in legal publications. Dr. Donna, would you like to go first?
Well, thank you so much, Mendian, for that very insightful introduction. It really sort of sets the stage nicely for a discussion that I've been much looking forward to, and it truly is an honor to join you all. It is my evening here, 9 p.m. East Coast time, and so, but I'm looking forward to a lively discussion. So, alternatives, it dawned on me that it might be useful to preface this discussion by talking a little bit about legal publications and the audiences that that we write for, and because when we talk about publishing alternatives, it across the field, it is appealing to a group of different audiences. And so in the United States, among US law schools, the initial decision makers on law reviews and law journals are actually law students. And so that is in general. We have a number of, in every field, there's a number of very prestigious peer-edited law reviews and peer-edited journals. But predominantly, journals in the United States are edited by second and third year law students, and the articles that are chosen by second and third year law students. And so I preface the response to your question with that background, because when we talk about things like disenchantment or pushing back on conventions, initially for the law professor seeking to publish in a student edited journal, one has to recognize that the audience is someone with very limited breadth and very limited understanding of the law. So part of the challenge before one presents an alternative perspective is very carefully outlining the initial perspective that one is pushing back at. And that probably would not be the case in a peer-edited type of format there. I think that really does change the landscape somewhat. In my field, so I teach and write in the area of corporate law and even more particularly securities law. And so in the 1990s, as we sort of start, I'll take securities law. There were questions about the source of regulation. Extraterritoriality was a very significant topic, and the question of how should companies be regulated in terms of their securities disclosure. Should it be where the companies are based? Should it be where the securities are listed? Should it be where conduct occurs? And so much of the reaction in the legal discourse was framed around this alternative concept. But I'll stop because I'm kind of interested in hearing from our other panelists in terms of their approach.
Thank you, Dr. Donna. Dr. Bajpai, would you like to throw some light on how do you perceive this aspect of alternatives specifically in the subcontinent and also let's say the Indian context, considering that we don't really have all the journals as student edited law reviews or student edited journals. We also have peer reviewed journals, and some of them are edited by some highly distinguished scholars and stalwarts in the field of law. So what are your thoughts on this particular aspect?
Oh, thank you, Dr. Manveen. Actually, my idea of alternative lies in the fact that I consider it to be a very unique mode of legal inquiry. First of all, let us understand the nature of alternatives as a mode of inquiry within the framework of legal research and largely within the framework of legal education. So when I say alternative is an evolving process in any particular discipline, because if you see that there are different kinds of modes of inquiry and research in a particular discipline, more specifically to the field of law, if we can see that there has been a dominance of classical scholarship, which was more and more concentrating on those conventional paradigms. And I'm using the term paradigms to denote the state of inquiry, as we understand that these paradigms are the concrete, they are the theories or concepts which are concrete application to theory and to the understanding of the subject matter of a particular. The issue is whether this transition of classical scholarship to alternative scholarship means something which is very unique to the field of law, or is it an evolving process within the framework of a discipline? That is first. Because this drift, what we call paradigm shift, why the paradigm is shifting to alternative scholarship? There are two very interesting reasons. One is that you yourself posed this question, whether was there any collective discontent amongst these scholars or amongst the scholarship community to utilize certain other ways to explore the truth, objectivity, and all that. So probably that process happened in all the places, including India, when we have started looking at what I call from rhetoric of law to the reality of the law. So reality of the law gave birth to the realists. Still, they were sort of looking at the context in which the law is enforced. However, the alternative scholars have come out with a very unique mode of inquiry. They were trying to look at why of the law rather than what of the law. So why of the scholarship has taken them to that kind of paradigm shift where the evolving of critical legal studies took place. In fact, the critical legal study tradition in the field of law is one of the consequences of the resorting to alternative scholarship in all places. So even in India, for instance, the growth of feminist studies, gender studies, environmental law studies, critical criminal law, like you asked about India. So during my days at National Law University, Delhi, when I was teaching criminal law, I started posing alternative questions within the conventional framework of criminal law. So conventional framework of criminal law is essentially black letter law. It is more of the rhetoric of the law. But if you take to the questions, if you go to the questions of the critical reflections on why of the law, then probably we look, because this critical scholarship has given birth to social activism. That is very important. And that is why the alternative scholarship is growing. Because generally there are people or there is a community of scholarship who are essentially are the believers of a status quo in the scholarship. They do not want to change the system, institution, and the scholarship tradition as such. Alternative scholarship is posing a challenge to the nature of scholarship, looking beyond the conventional domains or classical domains of understanding of a phenomena. That is why in India, this alternative or critical scholarship has impacted the course of understanding of legal issues. So if you see, it has impacted the courts, and courts are now giving decision. You are aware that we have LGBT decision, we have privacy decision. This is a paradigm shift. And this shift cannot take place unless you start believing into the alternatives paradigm. And alternative paradigms are actually, as I am saying, I'm very happy that you have chosen a topic. I haven't seen in the recent past this issue being posted as one of the subjects of discussion. And I'm saying that it has impacted the course of scholarship in India drastically. Therefore, we are finding now publication prefixing critical or prefixing alternative. Because alternative thinking is a reality. And I would go on to the extent of saying that it is not the growth of a subject, it is the growth of a scholarship. It is the indicative of the growth of a scholarship. So we now juristic thinking is shaping the course of alternative scholarship in India. Therefore, we are finding a lot of issues are becoming very, very important. I know there are obstructions in the growth of a scholarship. Probably we can discuss that issue a little later. But yes, there is a growth. But I would say this is not a collective discontentment in the sense that there is any kind of coercion involved. Rather, it is a natural growth of a discipline. And I can foresee we have installed a very new subject, probably that prefixing is not happening many places. So we introduced a subject in postgraduate studies in criminal law, critical criminal law. Now, critical criminal law means we are looking at the alternative traditions within the framework of that subject. And there is a community of critical thinkers in all fields, including criminal law, who are giving alternative paradigms. So there is a paradigm shift, like I teach mostly victimology in law school. So victimology, in a sense, is a paradigm shift from offender-centric thinking to victim-centric thinking. And when you fix your lenses from offender to victim, it means you are changing the nature of discourse in a particular discipline. Lastly, I always feel some of the subjects, specifically like criminal law, we have treated this subject as if the entire ownership of this subject lies with the state. So transforming from state criminal law to public criminal law, people's law, that transition is also very important. And all this, in a sense, indicate the evolving of alternative scholarship. And alternative scholarship, to me, is a genesis of the critical traditions in the field of a particular branch of law. And as I have just mentioned, the net result of this transition was social activism. Social activism came but for alternative scholarship, because they were the activists. They were actually posing critical question to the establishment, to the state, that you need to do this way. There are LGBT community, there are gender issues, there are environment issues, there are other kinds of issues. So state needs to give attention. Though they become marginalized within their own sense. And I also feel, I'll comment on this, that there is a lot of othering has happened. This otherness has happened. So generally we treat alternative scholarship as othering, as otherness, which is not a correct fact. Probably we can reflect on this particular issue a little later. Thank you.
Thank you so much, Dr. Vajpayee. I would say there possibly, and this is my personal opinion completely, there cannot be a better conversation on the aspect of alternatives than by touching on the LGBT community and their rights in today's state. I think across the world, the amount of discussion that has been going on, and the way people have come out in support of the LGBT community is something wonderful. Just to kind of drive home the point that alternatives are actually starting to find a place, not just in the books and writings, but out there in reality. And I'll come to that, Dr. Bajpayee. Again, you've given me quite a few points to actually, take this discussion forward. For now, I would like to go to Professor Isabel. Professor Isabel, I was just wondering, Dr. Bajpayee touched on the aspect of how things have been in the Indian context, and let's say with respect to LGBTQ community, and how we've seen that change. I was just wondering, how have things been back in your part of the world with respect to this dialogue on alternatives and their place in legal scholarship? So your quick thoughts on that.
Thank you. Thank you for the invitation, for having me here. It's almost midnight in Chile. So this is the wonders of Zoom, actually. So I'm going to speak on what you just pointed out on your remarks, but first, a little bit of context about Latin America. I would say that the professional legal academia in Latin America sort of has uniformed the forms of production a bit later on than what happened in the US and in Europe. So we're a little bit behind in terms of standard forms of production of legal research. Our journals are mainly peer reviewed in contrast to what happens in the US, right? But we have also seen these new topics emerge with very much force, I would say, part by different reasons. I would say one specifically would also be the fall of dictatorships that were present in the 70s and in the 80s in various countries in Latin America, including Chile, of course. And if you check, for example, in the Chilean law journals, the keywords that have the most published papers are actually on human rights and human rights discourses. That englobes LGBTQ, gender issues as well. And I would say that also it's very interesting to watch the transfer from the legal academia to what is happening on in reality, to what your remarks just actually went to. I would put this in context. In the Chilean example, we're undergoing a constitutional change. We have a constitutional convention here in Chile. It started sessioning at the beginning of July, and it will go on until at the first months of next year, actually. It's a year in total. And you see that the defining issues that are being discussed, we're discussing a whole constitutional change, right? So we're discussing the political system, we're discussing social rights, but then some of the key issues are gender rights. Another one I would say it's human rights in general, of course, again, related to human rights violations that occurred a couple of decades ago. But one that is very Latin American that has also come from, in part from the legal academia, not exclusively, is indigenous peoples. So the concept of plurinationality and what does that mean and defy the concept of a nation state. So these are some topics that are very, as you just mentioned, being discussed abroad, but also some are very, have been very relevant for the legal discussion in Latin America, particularly indigenous peoples. And the indigenous peoples today in Chile have a defining issue within this constitutional context. So the question is, of course, who the audiences are in terms of the academia, but also how does that audiences also relate to the general discussions that are happening in the country. And what I would say, what areas of the law have been more prone to these issues of, or the alternatives, as you mentioned, I would say that are much more related to these type of issues and to constitutional law or public law than to other private discussion or private law discussions, as Donna mentioned. And we can talk about it later, but what is the role of comparative constitutional law? And I would say that has been also very important in the Latin American context as well.
Thank you, Professor Isabel. That's quite insightful, and that actually brings me to the next point. Sorry, each of our panelists today touched on some aspects of public law, private law, and comparative law. That actually brings me to the next question, and I'll throw it open to all of you again. When we talk about comparative legal study or comparative law, it's basically nothing but a theoretical study of legal systems in close comparison with each other. And it has, of course, gained importance over the years. So much so that of late, there has been a rise in the number of writings on comparative law. And all of you present today here are scholars who've written on comparative law. So the question that arises then is, and what I would want to know from you, and I'm sure the audience would also want to hear from you, is the quality of published comparative law literature right up there? Or do you think there needs to be a change? There needs to be an improvement. There needs to be, like Dr. Bajpai mentioned that phrase in the beginning, paradigm shift. Is it required? Or do we say, the present quality of literature in comparative law is good enough and we can actually live with it? More so, is there an inclination towards comparative studies being carried out on just public law? Or is there adequate focus by journals and law reviews in the area of comparative private law? What are your thoughts on the same? You may go one by one, and I'll of course come to you. So, who would want to go ahead with the response to this particular question?
Maybe so I'll start just sort of stepping back and thinking about even this incredible conference that you've put on and will be putting on for the 3 days. I think that the pandemic has taught us worldwide a lot. One of the things, though, is the ease of collaboration. Through the wonders of Zoom, we now recognize that we can communicate, at least for me, in a whole new way in terms of thinking of projects. And so one of the expectations that I have as we emerge from this is that the relationships that we've built virtually, we will be able to build upon. And I think that will be reflected in scholarship through comparative projects. And so I think some of the best comparative scholarship in the areas of corporate and commercial law and securities law are collaborative enterprises where professors from different jurisdictions will work together and do a mutual comparison of the regimes that they are most interested in, and truly drawing lessons, truly drawing best practice in the area of business law in particular, because business is so multinational. It's imperative that when we think of issues, we think of the worldwide impact and not just the jurisdiction in which we're writing. So the trend that I would see in the quality of published comparative legal literature is going to be increased collaboration and increased learning in the vehicle of whether it's a book or a collection of essays or law journal articles.
Right. Thank you, Dr. Donna. Professor Isabel, would you like to go?
Sure. I would, different things, right? I would say that comparative constitutional law has produced, especially in the last few years, very interesting new production in terms of methodology. I would say that before we used to see a lot of, I would call it, because I don't find the appropriate term, but a sort of a cherry picking of certain regulations in terms of trying to put together an interesting production. And what we see today is that the methodology of approaching comparative constitutional law has produced very interesting articles and also not only academic research, but also databases. I'm, for example, thinking in terms of Tom Ginsburg, a US professor who has this constitutional website that allows you to research constitution and their amendments, and also a sort of network, actually. I don't know if you know ICON, the International Constitutional Law Society, that has national chapters. There's a chapter in Chile, in Argentina, and that has produced virtual or even actually local opportunities to meet and to sort of advance on different topics. And I would say also that within Latin America, comparative constitutional law, as I mentioned before, has a big importance. I mean, in terms of what I referred before as the example, but the constitutional change in Chile, we look very much at the process that Colombia had in the early 90s, that Venezuela had in the late 90s, that Brazil had a bit before, right? So even within the region, there's a lot of conversation of what went on a specific topic. I would say that in terms of private law, this is a bit behind. Maybe there's a very interesting discussion on the principles of contract within Latin America, but I would say it's still in an initial phase compared to what I mentioned before in terms of comparative constitutional law. And I would say that a different area that sort of pushes for benchmarking is antitrust. Because of OECD regulation, because of the US system and the European system, I would say that antitrust and general market regulation or regulation of the economy has promoted a very compared sort of benchmarking, constant benchmarking of where regulation should move and what are the issues. And that has produced a new area, at least in Latin America, that has been very, very important and will be, I would think, for the next few decades as well.
Right. Thank you, Professor Isabel, for your thoughts. I would now like to ask Professor Bajpai, considering that you are someone who's known for having written extensively on comparative criminal law and comparative constitutional law, and yet there are several other facets stemming from these two aspects of law. What do you think is the right approach towards comparative legal writing? Dr. Bajpai.
Yes, it's a very fascinating question because the comparative law scholarship is a traditional thing within the legal studies in India, especially in the field of public law and more specifically in the field of comparative constitutional law. However, so far the comparative law scholarship has been rooted within the comparables. So India being the common law country following adversarial process, we have been, benefiting from comparative scholarship initiatives in different common law countries, more particular in the UK and Australia and many other countries. And in fact, the course of comparative law scholarship was hugely impacted within the field of constitutional law, criminal law, and other public law fields. And therefore, I can visualize that the impact is now visible more and more in terms of adapting the best practices which are happening in other countries rather than substantive law, practical aspects of the law. So like for instance, the issues relating to criminal law, liability principles, gender issues, equality issues, freedom issues, policing issues, we have been benefiting a lot from, for instance, the experiences that we have in the UK. And now the scholars in India have better ties with overseas scholars in terms of carrying out joint projects. And I, at one point of time, also see the impact on non-comparables, like non-comparable jurisdiction. Say, for instance, during my tenure of a teaching in one of the places in Germany, Germany follows essentially a civil system. So they were quite enthusiastic about knowing the methods of teaching and scholarship that we follow in common law system, in adversarial system, mainly using case laws more and more. Whereas in in civil law system, they are more and more on law itself. So they were trying to infer and trying to understand whether the case law method could be a very interesting way of promoting legal scholarship in those countries which are essentially following the civil law system. This is very important. And I can tell you with a lot of conviction that the scholars in Germany particularly, they are more and more trying to adapt some interesting features of common law system. And therefore, in India also, if you remember the Malimath Committee, which was appointed for the reforms in criminal justice, it has suggested to adopt certain aspects of inquisitorial system, which is prevalent in Europe, in order to provide a right-based centricity to the victims of crime when they face trial and all that. Because in inquisitorial kind of model, judge has a very important role to play and to intervene. So what I am saying, the comparative law scholarship has now led to the adoption of best practices in different countries. So not essentially we are following their system, but we have recently adopted lots of things which are very unique and important in those countries, though they are following a different system. So comparative law scholarship is now looking at, like for instance, in the field of constitution law. So when Nepal's constitution was in the making, Nepal's constitution has essentially captured a lot of things which, mainstream countries do not have. Like for instance, the Nepal constitution now has right to health as a very explicit fundamental right. India or for other countries, do we have right to life, within which we claim that the right to health lies. So I'm saying the countries which are now redefining their constitution, are bringing amendments in their constitution, are essentially capturing those things which are now forming the part of central debates. So that is the advantage. And second thing which I find, which is a byproduct of comparative law scholarship in many countries, is the reform process. I would say criminal law reform process or law reform process as such is getting hugely impacted by developments in comparative jurisdiction. Two countries I can very easily mention here. Very recently, Sri Lanka has done a lot of reforms in their criminal law. And they were looking at India, they were looking at UK, they were looking at Australia and US also, in order to capture those best practices which can be factored into their law reform process. I am on the board at the moment for Criminal Law Reform Committee. I am the part of Criminal Law Reform Committee in India. And in my practice or in my engagement of criminal law reform at the moment in India, I'm essentially capturing the broader principles which now inform the due process consideration, or progressive aspects, or humane criminal justice aspects in different countries. So we are essentially learning from the core and central debates which are dominating in different countries to ensure the reform process in my home country. That is very, so probably the comparative law scholarship has not taken up to the extent of considering the reforms in the criminal or in the legal process. That is very important. And third is the theoretical contribution of comparative scholarship. Now, theoretical evolving of theoretical concepts or theoretical contribution has been a very, very dominant and very important, current. Now, people in alternative scholarship are doing huge work. Like in 2021, just a book has published. Other day, I was reading Jamal Green. He has written the wrongs of right in the United States of America, how the rights discourse is impacting negatively the United States of America. This is alternative scholarship. Or for that matter, in the US, when former dean of Harvard wrote, "When should law forgive?" A very, very alternative discourse. A law which is growing very, very punitive and retributive in many jurisdictions. Martha is writing, when should law forgive? So these are the, and now back in India and other countries, we are looking at forgiveness as one of the options in our adjudication of the cases. So I am saying theoretical contribution of comparative law is very, very important. So practice side, theoretical side, and reform side. Three very important sides are there where comparative law scholarship has benefited the countries drastically. Thank you.
Thank you so much, Dr. Bajpai. I think it's fair to say that when we talk about comparative law, we of course cannot ignore the aspect of case laws. Inevitably, we end up, comparing case laws across jurisdictions. There might be similarities, there might be dissimilarities, and there might be, more specifically, similarities in the application of law. If there is commonality between two legal systems, then we do end up comparing different jurisdictions, different decisions in those jurisdictions, and how their implementation over the years has impacted the evolution of law across jurisdictions. Which brings me to the next question, and that is that the traditional practice of reporting case laws in journals is, of course, time tested. And it draws cross jurisdictional parallels and allows for the adoption of a holistic approach to judicial analysis. At the same time, the changing ethos of society can result in some adaptations and deviations in the subsequent judgments without disturbing the sanctity of law as is laid down. It therefore raises a pertinent question, and that is experimentation advisable instead of mere flexibility in precedent laws, which would then keep the social fabric intact while undergoing constant evolution? So, is it so that if we are to choose between flexibility and experimentation, you'd probably go with experimentation and not complete flexibility because we're not really sure what's going to happen? So, I would want to ask Professor Isabel, what exactly is it in Latin America that would probably help you to answer this particular question? Professor Isabel, over to you.
Thank you. Well, this is a difficult question for Latin America because we come from a civil system and then we move away, right, from the precedent law. And I would say that we navigate in a system of tension, right, between sort of certainty and then justice in the particular case. Just I'm going to use the same example that I've been using the whole panel, but we are now in the midst of a discussion, as I mentioned, of a change of the whole constitution, and that entails a discussion of the justice system. And if you see if you watch the convention in Chile, and you can actually watch it because there's a TV channel. Part of the discussion is, well, what should the role of the Supreme Court be in Chile? Should we move to a similar system, much more like the US? Or should we maintain what the Supreme Court in Chile does? And that is, I would say, an option for justice in the particular case, moving away from the certainty of the present system. And I would say that because of this context, the role of the academia in analyzing case law has been much more focused not on the rupture and not on sort of moving things ahead, but much more on sort of analyzing the development of jurisprudence and of what are the trends and sort of also identifying what are the legal vacuums that we have to address, right? So our framework actually is very different from yours, and I would say that that goes right to what we were discussing a little bit before, where the challenges of having these different points of origin or frameworks for doing comparative constitutional law, actually. In some areas, I think the discussion is different, but in this particular area, I think the initial point is very, very different. I don't know, it's better or worse, but it's just different.
Okay. I think that's a valid point, because we cannot really say that countries or jurisdictions across the world would probably have the same outcome when we touch upon this particular aspect of law and presidential law as such. On that note, I would like to ask Dr. Donna as to what exactly is it in America that prompts you to probably side with one or the other aspect of alternatives.
Yeah, as Professor Isabel was talking about the role of our U.S. Supreme Court, and we're thinking of sort of stability versus experimentation, I'm sort of struck by the irony that today our United States Supreme Court for 2 hours heard arguments in terms of whether the longstanding reproductive freedom decisions of Roe versus Wade and Casey versus Planned Parenthood, the right of reproductive choice, is going to stay as the law of the land here in the United States or not. And so this whole discussion is such a timely and sort of heartfelt issue in contemporary. The Trump presidency as well, and the sort of post-President Trump Supreme Court, I'm not sure where the stability is going to be. I mean, it is a constant topic of conversation in terms of the political nature of judging, and we may very well be seeing many of our cherished precedents being just one after another coming down. So I did want to respond to that aspect of Professor Isabel's point. Dr. Manveen, though, you had a particular issue you wanted me to focus on.
Yeah, so what I was actually pointing at is the fact that whether we could say that flexibility is something that could be adopted as a norm or as a more preferred option over the experimentation. When we talk about reporting case laws in journals or largely speaking, how we approach legal writing. So my point was simply speaking, the fact that which of these two approaches would you prefer or you see being preferred in the United States?
Yeah, I think that as a federalist system with 50 different states, certainly the virtues of experimentation has often been accentuated, and that would go in many different types of scholarship and forms of scholarship in terms of critiquing the value of experimentation. And so that can certainly be seen in areas such as corporate law, where we don't have a single national area of the law. States are developing their own corporate law, Delaware being the predominant jurisdiction. But we certainly, and I think the two concepts are very related, because with experimentation does come flexibility.
Sure. Dr. Vajpayee, due to the paucity of time and as a matter of fact, I would also have to direct at the panel a few audience questions. If you could please sum up your views in about a minute and a half on this particular aspect, and then I'll quickly jump to the audience question.
Yes, sure.
Thank you so much.
As far as the theory of precedence is concerned, I feel that the course of scholarship is not changing. India is a country which is too dominated by the doctrine of precedent, especially in cases which are before the Supreme Court. They are expected to follow the theory of precedent. But the issue is that lately the cause of justice has emerged much more important than adherence to the doctrine of precedent. I would suggest that the ideas that the Supreme Court is recently exploring, they are not necessarily following the theory of precedents in many ways. Like, for instance, in death penalty jurisprudence in India, the courts itself has broken the tradition several times, going beyond the stare decisis or the theory of precedents in many ways. Like, for instance, very recently, the Supreme Court said that the potential to reform will continue to be a very important factor. However, many times there is a zigzag sort of course that the Supreme Court has adopted. So I would say only in conclusive remarks that adherence to theory of precedents in the matters relating to the larger cause of justice is no longer relevant, because alternative scholarship has given rise to a different types of thinking. So now we are looking at the rights of vulnerable, rights of minority, like in Sabrimala temple, the Supreme Court held that even the concerns of minuscule minority can be of importance to us. Their number is not important. Doesn't matter what the previous cases have been saying. So there is both ways. Sometimes the theory of precedence is held, sometimes it is not upheld. Both the things are happening. So I find that this flexibility is a very important pointer to the growth of the discourse on justice. So mechanical or instrumental sense of justice is not important. Substantive sense of justice is more important. Thank you.
Right. Thank you so much, Dr. Bajpai, and to the panelists for their insightful comments and views on this particular aspect. I would now like to quickly jump to the audience questions, and I'll see how much the time permits us to take them up. It's a very interesting yet intelligent question that has come up in the chat box, and that is, what are the factors that restrict the implementation of alternatives in reality? So who would like to take up that question? Dr. Vajpayee, please go ahead.
I'll say, actually, there is a resistance to alternative scholarship in the mainstream academic community, because, as I have said in my previous remark, the alternative scholars are considered to be the others, and this othering effect is the first restriction. Secondly, there are pressure within the academic community, within the social community, to become more and more to adopt the role of that of conformist rather than deviant. Alternative scholars at times are considered to be one of the deviants in the academic community because they are talking about something else. So there are pressure. Third pressure is already where Dora has pointed out, that in terms of publication. So publications, though they mostly the publication community continue to be dominated by the classical scholarship holders. So they judge the alternative scholarship through the lenses of classical or dominant scholarship approaches. Therefore, the alternative scholarship faces a lot of hindrance in the process. And as I say that this mainstreaming of alternative is resisted because you are breaking the tradition. And moreover, in legal academia, there is a system of maintaining the status quo even for the scholarship. So we feel comfortable within our own way of thinking in our own domain of scholarship. The moment it is dismantled and challenged, there is a resistance. So probably these are some very crucial concerns which have some detrimental impact on the growth of alternative scholarship everywhere.
Thank you so much, Dr. Bajpai. I have a good 1 minute left. So if Professor Isabel and Professor Donna want to take 30 seconds each, I'm more than happy to come to you. Professor Isabel, I'll go to you first.
Thank you. I want to thank you again for the invitation. It was a pleasure to be here. And I just want to say that maybe next year we can talk about something that I think is so also very interesting, which is the relationship between legal research or the legal academia and other disciplines. So how we as lawyers research with economists or with social scientists in issues that are much more complex. I'm thinking, for example, climate change. And what are the relationships that we have to establish and the methodologies that we have to use? I think that will be a pertaining question for the law in the next few decades. Thank you again.
Thank you so much, Professor Isabel. Point well taken. Dr. Donna, 30 seconds. Sorry for pushing you.
No, that's okay. So I too just want to conclude with a big thank you. It truly has been an honor, and I've enjoyed the opportunity to interchange. Funny enough, my concluding point was mirroring Isabel's. There was a time where legal scholarship, where the whole idea of alternative approaches involved sort of the law and movement, whether it was law and economics or law and philosophy or legal history. And so much has sort of grown out of that. And I think looking at some of the recent work in linguistics and law and linguistics and better understanding the ideas of artificial intelligence as well is, an area. So I think this is just the beginning of a very interesting and fruitful conversation that I look forward to participating in the future.
Thank you so much, Dr. Donna. With that, we would conclude this particular session. For all the viewers who've joined us from India and abroad, thank you so much. And sorry to wake you up early in the morning in India and to keep you from going to bed in the US and Latin America. It has been an absolute pleasure to host you this morning, and I'm extremely thankful to you on behalf of my Vice Chancellor, Professor Dr. C. Rajkumar, who has joined us now. Thank you so much, Dr. Bajpai. Thank you so much, Professor Isabel. Thank you so much, Dr. Donna. And to the viewers, I would just like to say, we would be beginning with the Judges Colloquium in about 13-14 minutes from now. So please stay tuned. Thank you so much.
Thank you very much, Dr. Bajpai. And
thank you. Thank you. Very good morning.
Really appreciate your presence and your contribution to the fascinating session. Thank you.
Thank you. Thank you all fellow panelists, Isabel and Donna and Dr. Manveen. My greetings of the day. Have a great day. Thank you.
Thank you, Professor Raj. Thank you so much. Bye.
Thank you. Bye-bye.
Thank you.
should just all be ready.
A very good morning to all of you in India. Good afternoon to our friends in the Southeast Asia, and good evening to our friends in Australia and probably some parts of India late, some part of the world late in the evening. I would like to extend a warm welcome to the second day of the Global Law School Summit, and we are about to begin the thematic session entitled Global Judges, Globalizing of Judging. We have with us Honorable Ms. Justice Sabrina McKenna, Judge of the Supreme Court of Hawaii, United States of America. Honorable Mr. Justice Arjun K. Sikri, former Judge, Supreme Court of India, a distinguished international judge at the Singapore International Commercial Court. Honorable Mr. Justice Michael Wilson, Judge of the Supreme Court of Hawaii in the United States, and also Her Excellency Honorable Margaret Beasley, former President of the New South Wales Court of Appeal and currently serving as Governor of the state of New South Wales, Australia. As we know, globalization, as in every other domain, had its impact on judiciary as well. Like every other institution, judiciary also came under the demand for greater transparency and accountability. This unassailability judicial pronouncements enjoyed from criticism began to diminish as all regimes of authority fell within the fall of modernity. Hence, judiciary had to reinvent itself under the postmodern temporal conditions. But it did invent its institutional self, rediscovered its identity, and reorganized at various levels through extraordinary juridical imaginations. Of the many reimaginations, noteworthy has been the renewed sense of professionalism and outlook of judges. Thus was born the image and concept of a global judge. If global is the postmodern time space, the global judge is the one who has global sensibilities and global consciousness. That is to say, global judge is the one who is conscious of the historical process of the fall of modernity, the end of histories, rise of postmodernity, the rebirth of ideas and thought, and the emergence of liberal democracies. They understand the integration of local and global and the essential connect between everything everywhere. Seen from an intellectual and phenomenological perspective, the global judge is not localized in their imagination and has transnational and comparative perspectives, what is often referred to as transjudicialism. They appreciate pluralities, even of the truth, and intersubjectivity, such as they do not fall prey to grand narratives and false objectivity. They cherish the essential values of justice, rule of law, access to justice, cultural relativism, humanism, and tolerance. They recognize the new subjects who have earned a representation in global society and who were earlier pushed to the peripheries and respect and protect their rights. They also sense the inevitabilities and necessary evils of global society, self-interest, capital mobility, ubiquitousness of politics, and unpredictability and incoherence. How have the global judges, imbued with the above said qualities, transformed the judicial landscape? What has been the impact of their enlightenment in the delivery of justice? What is their role in social production in global society? What are the striking instances of their thinking and acting globally? Such and similar questions will be the subject matter of this distinguished panel of jurists from around the world. Let me begin by my first question to Justice Sabrina McKenna. When we speak of the globalization of judging, what comes to mind is certain essential knowledge, skills, and qualities which a global judge shall have. Let's start with knowledge. The globalizing society requires judges to know and apply things globally, particularly through comparative perspectives. How can the comparative perspective be developed when the judge, no matter how much globally conscious they are, has to function in a local context? How can transjudicialism, which is an openness of mind, can be created in domestic judicial settings? Over to you, Sabrina.
That is such an extremely interesting question. You know, I think the whole idea of global judging and transjudicialism is, and as you've indicated, judges, we only have jurisdiction over limited jurisdictions. However, we can and do talk to each other. I think what's really important is that judges think globally and act locally. And in order to develop judges like that, it's really important that judges, you have the kind of people that have a love of learning. And it would be wonderful if one can travel all over the world. I have been blessed to be able to do that. But it starts at a much younger age. Are you a reader? You can learn about the world. You can travel the world through reading. Or now with media, with just watching TV and movies, whatever. So people can become global without traveling. However, it's really important that judges communicate with each other, not just locally, but nationally and then transnationally. And it's been wonderful to be able to converse with judges from around the world. I have a lot of opportunities, as everyone here, to speak to judges from around the world to exchange ideas, whether it's in Europe or South Asia or East Asia or other parts of the world. And so you learn from each other, and there is so much that we can and should be doing at a transnational level, transjudicialism, especially in the areas of environmental law, climate change, and human rights.
Thank you very much, Sabrina, for setting the tone of this panel. Let me move to Honorable Margaret Beasley. Margaret, now, of course, I want you to reflect on the same question, but you may want to add that to what extent common law jurisdictions are equipped to kind of enable judges to be able to look at other jurisdictions, even when they are interpreting in domestic settings.
Again, a very interesting question. And Sabrina, very interesting that you raised, for example, two things which in many ways I think are at the center of what we might be aiming towards. And that is that concept of think globally, act locally, and the means by which you might think globally, and that you threw in a particular area of environmental law, which is exactly one of the areas where I thought, and I think that we have a global context. I would suggest that there really is no longer a true common law jurisdiction. We are a common law country, but increasingly we are regulated, governed by, have to apply statute law. Our administrative law, for example, is very much statutorily based, and indeed many areas in the environmental law field are regulatorily based, whether it be, for example, town planning, which is an environmental issue here in Australia anyway, whether it be energy law, whether it be now, as we're beginning to see, space law, whether it be the law of the sea. So we really are speaking in a hybrid world very much. It's almost the word of a couple of years ago, it was unprecedented. It was the word of the time. So I think these days it's hybrid. So I don't see that coming from a common law jurisdiction, one is sort of particularly hamstrung by the fact that there are sort of major part of the world is civilly based, a civil law based system. I think the concept of thinking globally was interesting and how we do that. I do think that you can get that sort of base by very wide reading, and one would hope that we're all in that field and that's what we do. I must say, however, that some of the sort of more expansive experiences I had in terms of a global appreciation really came through conferences and actually through the International Association of Women Judges. And they have a very interesting process, or very interesting construct, because at their international conferences, every topic is judging and, so it could be judging and the environment, judging and the aged, judging and human rights, judging and corruption, and the like. And by putting it in those terms with judges from all over the world, and judges at all levels of the court hierarchy and the court specialisation system come together and they express views and their understanding of what judging involves in respect of that particular topic. And I was once asked, holding at the last moment, to chair a session on judging and the ageing, and I thought I'd drawn the short straw. And I have to tell you that by then doing some research about some demographic research to start with, and then having the two panelists, being one from America and one from Uganda, and to put their, not only their legal knowledge forward, but their social understanding forward in both that they had both from their judging experiences, from their cultural experiences, and from their family experiences. And I thought if there was one topic that really was an eye-opener into the way different jurisdictions react to a common problem, that was it. But you can pick any topic you like and you will find it being able to be discussed. I don't think it would be as a valuable experience. We talk about our experiential knowledge. I don't think it would be such a valuable experience if it were not pinned at the very beginning to the concept of judging. And to me, I thought that was a sort of amazing exposure. You have lots of conferences on cross-border issues, of course. Cross-border insolvency is a classic. So you can start bringing a lot of these in, and it doesn't come out of the International Association of Judges, women judges only. It really comes out of an international association of judges, and therefore of judging.
Thank you very much, Margaret, for that. And I entirely share your perspective that to a large extent, some of these issues also depend upon the type of issues that you are adjudicating, and some of them end up becoming more amenable to that type of transnational, transjudicial conversations. Let me move to Justice Sikri. Sir, in the Indian context, I quite remarkably, particularly the Supreme Court, but also the High Courts, have rarely hesitated to draw upon other jurisdictions, not only in the fields of public law and human rights, which is quite natural, but also in other areas of law. Do you think there are peculiar and unique reasons why Indian judges are much more open to drawing upon other jurisprudence from different parts of the world?
Again, I would say very interesting question when it comes to Indian context. As you have rightly mentioned, and if you see the judgments of Indian Supreme Court and various high courts also, not only on human rights issues, but other issues, maybe commercial issues also, and family issues, etc. I have seen and have myself done where we have relied upon the jurisprudence which has developed in other countries. And a good thing is that in India, the judges felt, and I've seen this trend right from 1950 onward itself, when the Supreme Court was established and our constitution came into force. That, if I may say, this is what is said about Indians and our philosophy is that we welcome light from wherever it comes. And that has been creeped into insofar as judiciary is concerned. But having said so, general remarks, let me tell you the specific reasons which I feel have led to this. And these reasons are not peculiar to India. They may have universal application when we are talking of this transjudicialism and the global judging. What I feel is that, number one, there are many constitutional issues which have universal application today, and all jurisdictions are facing these constitutional issues. If you, I give the example in United States also, the debate on Roe versus the judgment has again erupted about that.
there are certain issues which are highlighted by my earlier speakers also. Environment is one such issue. It is not today confined to only, it can't be localized. It has when we are talking about so many summits on environment and how to take care of the climate change, etc. Refugee problems. Again, most of the countries have this. And issues which are now arising relating to the data privacy issues, which everybody is, and apart from that, social issues which have, this implication, constitutional implications, like whether death sentence should be abolished or not, issues relating to euthanasia, LGBT, abortion. So these are some of the issues on which we have to have universal application. They should universal standards because they are not confined to one jurisdiction. So while deciding such issues, at least Indian judiciary has felt that we should have the experience of other countries also. And many times while deciding these issues, if I may tell you, give the example where we had this Aadhaar judgment, where the case was made out that the Aadhaar, of course, it pertained to data privacy or data protection, where much from other countries, etc., what are the data protection laws was taken into consideration. But more than that, in order to judge the reasonableness of a restriction in the form of intrusion into the privacy when Aadhaar is there, regime is there, the doctrine of proportionality, which the Supreme Court evolved in this case for the first time. We knew this has been discussed or originated in German Constitutional Court, and Canada, and thereafter in US also and other countries as well. So, but yes, at the same time, after discussing in detail what is the position in Canada of proportionality, what is the position in Germany, and what could be the best. There were some differences, but what could be the best alternative insofar as India is concerned. But what I'm trying to say is that these are some of the aspects which necessitate banking upon the experience of other countries or other jurisdictions, because the very issues have universal application. That is one. Second, I would say globalization. When globalization has led to economic activities with increased economic integration, etc., which has led to convergence of laws. We know today UNCITRAL comes with model laws. Model law on arbitration is there. Model law on now mediation has come out, on which Singapore Convention has been signed. And there are along with that, third thing which comes is about the cross-border ramification of these there may be domestic issues. Take, for example, Amazon judgment, which that is arbitration which is going on in Singapore, and this emergency award which was given. The implementation of that emergency award, it came to India. So therefore, it has the ramification. It is something is decided where, as per the Singapore law, because that is the law applicable. But then when it comes to the enforcement of that, so on many of these issues, it becomes necessary in any case. I give you a very interesting example. Many times on such issues which are emerging for the first time, say in India, and we don't have any precedent. And then we see what can be done. There was a film called Nishab, which had come, and there was a challenge to that. Under the Trademark Act, somebody had said that I had already produced a film of this type. Of course, that was a film which was not, commercial, under the commercial cinema. But then that was filed, and I remember it came before me. There was no precedent in India on the copyright on a title. But I went to American law and I found hundreds of judgments on that. And as was said, common law countries, when we are common law countries and the value of precedent is there, Of course, we will have to see in the context of our Indian law, that Indian Act and that provision. So whether, and we have to see the draw the comparison that the judgment is given in the context of a statutory provision in that country, whether those statutory provisions are same or not. And if you must have seen that many times, I give another example under the Contract Act, then under Section 73 of the Contract Act, damages, etc. So English law, although Indian Contract Act has been drawn from English contract and is an act of 1872, but what the Supreme Court found very early in times, in I think 60s only, some judgment was given that the entire regime of damages which can be awarded for breach of contract is different from England, and therefore we can't have. So therefore these are some, we have to have, but then these are some of the reasons because of which Indian Supreme Court, take the example, if I may say at the end, this Article 21. Now Article 21, whether that nobody shall be deprived of his life and liberty except by the process of law, whether due process or not. There had been a debate from initially correcting, etc. It was decided that due process, which is in American Constitution, word due is not there. We should not. But ultimately, in Menka Gandhi, the court has held that no, we should read due process into that, because what I will say, that is by reading it, we are giving proper meaning to Article 21 for which it is meant. So therefore, these are some of the reasons because of which I would say that Indian Supreme Court and the High Courts have been more liberal. I've seen, and there is a debate of this nature in America, in many judges, they feel that no, we should not draw on the precedents of other countries.
We are going to come back to that, sir. Just in fact, I know what you're saying. Justice Scalia's judgments, we'll come back to it shortly. Justice Michael Wilson, over to you. Michael, while we are discussing this, one of the things that has also led to a situation where we are talking about what Professor Anne-Marie Slaughter has described, what she talks about is that transnational judicial dialogue is happening in which courts are using comparative legal analysis. And she has described this, and I quote, a process of collective judicial deliberation on a set of common problems, unquote. Do you think that's where we are going? We are moving in the direction on some of these issues?
Raj, it's a real pleasure to be here. Thank you very much for the invitation, and it's always a learning experience to be with Her Excellency as well, Judge Beasley, and one of the great judges that you and I both know that we've been able to spend very, very important time with is Judge Sikri. So, Justice Sikri, I'm honored to be with you too, and I'm a bit humbled to be in the presence as well of my great colleague, Sabrina. So this is a terrific opportunity to learn. But to answer your question about whether we're moving in the direction of transnational judicial decision-making and whether there's a dialogue that's been created, I mean, that is such a profound understatement. We have a variety of international judicial institutions that have arisen very quickly in the last decade. And why is that? Whether we're talking about the International Association of Women Judges, whether we're talking about the European Judges for the Environment or the Global Judicial Institute in the Environment, I mean, there are a vast number of institutions that have formed that make the point that you just raised about the kind of dialogue that's taking place. But I mean, what is the future of this kind of narrative? What is the future of this relationship? And I think that it can be seen as a kind of reflection or an evolution of what has been started by great courts like India's court. I mean, Justice Sikri talks about Article 21. While the right to life has been something that has been addressed by many different courts now, from the point of view of interpreting, as the Supreme Court of India did, for example, the right to a clean and healthy environment to be part of the right to life. That's just one example. So the needs of our world community to be able to have these kind of overarching principles, whether we're talking about international rights to commerce, international human rights, or, and I can't neglect mentioning the great Court of New South Wales, which Justice Beasley has been the leader for. There are some extraordinary judges who have become very international and very much leaders, not the least of which is Brian Preston, who wrote a great decision, the Gloucester case back in 2019, where he referred to many cases from around the world, but at least half a dozen from the United States. Another member of the Supreme Court, Francois Coke, wrote a very interesting article that pointed out the need to be thinking globally, applying it locally perhaps, and that need was expressed in the proposition that we're not going to have a rule of law soon. In 40 or 50 years, as he pointed out, when we get to the point where climate change has become severe enough and you have 160 million people leaving Bangladesh because of sea level rise, the rule of law is likely to start disappearing. So we need to think collectively. We need to gather together on some very, very powerful principles that are new principles, really. I mean, what are the principles that are applied under Urgenda? Urgenda just took over in many ways in terms of a principle saying that the citizens of the earth have a right to a stable climate capable of supporting human life that's being represented and supported by international documents such as the agreement in 2015. So I'll end my remarks there, but yes, it certainly is true, and it's an understatement that now we have this very powerful narrative dealing with transnational judicial dialogue.
Thank you very much, Michael. It's a fascinating beginning to our session. For all those who are watching live on Facebook and YouTube, please send in your questions, and shortly at the end of the session, I'll be taking some of your questions. Sabrina, let me move to you again. Now, of course, we've seen a broad sort of endorsement and even welcoming the very idea of transnational judicial dialogue. And Michael seems to argue that it's even an understatement and there is so much happening. But at the same time, let me refer to you what Justice Anton Scalia, for a good part of his life, but also in his judgments, constantly referred to. Now, as we know, Justice Scalia devoted several portions of his judgment in Sosa v. Alvars McCain, in which he talked about, he decried the idea of judicial and scholarly trend towards using evidence of foreign practice. And he said, and I quote, "The notion that a law of nations redefined to mean the consensus of states on any subject can be used by a private citizen to control a sovereign's treatment of its own citizens within its own territory is a 20th century invention of internationalist law professors and human rights advocates." And he further said, and I quote, "The framers would, I am confident, be appalled by the proposition that, for example, the American people's democratic adoption of the death penalty could be judicially nullified because of the disapproving views of foreigners," unquote. He goes on to say many other things as well. So my question to you is that these are not, necessarily minority voices. For all you know, these are the dominant voices around the world. They may use different perspectives and reasons, but Anton Scalia's views are among the more stronger views representing a certain type of judicial trend which looks within the jurisdiction and expects to look at it only within the jurisdiction. After all, you are interpreting a constitution or a legislation of a particular country. So how do we respond to it as internationalists, as those who believe in the transnational judicial decision-making process? Somebody.
Thank you. Yes, and as the point has been made, unfortunately, I believe it is my country, the United States of America, and specifically the highest court in our land, the United States Supreme Court, that does have some justices that have expressed the point of view of Justice Scalia. However, that has not been consistent. Justice Kennedy is well known for having cited to international decisions, meeting with other international judges. Justice Ginsburg, same thing. So there are, there are many opinions of Justice Scalia that I respect some of his opinions I respect. This is one area in which I have to express strong disagreement with him. And I'm hopeful, I really do think that, as you know, in the United States, 40 years ago, when I became a lawyer, it was very, very difficult to research judgments, opinions from other countries or other jurisdictions, even other states. Now, with right on my computer, I can read opinions from around the world. And it's easy to find cases from other jurisdictions that talk about the same thing. And so I do think that there's more and more dialogue happening. For example, I happen to be on the board of directors for the George Mason University Antonin Scalia School of Law and Economic Center's Judicial Education Program. And for the first time in Hawaii, next month, we will be having a conference of United States State Supreme Court justices, where we will exchange ideas and of differing points of view. So this is a way in which we are starting to convene more. As Governor Beasley has said, I think I have learned the most by going to conferences with other judges and going to international conferences. I think some of the issues that we deal with nationally and internationally, let's talk about COVID pandemic. These issues require international solutions. We are learning in the United States that our focus on vaccinating Americans only and not getting vaccinations out to the rest of the world in this global world, we'll never get a control over COVID unless we act globally. And I'm hoping that that's the kind of awareness that is arising within the United States. I think with Zoom, before COVID, we didn't do this. We didn't do these Zoom conferences. We are now having international Zoom conferences regularly. We're exchanging ideas. We're learning from each other. Judges are, just as lawyers, everyone, business people. So I believe that we are now in the 21st century, and even if Justice Scalia didn't thought it was a 20th century idea, in the 21st century, we are a global economy, as Justice Seepery has said. We are a global world when it comes to health. We have global climate change issues. Just today I was reading the Navjot Singh Johar versus the Union of the Section 377 case of the India Supreme Court, and Chief Justice Mishra and Justice Chandrachud cited just so many foreign decisions, United States and other countries. And our Supreme Court has done it several times. I'm hoping that we will start looking more toward the international center. And if you don't mind, because process or due process for life, liberty, and property, it's not an American concept. Where did that come from in the Declaration? John Locke, but where did John Locke get it? This is an ancient concept that comes from Rome, from Greece, throughout the nations. These are universal concepts. So as you said, Professor Anne-Marie Slaughter is a leader on the transjudicialism movement, and she just wrote a book called Renewal. She talks about how important it is to look back and look forward. And that's what transjudicialism is. We are looking back and we are looking forward.
Thank you very much, Sabrina. That's a fascinating, not just a defense, but even a very, very optimistic and futuristic view about this. Let me shift gears and Margaret, now that we have, to a large extent, at least in this panel, established that we need to be a global judge, my question to you is, what are the essential qualities of a global judge? A global judge has the situational awareness about global society, that they respect the global values of pluralism, right to representation, rule of law, access to justice, faith in civil liberties, and treatment of everyone with dignity and respect. So, thus, value richness being one quality. What are the other qualities of a global judge which depart from, let's say, conventional understanding of judicial qualities? Or are there ways by which one can evolve and to become a global judge from the time one was a lawyer or even the time when one was a judge before, to be able to then evolve into being more sensitive about the transnational judicial conversations that is taking place? Margaret. Margaret, you need to unmute yourself.
Right now. One of my better tricks on one of these international conferences was for the battery to run out on my mouse, but not today. Look, you raise very, very interesting questions. Are we really talking about different qualities, or are we talking about a base assumption? You've mentioned a number of qualities of a judge, which are very much, I think, attached to, I suppose, the jurisprudential nature of the law. What is it that law is intended to serve, and who is the law intended to serve, and how should it serve the law? So you've mentioned rule of law, you've mentioned access to justice, for example. There's only two matters. In many ways, I think if we are really going to have a transnational judiciary, you are talking about a knowledge base. You see, the other, for us in any event here in the common law world, the other essential attribute of a judge is independence, judicial independence. Now, judicial independence is not only the right to be free to make decisions, or the right to make decisions free of any outside influence, and most particularly political influence, that must then become an essential attribute of transnational judging, as I believe it is in our common law system. But you also have to have an ability to know the law elsewhere. And I think this has been covered in various ways in the comments that have already been made. You have to be able to have the ability to research the law. You then have to have the ability to, and I guess in some ways this is the sensitivity to your own, not only your own legal system, but your own community, to know how those concepts which maybe be developing in other jurisdictions are best applicable in your own in your own jurisdiction. So that actually takes a fairly finely tuned judicial mind. Is that a challenge? In one way it is, but should not a judge continually, in the application of the law, in their learning of the law, in their appreciation of the law and its proper application, not be always finely tuning the analytical basis of it? And I guess that is where judicial education comes in. So I guess another feature of the transnational judge is a judge who openly embraces judicial education in the areas that we're talking about.
Thank you very much, Margaret, for that. Well, let me move to Justice Sikri. Now, Justice Sikri, the reorganization of judicial thought and practice in the global society has today become a new theme of and a new branch of knowledge known as judicial studies. In fact, judicial studies is far broader and bigger than having a historical record of the judicial reorganization itself. Today, judicial studies encompasses the role and functions of judiciary in newer social and political conditions, a training in judicial skills and qualities, including training of judges in, say, law and economics, a technological training for judges, which has become far more imperative now, and other matters of professional enabling and empowerment. My question to you is that what is the real scope and potential of judicial studies in making global judges? Can training, capacity building of judges help them become global judges?
Yeah, I think to some extent Margaret has already answered this question, and rightly so. When we talk of judicial studies, we have to, the previous questions which you have to put, which you have put to us, one was about the first question about the knowledge and the context and how, I mean, this, when we talk about transjudicialism, what kind of knowledge international judge or a global judge should have, and what kind of aptitude he or she should have, and coupled with the question of the skills, etc., which was raised thereafter, and the essential qualities of global judge, which you yourself mentioned, and Margaret highlighted upon that and dilated on that. Now, in order to acquire all this, judicial studies it becomes an important facet of, and for which we need to have some programs. One is, as we have been discussing and we have said about the Slaughter saying about transjudicial communication, where the judges are meeting at various levels and are even otherwise discussing. Now we have this today also we are discussing on this platform where everybody sitting in his or her place, and we are able to converge and able to have it together. So there should be a judicial dialogue on this, where we can, I tell you from my personal experience, from 1999 onward, when I became judge of the High Court in 1999, there's an organization called INSOL International on insolvency laws. It's a, I mean, very famous organization. We have likewise in the arbitration also ICA is there. But giving specific example of this INSOL International, there are judicial colloquia which are being held by INSOL International apart from other conferences. I have been attending since 1999. The law on insolvency in India was at an infancy stage at that time. It had not even taken the shape which it has taken now only in 2015 with the enactment of Insolvency and Bankruptcy Code, IBC, which we call. But the kind of the issues which are now there in our IBC, which we are dealing with and which were not there earlier, I was exposed to these issues and these discussions when I was having these dialogues with the counterparts from different jurisdictions on those judicial colloquia. So how much enriches this kind of discussion enriches is that example which I have personally learned. And apart from that, I think it justifies the training of judges by judicial academies or law schools, etc. That also becomes a very, very important aspect. And what we need to learn, as I said in the beginning, today, and we have known earlier also, but it has become more important today, that law is an interdisciplinary subject. When we talk of law, we are and which is not a total, I mean, a statutory interpretation of a particular act which we are dealing with in a particular case. In the process, there are many issues which may relate to the case which has come up, technology, issues of economics, etc., as you rightly mentioned about law and economics. So therefore, the connect of law with other disciplines and that kind of judicial study also becomes very, very important. So all these are the aspects which have to be taken into consideration. What I feel is that, today judges must address not only legal but social issues, including economics, medical, philosophical, sociological concerns, etc. And therefore, in order to address, and we are called upon to do that. So in order to address these issues, appropriate decision-making skills and competently manage caseloads and personnel, these are the issues which come. and which become a part of judicial studies. So as you rightly said, it becomes a very, very important facet. That's
Thank you very much, Justice Sikri, for those very valuable comments and perspectives. Let me move to Michael. So, in some ways, we recognize that such training and capacity building is important. Now, we spoke about the need for judges to understand the socio-political global conditions. Now, while this knowledge can be self-acquired, things cannot be led to be a matter of personal pursuits of judges alone. There is a need for larger institutionalization. Indeed, some judicial academies can play a role in creating such global imaginations. But don't you think that universities and higher education institutions and law schools could be the right place to impart this knowledge, thanks to the value based and pedagogical approach to legal education? If so, what are the ways to impart judicial education in a global way to the judges through law schools and higher education institutions? In fact, what I'm keen to hear from you is what are your views on universities becoming sites of judicial education? Michael.
Thank you, Raj. Well, I've had the introduction to judicial education through higher education in India with the institution that you developed and that has become so prominent in India. So it's been very fascinating to see the interaction between Jindal Global University and Jindal Global Law School and the judiciary. So I'd cite that as sort of an example of what can happen, but it's a complicated formula. It's not easy. In Hawaii, we have an interaction with our law school that doesn't include judicial education to any great extent. And the development of judicial education through institutions of higher learning, I think, is something that is appropriate, and to some extent it might be inevitable when it comes to some issues in an individual community that are of great consequence. Now in Hawaii, because of many reasons that I think this audience understands, Hawaii has some very pressing environmental problems, and as a result, our community required that we have an environmental court. And because we have some great leaders at the law school on that issue, it evolved into a training curriculum that was designed in large part by one of our great professors at the University of Hawaii Law School, who's a very close colleague of Sabrina and myself. Well, that's a good example, a very direct example of an institute of higher learning helping judges. But it also makes the point how difficult it potentially can be, because judges are very sensitive to the idea that they need to learn something oftentimes. The idea that somebody's going to teach them, or they're supposed to go into training. I mean, it's just a reality. Sort of personalities that judges are sort of confident in themselves. So an opportunity to learn is much more accessible and I think agreeable to judges if there are other judges around. You don't want to be taught by, for example, a team of professors of the law if you're a judge about what you should do necessarily. Now, there are exceptions to that, but it gets me, I guess, to the end of my point, which is that the relationship between the academic community and the courts make a big difference to overcome this natural hesitation of judges to be taught by those outside of the judiciary. And the Supreme Court of India has been an example of an institution that has great, I guess you could say, intellectual sense of humility and confidence, so that there is this great interaction. And it certainly happens with the Global Judicial, with Jindal Law School. I mean, I personally, much of the work that I'm able to do with an international perspective is a result of Justice Sikri, of Justice Swatantra Kumar, of Justice Chandrachud. I mean, but it's a result of your relationship and respect with the court. So unfortunately, I think This is a difficult task, and it depends a lot on the leadership of the academic community and the credibility that the academic community has with the judiciary.
May I add something here?
Yes, please. Thank you, Michael, and over to Justice
minutes,
please.
But it's a very important and I would say very interesting question as well at the same time. And I'm telling you the Indian experience, where I think what some of the apprehensions which Michael has expressed, we can think of a hybrid system here, where we take the help of universities, and particularly in when you talk of judicial studies, we have just not talked about it. And we have done so. We have in India, we have National Judicial Academy at national level, and we have state judicial academies. Interestingly, till recently, National Judicial Academy was headed by a director who was from academia. Initially, Professor Menon, then Professor Mohan Gopal, then Professor Balram Gupta also thereafter. And in between that, Professor who was again from Delhi University, who was taken, I've forgotten his name. Anyway, so initially for many, many years, of course, at present, the director is a retired High Court judge, but these have been, number one. This is the experience of our Delhi Judicial Academy as well. Number two, I have seen in National Judicial Academy, when they have recruited other persons that who prepare the synopsis or the material, etc. Most of them are professors. Either they are taken, they are recruited as such from the teaching community, or they are on deputation there at the National Judicial Academy. So what I'm trying to say is the role of universities cannot be undermined when it comes to, because they are the source of knowledge. And as Michael has rightly mentioned about O.P. Jindal University, in fact, when we are talking of global judging, you're the example, your university is the, a perfect example of global education, where you're having teaching community from all over the world. You're having the syllabi from all over the world, which whatever is good in other countries and why it should not be here. So therefore, when we talk of judicial studies, particularly in the context of global judging, and we want to train the judges who can have a global perception while deciding the cases, and from that angle, I think universities can play an important role. At the same time, there are some of the misgivings about it. So there was a hybrid system where we take the help, like the Judicial Academy, which is set up by the courts, where the judges also go, where the advocates who are experts in the field, because they have the practical experience, and which is very much required. But at the same time, we have the experience of academia by associating the universities. In many programs, universities can suppose a particular, we are talking about it, how they suppose judges are to be trained in this field. Why not NJA, National Judicial Academy, or Delhi Judicial Academy hold a program in association with O.P. Jindal University? And that serves the purpose. This is what, at least start can be made like this.
Absolutely. And I thought it's a fantastic set of suggestions, sir. And I think in a way, the relative, at times, lack of intellectual capacities that end up being unavailable in the judicial academies can be usefully created by these type of collaborations. All right, we have around 6 minutes to wind up the program. I have several questions, so I'm going to quickly shoot those questions in the order we started. So, Sabrina, short responses. This question is, what are the factors which are to be kept in mind while one transplants judicial decisions from other jurisdictions into one's own, keeping in mind the diversity of the society that we are talking about?
I think some of my colleagues here have already discussed some of these issues. Obviously, you have to look. You think globally, you have to act locally, which means you also have to look at, is the statutory law the same if we're construing a statute? Is the constitutional provision the same? And of course, you have to apply it to your own circumstances. But I just want to jump in on the last one. I do think that there's a place for higher education. You probably know, Vice Chancellor, about the Duke program, the Bulge Judicial Institute. They started about 9 years ago. They have an LLM in judicial studies. It's a mix of academics and judges teaching. And the National Judicial College in Reno, which is associated with the University of, it's on the campus of the University of Nevada in Reno, also offers an LLM. So these are programs offering LLMs in judicial studies to judges. I believe that Jindal should do an LLM in global judicial studies. Thank you.
Thank you very much, Sabrina. It's music to my ears. In fact, it's kind of public knowledge. I had, soon after the new Chief Justice took office, I did meet with him and actually ended up giving a proposal exactly on these lines when he had positively taken it up, and he had assured me that he will also engage with the Judicial Academy. But in some ways, one of the today's context has given that opportunity, and that's what another question is asking. Maybe Margaret should answer. To what extent judiciary and judicial institutions can take some of the experiences that they had during the pandemic and take it forward even into a post-pandemic world? The Indian context is phenomenally instructive because before the idea of judges adjudicating, sitting in their homes and hearing people through video conferences is simply unthinkable. But today it has happened. So the question that's being asked is, are there learnings that can go beyond the pandemic? Margaret. You can unmute yourself, Margaret.
Look, the experience here in Australia has been interesting. Just about every court kept itself going at different levels. Jury trials were a challenge and, in fact, really couldn't proceed. But most other types of matters could proceed from the highest court at the appellate level down to what we call the local court level. I exclude the jury trials. And that, of course, then created problems in terms of delays and ongoing delays. So technology was the answer during the pandemic. It was embraced by the Chief Justices of the various jurisdictions because of the importance of keeping the legal system going, and most particularly, not only keeping the judges engaged and the lawyers engaged, but most particularly to ensure that the litigants were being given. It's a real question of access to justice, actually. If you simply shut down a court for a period of 6 months or 12 months, that's actually an access to justice question of a different nature to what we normally talk about. So, huge experiences, good technology, absolutely essential. Increasingly, I hear from the judges and from the barristers who were very happy to embrace it that they are happy to be back in the courtroom. You hear many say, I couldn't read the judge. And so therefore I wasn't sure where I should be pitching my argument and or how strongly I should be pitching my argument. Witnesses were being taken, obviously, by video. That happens anyway in international cases or with witnesses overseas. But again, a resistance, particularly in sensitive matters where one is not only looking for example, the exposition of an expert opinion or the production of a document, but where there are real issues that need to be worked through and which are contentious. So I think the real experience is the more contentious the particular case was, the less satisfactory the technological use, the use of the technological courtroom was, but generally a sense of we are better in the same room, because in the same room whether it be in the courtroom, where there can be the interaction between the judge and the counsel in a way which is not nearly as easy, because it has to be much more constructed in a technological court, but also the discussions as between the judges outside the courtroom. So yes, there are lessons. The technological court will never go away. My sense, at least in the immediate aftermath of this pandemic, is that it will be siloed into probably smaller matters, administrative matters, directions hearings and the like, which will make life extraordinarily efficient and convenient and ought to be maintained, but other areas where perhaps it should not.
Thank you very much, Margaret. Justice Sikri, over to you now. This is my own question. Just before the pandemic, as you know, there were approximately 30 million cases that were pending in Indian courts. The Chief Justice of India just announced a few weeks ago that post-pandemic, it's now nearly 50 million cases are pending in Indian courts. My question to you is that, what are the possible learnings that we can gather from even other jurisdictions, but also our own experiences to respond to probably the biggest crisis of access to justice that we are facing today?
You see, what I feel is here ADR, alternate dispute resolution mechanism, would play a very, very significant role. It has to play. And of course, when you talk of ADR, it's all forms of ADR. We have in Indian context, Lok Adalats also, which have been playing a significant role, which should be now encouraged much more and should be held on a very regular basis. We have arbitration. We have mediation. I think mediation should be, again, a very important tool in this process, which has to be utilized. We have not exploited its full potentials. And more than that, I would only say that this ODR and technology has taught us online dispute resolution. When we talk of online dispute resolution, we are not only talking of holding the courts online or doing arbitration mediation online. There are some platforms, and it is the experience now, which is experimented, private platforms, which I'm going to, and it started with the eBay, where consumer disputes of eBay, they started doing in-house mechanism and started resolving those disputes. And then, but it percolated their platform, their startups in India also, which are ready to take. And I tell you, only 3 days ago, it was a committee set up by Niti Aayog on ODR, which I chaired that committee, and a report was prepared. I'll share that report with you. It's a fantastic report where the landscape is given as to how we should, now have more and more ODR, where consumer dispute, MSMEs dispute, and many disputes which would arise from COVID now, when the COVID goes, and it has already started doing. It's like tenant landlord dispute where rents are not paid because the premises, if I had taken on business, the premises lying long for 5 months, 6 months, I couldn't do the business. All these kinds of disputes are bound to arise. From 30 million in 1.5 years, we have gone to 50 million. Reason is simple, that we have almost 10 million cases filed in Indian courts every year. And we have been up to now 30 million. It was, the pendency was at that because the Indian courts were deciding also 10 million cases, which we were not able to decide. So in 2 years, how the pendency has gone up. And there have to be surgical strikes and surgical methods adopted. ODR is going to play a very, very important role in this behalf. And here again, you're talking of judicial studies. I'm saying the universities can play an important role as far as ODR is concerned. And I share this. So this is what I like to say in nutshell as about Indian position. Yeah.
Thank you very much, Justice Tikri, for that. Michael, you have the last word. Michael, if there is one big thing that we have learned from the pandemic is the huge global vulnerabilities under which all of us are living. As you rightly said, and I can only remember what Martin Luther King said, a threat to justice anywhere is a threat to justice everywhere. So in a way, the whole unfolding of the climate crisis should only end up galvanizing greater degree of social, political, economic, intellectual, and of course, judicial consciousness. What do you think the law schools and law students and law professors can do to join hands with judiciaries to advance the cause of justice in a world that is going to become far more uncertain in the future? Unmute yourself, Michael.
Yes, I did. I just returned from the COP in Glasgow, and the former president of the United States gave a message much like the one that you've been alluding to. So he was talking about how the future essentially is one of great instability and certainly great threat to those that are the younger generation. And he said, the way forward for the transformational change that's necessary, the way forward, the number one way forward is for young people to get involved and vote like their life depends upon it, because their life does. So we have a life-threatening situation that's going to be front and center even more for judges than it ever has been before, that involves young people. Now, you are at the top of a kind of communication process that might be able to help the judiciary and its relationship with future generations. I mean, you raised the possibility that young law professors and the students that they teach are going to be able to organize in a way that penetrates the decision-making of us. You know, we're talking about middle-aged, older people, many of them disconnected from the reality that young people are facing throughout the world, that poor people are facing throughout the world, and the hundreds of millions of refugees are going to be facing as they move. So the idea that the academic community and the young people that are part of its team, part of its responsibility, could ignite the awareness that social justice is an issue as it has never been before, will empower and encourage judges who generally are very conservative, who generally are not innovative, who generally are not on the forefront of social change. And you'll encourage those judges that have courage, like the Supreme Court of India has demonstrated so often. And that is so essential, that somehow the men and women that are judges now of this culture that was not really a culture in sync with or familiar with what's happening with the planet and young people, that culture will respond. So I agree. It's possible that the academic community, combined with the extraordinarily talented young people it has, will be able to move forward social justice by bringing cases and by meeting with and by social activism that alerts the judiciary of the world that, you know, it's not just transnational commercialism. It's not just transnational decisions about how we're going to deal with profit making, not just transnational issues that have to deal with insolvency. While these are very important to the leadership community of the world, there's another community that's getting less and less access to justice and is more and more in danger because of the practices that are taking place globally that are affecting those that are young people. So thank you for the opportunity to make that point.
Thank you very much, Justice Michael Wilson, Justice Sabrina McKenna, Justice Arjun Sikri, and Honorable Margaret Beasley. Thank you very much for being here. It's such a pleasure to have this conversation with you. I'm grateful to each one of you for taking time out of your busy schedule from different time zones in the world. All of us enjoyed the conversation. I'm sure those who watched this enjoyed it even more. Thank you very much. We will be going into the next session in 5 minutes. This will be a fascinating lecture and dialogue with Mr. Cyril Shroff, who is the founder and managing partner of a major Indian law firm called Cyril Amarchand Mangaldas. He's already here, and we should be having him soon for this. Thank you very much to each one of you.
Thank you.
Aloha.
Good morning to everyone in India. Good afternoon to our friends in the Southeast Asia. Good evening to our friends in Australia and some other parts of the world. It's indeed my proud privilege to welcome all of you to the second day of the Global Law Schools Summit. We have with us a very special guest who is delivering the second keynote address of the summit. We have with us Mr. Cyril Shroff, who is the founder and managing partner of Cyril Amarchand Mangaldas. I have great pleasure in introducing Mr. Shroff. Mr. Shroff has nearly 4 decades of experience in a wide range of practice areas, including corporate and securities law, disputes, banking, bankruptcy, and infrastructure. Over the years, Mr. Shroff's passion for a just world, blended with a keen sense of fairness and empathy, has helped the Cyril Amarchand Mangaldas firm firmly establish itself as a trusted advisor to its clients. Mr. Shroff has consistently been ranked as star practitioner in India by Chambers Global and is often regarded as the M&A king of India. A thought leader and a visionary, Mr. Shroff is known for advising on many first-of-its-kind transactions in India. He regularly gets recognized as an award-winning professional across multiple areas of practices. He's also held distinguished positions of responsibility, including spearheading many public policy initiatives in India. He serves as chairman of FICCI's Corporate Laws Committee, member of CII National Council and Financial Markets Committee, chairman of the SCS ESG Advisory Board. He also served as member of the SEBI-constituted Uday Kota Committee on Corporate Governance and SEBI Committee on Insider Trading. He was also a member of the first Apex Advisory Committee of the IMC International ADR Center. For his distinguished contributions as a legal professional, he has been given a number of awards, including the Deal Maker of the Year, ALB India Law Awards 2020, named as A-List Icon in IBLJ A-List Lawyers 2020, included in Legal 500's Hall of Fame 2020, recognized as IFLR Asia Best Lawyers 2020, Band 1 Private Wealth Law, Chambers and Partners, H&W Guide since it's published. Has been consistently recognized as an eminent practitioner for private equity, banking and finance, and restructuring, insolvency in India, and star individuals for corporate M&A in India. There are many more accomplishments to his credit. But something that I deeply have been inspired by his work is his strong support and contribution towards the advancement of institution building and nation building. I had the privilege to meet him even before the founding of OP Jindal Global University and Jindal Global Law School. And Mr. Shroff was one of those few individuals who believed in the vision and the imagination and the idea of OP Jindal Global University, Jindal Global Law School, long before its creation. He not only supported the idea and walked with us all through this journey, and since the establishment of the school, he has been one of our strongest supporters and an institution mentors for our institution. I am deeply grateful to him for his leadership and his encouragement and his support all these years. With those words, I have great pleasure in presenting Mr. Cyril Shroff to deliver the keynote address. Over to you, Mr. Shroff.
Thank you, Raj, for that most generous introduction. I was, as you might have noticed, I was blushing on the way through it. But I think for me, the most valuable thing has been our friendship and the association with the Jindal University. So it's been a real pleasure. I delivered the keynote address last year as well. So I must have done something good. That's why you called me again. The last time, if you recollect, I had spoken about the Delta lawyer. And that I think is still a concept that holds good. And we are seeing that some of that play out in the real world as well. But as I look back in the last 18 months, and I mean, I'm just using again the keynote address that I delivered, I think it was around the same time last December, as a reference point, and ask ourselves, okay, what have we learned since then? What have we learned from December 2020 to December 2021? And there are a couple of thoughts that come to mind. I think the first and the most obvious one is that we are truly living in a VUCA world. Volatile, uncertain, complex, ambiguous. Who would have thought on, say, 1st January 2020, that within a few weeks from then, the world will go into massive lockdown. So I think the first point is that the future will almost always catch you unawares, no matter how much you plan. The second learning, I think, is that the future of work has almost permanently changed. I think it's still work in progress, but my instinct tells me that we are not going to go back to the old model of work. There is something that has very fundamentally changed. It required a pandemic and a lockdown to make us kind of realize the new working model. So I think that is going to have profound implications on a number of things, on culture, on the nature of work, on employment, and you name it. The third comment I would make is that with every challenge comes great opportunity. If the greater the challenge, the greater the opportunity. And what we have seen in the last 18 months is that these challenges have been met by two different kinds of people. Those who saw it as an opportunity and thrived from it, and those who actually saw it only as a challenge and paid the consequences. Some of them have been wiped out. So as we look at the VUCA world, I think we need to be clear about the fact that that we are at the batting end, and from the bowler's end you can get any kind of ball, and you can either get out or you can hit it for a six. The other comment I would have is that unlike in the case of the global financial crisis, which at that time looked very profound and it was going to change many things, including the world of law. But as we look back now, not that much changed. After a brief kind of hiatus, things kind of came back to a normal and maybe even more enhanced. But I feel that this crisis is a little different. I think at least some of the changes, including, say, for example, the ways of working, these are permanent changes. And I think these are going to be changes in the law firm world as well. How the law firm world reacts to this is still work in progress, but certainly a lot has changed. As part of the opportunity sort of paradigm, a lot of new areas of practice have emerged. One of which I think is the entire sphere of ESG. And both the E and the S and the G have each thrown up massive opportunities. It is going to be one of the biggest practice areas of the next decade, because every part of society, whether it be the public sector or the private sector, is going to have to be fluent in ESG, and there is very inadequate knowledge about these subjects at this point of time. So educational institutions such as yours, and I know, Raj, that you're already very much on this, but I think more broadly, the education world will have to put the accelerator on the ESG topic, and so will service providers like us have to embrace ESG, not just as a sort of a sideshow, but as a mainstream in our practice. I think, as you also know, the corporate landscape is changing at warp speed. Every month, I'm talking only of India just now, but I think it's true across the world. We are producing at least 2 or 3 unicorns, and these are finding their way into the capital markets, as well as they're affecting our lives in a very profound way. I mean, eating has not been the same after Zomato and Swiggy and whatever else are the equivalents across the world. Travel has not been the same, or at least boarding has not been the same after Airbnb. Local travel has not been the same after Ola, Uber, and all of that. So these changes are profound, and I think in this process we are creating the industrial titans of tomorrow. I think some of the old industrial titans and conglomerates will remain, but that list is going to be churned immensely, almost like a samudra manthan of the corporate sector, as we see the kind of new barons of tomorrow emerge, and they come with a very different paradigm. Their ownership structures are different, their mindsets are different, their worldview is different, their their sensibilities are very different from the past, and I think that is going to have massive implications on how legal services and professional services are delivered. And I think another change that we have learned is that the expectations of talent have changed. Expectations from life and expectations from work. I think there's a new social contract between the millennials and Gen Z with the nature of work itself and with their employer, and it is something which we are still grappling with. And I think the future really belongs to them. I can imagine we are already seeing that in that the millennials and Gen Z are coming into the policy and the governance space as well. 10, 15 years from now, all the global leaders will either be millennials or Gen Z. You can imagine at the moment, of course, the US has a fairly old president, but a few terms from now, you will have a millennial in that office. The expectations from clients are changing, and the expectations from employers are changing from talent as well. So I think we are in a perfect storm and a fertile ground for innovation. It is also the greatest opportunity. I think as far as legal services are concerned, we are on the threshold of a golden era, if not already in it. And there is, depending on your own view of it, I think we are on a burning platform. Some firms, I think the traditional view of law firm would believe there is no burning platform. I mean, this too shall pass. And at some point of time, we'll just come back to the same workplace and just charge a little more, and life will go on. But I don't think that is true. I think that there is a burning platform, not just because law firms and service providers think so or don't think so. There is a burning platform at the client's end. There is a burning platform in the in-house legal community and in their own principles in terms of business, and they are going to force that change. So the law firm model, I think, is begging for reinvention. It is essentially a very short-term model. Most of them are general partnerships where the entire profits are distributed every year, maybe sometimes sort of keep back a little, but essentially it's a cash pass-through model. So nobody is investing for the long term. So except for a few, I think some firms across the world have started taking the long view and are investing for the future as well, especially because they recognize that the future is different. Whether it is different types of technologies or how they're going to re-engineer their process. Building on the Delta concept that I mentioned last year, I think there is even more a need for what's called a T-shaped lawyer. What's a T-shaped lawyer? T-shaped lawyer is essentially deep, at least on one thing, which is quite often just deep technical legal knowledge, but has also got some solid horizontals, which could be different skills, whether they are of sort of collaboration, technology, politics, social science, or whatever it is, because the clients are and their constituencies are asking for this. The day of just an I-shaped lawyer is over, completely over. I think they will stagnate, and I think they will probably just become cogs in the wheel. But for the leaders and for the best professionals, the model is clearly the T-shaped lawyer. So Raj, I think this begs the question which should be posed by legal education to itself, is what changes should we be making to legal education to produce tomorrow's lawyers, to borrow Richard Susskind's phrase of, how are we going to produce lawyers who are fit for purpose? Because as they say, you have to design not for where the puck is today, but where the puck is going to be tomorrow. And these are issues both of syllabi as also of teaching methods. Again, as they say, astronauts cannot be trained in a classroom. You have to, before you send them out to space, you have to create kind of a virtual environment in which they know what outer space really looks like. So all sorts of techniques, I think, are on the threshold of entering legal education, whether it is tech awareness, a different mindset of more outcome-focused sort of training and delivery, rather than merely input-focused. So as they say, to use a medical example, it's not about the medicines that you prescribe, but what are patients concerned? Patients are concerned about health and not about the medicine that you gave them or what surgery you prescribed. Now, having said this, I would like to comment on a few specific topics which directly or indirectly impact the future of law and hence the future of lawyers. First, let me talk about geopolitics, because all of this is happening sort of on the base of tremendous movement and changes in the world of geopolitics. If there's one lesson that we have learned from Afghanistan, is that the US is no longer desirous of continuing its role as global power. It will play its role as superpower selectively where it serves its own interest, and we can no longer rely upon the United States as kind of the guarantor of democracy or the rule of law across the world. To an extent, I think each nation will have to look after itself. What is also what we are seeing is that there is clearly a bipolar order that's emerging with the US and the China, and they're two completely different systems. One is clearly sort of believing in free values, and the other is autocratic. And I think they're going to produce two very different types of clusters of nations and ways of thinking. The nature of war will change. I think whilst nations will need to keep their tanks and missiles, I don't expect future wars to be fought with guns and missiles. And the future wars are going to be bio wars, technology wars, and things of that nature, which is going to require a very different level of preparedness and also advancements of science and policy rules in terms of how these new tools are going to be tackled. The importance of borders, I think, is going to become very important, whether they're maritime borders or they are political borders. I think these are extremely vital, and we're seeing that because as the world is shrinking conceptually from a globalized world to a more nationalistic world, borders are going to become more important. We are seeing this just now in COVID. Within literally a week of Omicron, the emergence of Omicron, and many countries don't even have a single case. We are seeing how fast borders are shutting down, or so many hurdles are being created in terms of entry, quarantine, and RT-PCRs and whatnot. And they are not uniform standard. There's so many different nations who have adopted different techniques for dealing with this. We are also going to see different standards. So as technology develops very fast, I think standards are going to be important. And I think we're going to live in a world, thanks to the bipolar construct of essentially two world standards. One, a more Western, freewheeling, open architecture type of standard led by at the peak by the US, and another kind of more closed system with China in the lead. So, and these are going to have profound implications for countries such as India. What we are also going to see by whether it's 2030 or more likely 2050, that the E7 are going to be more prosperous than the G7. And that's both an opportunity for us as well as a challenge. So that's the world of geopolitics, and I think a lot of this is going to have a direct implication on policy making as well as legal education. Second point on ESG. Building on what I just said, I think it's clear that we are at, the world is facing an existential threat. Mumbai, where I live, has been predicted by 2050, or at least parts of Mumbai are predicted to be going underwater. And there are at least 13 globally important cities like Mumbai, which are going to face this threat. And these will have profound implications. So this challenge, firstly of climate change, will have to be fought at every level. It has to be fought it has not merely to be handled by the state, but I think the private corporation, the public company will have to play its role. Within that, individuals will have to play their role. And in the professions, I think the lawyers, more than anyone else, will have to play a significant role. The good thing about being a lawyer is that you have boardroom access. I think that the boards listen to you. We have a role to play in terms of following of standards. We have a role to play in terms of influencing how good decision making is done. So I don't see the E, S, or the G being merely statistics. I think they're going to be very significant real issues which are going to impact the practice of law itself. We have, from a corporate governance and hence corporate law practice itself, already in India embraced the stakeholder model. Newer and newer regulations have come up. SEBI has come up with what's called the BRSR and sustainability reporting, which is going to be a pretty big deal from next year onwards for the first 1,000 companies. So what law firms and lawyers and hence law schools will have to produce are what I call the ESG aware lawyer, who are very fluent in ESG concepts. We, from our law firm point of view, we have founded a separate ESG practice, which is and is kind of growing from strength to strength. We see in future not merely pure lawyers within it, but it will probably have a multidisciplinary content. The third point I'd like to make is on future technology, data, and automation. So as they say, there's a study which has been done that 85% of the 2030 jobs, that's not too far, it's 8 years, do not even exist today. So with the recognition that kind of data is the new oil, to use a cliche, and the vast volumes of data that are being produced with essentially an internet-based world, the entire framework in relation to how a data will be managed and how technologies will be kept ethically aligned, I think is a whole new sort of area of law and policy that is yet to emerge. And this is tremendous opportunity for young lawyers. As far as training is concerned, augmented reality, virtual reality, and AI are going to be very important. Our friend Mark Zuckerberg has already talked about the metaverse, and I can't even start imagining what kind of challenges that will create. You could land up committing a crime in the metaverse, and you don't know how the criminal law system will deal with it. Legal tech will not be just tech. I think it will be it will move forward and actually become part of solutions. Training will be simulated. I can imagine, just like the astronaut example, that legal training or legal teaching as well will be simulated. Fourth point on importance of design. So generally, I think the traditional one-dimensional or two-dimensional training that is given in many professions, including the law, has not adequately factored in the element of design. Design thinking will have to enter legal services and delivery. So I don't know whether General University offers design courses or not, but if not, I think this is certainly a big item to be introduced to curriculum, because what design thinking does, is that it helps you focus on the solution, put the customer at the center, rather than to put yourself at the center. Most of the kind of law firm and legal services models are designed with putting themselves at the center and not the client. What is the hourly rate model? The hourly rate model has put the law firms at the center of the model. The more hours you produce, the more profitable you are. Have we thought about how design thinking and how outcome-based solutions will work? So the future will belong to those firms and those organizations or service providers, and which need not be law firms, would have incorporated design thinking and found out new ways of collaboration. Last point is on what I call the verticalization of legal services delivery. So the horizontal view, which is kind of currently holding the field, is that legal services are horizontally divided. On the one end of the spectrum are the likes of the law firms and experts who handle the complex and more difficult problems. And on the other side of it are more process-oriented service providers who can do the simple things. You're either this or that. The outsourcing world, for example, belongs to that side. But what the future is more likely to show is that we will need to move to a more vertical model, where on either side of the current horizontal, say the law firms will have to have process and technology in the pyramid, and conversely also what are currently seen as the more processized, commoditized service providers will need more expertise. They will need more judgment. They will need more human intelligence in order to assess and fill in the gaps. So the future, I think, and nobody has yet properly done it. This is a problem that remains to be solved because it fundamentally changes the economic model and it has to happen because finally it's the clients who are asking for this. So the future lies in the vertical model, and the moot question is who will do it. The short-term implication for law firms is that they will really have to start focusing on knowledge management as a key function. Knowledge management has traditionally not been very, except barring a few firms, has not been one of the most important functions of the firm. But as you take this more vertical view of the future, there will be a huge focus on knowledge management and technology. So in conclusion, I'd like to add that the 2020s and the 2030s are going to be vastly different from the past. And they're not just another more efficient version of the past. I think they're going to be qualitatively different. More so in the 2030s. I think what's left of the 2020s is about 8 years. But within that, I think you will see the direction of change. And hence, I think the question for all of us to ponder, for law firms like me and universities like you, is how are we going to embrace this change and how are we going to get ready for this? So I'd like to sort of end my talk with leaving this question for us, all of us. I don't think there are any current answers, but at least, we're getting closer to know what the question is.
Well, thank you very much, Cyril, for a fascinating and comprehensive, set of ideas, reflections about what the situation and changing dimensions of law firm practices and how the future is going to be impacted. There are a number of questions that have already come in from our audience, but before I do that, I want to begin this conversation by some of my own questions as well. Cyril, in late April, Thomson Reuters published a piece and talked about the fact that about 1/4 of European investment funds classified themselves as quote unquote sustainable as investors' demand for adherence to environmental, social, and corporate governance, those concerns increased. Now, although demand for ESG compliant investment products is indeed increasing, there's a lot of confusion even in the European policymakers' context as to what are these standards. Now, interestingly, Thomson Reuters has observed that there is spillover effect on this demand, which is also impacting law firms. And they have said, and I quote, according to Thomson Reuters data, 42% of its large law clients have ESG practices, including Freshfields and Herbert Smith. Yes. So my question to you is that while you have already begun to take a leadership role in your own law firm in developing this practice, what are the fundamental changes that need to go through in the mindset of your clients to recognize the importance of it? Because of course, law firms as thought leaders can create areas of practice, but to what extent the typical Indian corporation, company, business enterprise is ready to reimagine its functioning and recognizing that ESG matters today?
So that's a great question. I think there are a number of dimensions to it. First, I think the market, is driving a lot of this change. The market and regulation. So in the market, there are the index funds like BlackRock and State Street and Vanguard and others, all of whom are driving the ESG agenda. Then there are other investors, including, for example, private equity or strategic investors, who now almost always insist on an ESG diligence or an ESG assessment before they put money to work. as far as the debt finance markets are concerned, we've already seen the rise of green finance. There are several green. So the financial consequences of embracing ESG has created both the right penalties and the right incentives. If you embrace ESG, your cost of finance is late and the market rewards you, it actually gets you better profits. And by not doing so, you're kind of endangering your own future. So that's an incentive-based model that we are seeing that is already at play. Second, I think there is thanks to the pandemic and all the daily conversations about climate change and things like that, I think there is a great awareness of the need to embrace ESG. A more nuanced answer would be that there has been a greater emphasis in the past on the G part of ESG. I think E is rapidly catching up, but as far as S and the social is concerned, it's lagging behind a bit. So there is very little attention that is currently being paid in the relative context to. So currently there were three horses. G is leading, E is not too far behind, and S is very far behind. And therefore, I think boards will have to think about these issues very carefully. And third point, I think, is regulation. So regulators and policymakers, like very specifically SEBI, has now introduced a new framework, which is going to kick in mandatorily from 1st of April in this now literally 4 months from now, which is going to require sustainability disclosures by the top 1,000 companies. So there is no option anymore. And every company will have to take a stand. So, and I think all of that on the back end drives creation of service capacity, whether it's the big four or the consultancies or law firms like us. So ESG is here.
Thank you very much, Cyril, for that. Let me move on to another important aspect which you briefly touched upon, which is the fact that what kind of legal education need to be in place for those future lawyers. But before I take it up, I want to ask you, as a leader of a major Indian law firm, which is in many ways a global law firm, what are the, let's say, training and capacity building programs that your law firm has put in place when it comes to nurturing new knowledge, new perspectives, new skills above and beyond the opportunities for lawyers to learn through working? Because the reason I'm asking this question is that when I look at global law firms in other parts of the world, increasingly there is a very strong sense of professionalization. There are a lot of external interventions happening. In fact, Wall Street's M&A powerhouse, Walker Lipton, Rosen and Carnes, which is not known for making senior lateral hires. Last year, it made an important exception, bringing on board a consultant, Leo Strine, the former Delaware Chief Justice and a leading proponent of governance reform. Now, these are the type of radical changes that are happening around the world to internally examine, training, capacity building programs that big law firms have. My question to you is, how do you see reimagining this space?
So we're already doing a lot on this, and the entire learning and upskilling process has been a personal passion for me for long. So I think firstly a lot depends on leadership, and particularly how the senior leadership of the firm sort of focuses on this and what are its core values. So if you're a firm that is only about, let's squeeze out every, hour of billable time from your lawyers and convert it to money, then I don't think you're going to invest in this. But if you're the kind of firm that kind of does a good balance between the short-term needs of profitability and the long-term needs of investing in the human capital of the firm, then you're at the right place. So what have we done? We have established an internal learning university, we actually call it that, which has two broad departments to it. One department is called the Leadership Academy, and what the Leadership Academy does is that it deals with all non-legal skills, whether it is how do you manage self, how do you manage team, how do you manage the business, how do you negotiate, how do you imagine the future, all of the stuff that is other than legal delivery. And on the other department is an actual technical legal university. I don't mean it in a general university sense, but it teaches you about law, lots of L&D, and cutting edge research as well. So as you know, we produce a lot of thought leadership as well. So these are the two engines, and they are manned by very senior people. On the Leadership Academy side, we recruited somebody from industry who had actually set up a global leadership academy for a multinational, and ran it that way. I should introduce her to you at some stage. And on the legal technical skill side, we have two of our former partners who wanted to get off the rat race, so to speak, and actually had an academic bent of mind. So they are leading that. So, but you know, these are we are still at the early stages. The most important thing is that learning and development more broadly and professional development is at the top of our agenda. Because we are designing for the future.
Thank you very much, Cyril, for that. Cyril, let me slightly shift gears here. One of the things that has been a matter of major concern is that the relative unpredictability of regulation and also possibly even the role of courts when it comes to corporate commercial tax and other type of disputes. Now, as a law firm which works with companies and corporations both in India and abroad, how do you help international investors, let's kind of instill a certain degree of faith in them to believe in the stability of Indian regulatory landscape, and yet ensure that the role of Indian regulators can be more positively impacting the business and the investor climate in India?
So, regulatory stability, as the way you just described it, is a mirage. It never happens. But I have great faith in the rule of law. I think India is one of those societies and nations which has a real rule of law. Yes, sometimes we can have our delays and all of that. There could be sort of cholesterol in the system. But if you look at it at its core, it's one of the finest rule of law regimes in the world. So the only answer I give when a client asks the same question is, don't ask me about giving you any kind of opinions or assurances about the fact that this regulation will change or not change the stability of the system. But I can definitely tell you that India's rule of law is right up there. And I think that should be enough for people. Because when you look at the investment destinations options across the world, you could have many places which have a stable regulatory regime but no real rule of law. I would rather, if I were to trade off one, I would take rule of law.
Thank you very much, Cyril, for that. There are more questions coming in, but let me ask one more question, then take up questions from audience. Just before the pandemic, Cyril, India had approximately 30 million cases pending in Indian courts. Just now, a few weeks ago, the Honorable Chief Justice of India announced that there are nearly 50 million cases now pending in Indian courts, which is approximately 5 crores, as we call it in India. So my question to you is that despite efforts to build a serious alternative dispute resolution practice in India, there have been numerous challenges for it to evolve and become a part of an Indian narrative. How do we address this issue? Because this ties in quite nicely with what you mentioned, which all of us share, which is that we are a rule of law society in which independent courts and judiciary is involved in adjudication. But the reality is the costs that are associated with litigation can be hugely disincentivizing people to go in that route, and ADR being what it is, that also has its own challenges.
So this is a very difficult problem. And the question that you have asked me is that, how do you eat an elephant? And the answer to that is one spoon at a time. So that's the only way you can effectively deal with it. But this is a very nuanced problem, because all the 5 crore cases are not all very important cases. They comprise a very different mix. There are constitutional cases, there are tax appeals, there are small claims, there are small recovery claims, there are traffic offenses, there is all sorts of stuff. So you will have to find different ways to cut this. It's like it's like a overall disease which requires a cocktail of medicines to cure it. There is no one cure. You can't just appoint 500 judges and expect to fix the system. I don't think ODR can fix the system on its own. You will have to go at it one spoon at a time from different directions. And the fact of the matter is that we are a very large country. There is because of this problem on delays, there is a arbitrage there's a litigation arbitrage which an unscrupulous litigant will always take advantage of. If they can play the system, why not? So there is no moral answer to this. There is no structural answer to this. We just have to, as they say in the movies, lage raho.
Thank you very much, Cyril, for that. Let me now take up the questions from our audience. There are a number of questions. I'm going to pick up a few. We have another 10 to 12 minutes or so. The first question is about what are the lessons that your law firm, but also maybe Indian law firms in general, have learned from COVID-19, and what among those lessons you think, or even practices you think, can be carried forward in a post-pandemic world?
So I dealt with that in some of my initial comments on what we have learned, but if I can now answer it specifically with reference to law firms, then I'm going to talk about mine. I don't know about the others.
Sure.
I think the first thing that we learned is that leadership matters, and that in times of crisis, leadership matters even more so. You have to be out there and communicating with your lawyers and your entire workforce, because at a time when there is so much uncertainty, when there is a kind of a storm outside, I think there has to be somebody who has to kind of stand up there, communicate and comfort the organization. So a law firm is essentially a organization of human beings and people who have their insecurities and their emotions and all of that. So you have to lead with a human perspective. I think that is lesson number 1. Lesson number 2 is that you have to be flexible and adaptable. We switched on 17th of March 2020 from a full work from office to a work from home in a second. And we didn't have some big committee to set up to look at it. We just decided that this has to be done. We can't put our people at risk. So we pursued a people first strategy. And since we already had the technology platform for us ready since years, I think that was easy. So flexibility is one. And I think that's also a more general answer to the VUCA world problem. I mean, again, to quote Darwin, it's not the strongest or the smartest of the species that survive. It's the most adaptable. And like any other animal in the animal kingdom, a law firm, if you think of it as an animal, only the adaptable ones will survive.
Thank you very much, Cyril, for that. That's, I think, very instructive, and that's the most pragmatic approach for the future. There's a very interesting question about does the pandemic in many ways reinforce the need for people to look inwards rather than outwards? In a way, if you look at the European context, the pandemic has created opportunities, different forms of even xenophobia, security-related, doubtfulness to have. Obviously, the Brexit is one example, but there are many more. Does that possibly change the way law firms were used to functioning? Is it part of an imagination where this is a time when less risk-taking on the part of clients will impact the law firm world?
So firstly, just to comment on your last comment, clients are not taking any less risk. There are two kinds. There is one set of clients who are taking much less risk, but there is an equally aggressive and large constituency that are betting the company. They're taking the biggest risk of their lives because they see this as an opportunity and they're growing exponentially. So I don't think it's fair to say, as we sit in December 21, that the pandemic has made people more risk averse. I think it has generated two types of responses. One response is that that the pot has been stirred by the virus, and everything is up for grabs. This is a once in a lifetime opportunity to kind of reinvent yourself. So let's take big bets and do it. So then, and these names are in the papers every day. So that's one type of company, and those that are kind of looking at the whole thing with fear and are going inward and are actually shrinking. So that's as far as the clients are concerned. But turning to your first part of your question on the human side of the talent force, so you touch upon a very important issue. And I think the virus there are two diseases at play over here. One is the coronavirus with all its variants, and the second is the mental health problem. So it is not talked about, but it is massive. And even relatively, robust, friendly, positive people, because of the isolation, because of how the virus has affected some of their near and dear ones, has scarred people's psyche a lot. So how this epidemic, this mental health epidemic, is going to be dealt with, I think we have to see. It is not going to be fixed by just having a few psychiatry lectures. I think it is going to require a long time. These are very deep scars that are embedded. The only way I can think of to deal with it is by continuous doses of positivity and growth. Because when you create that kind of positive energy, it kind of overpowers the negative energy, and you create a momentum. But this is the second big problem, and I think it has affected everyone.
Thank you very much, Kiran. There are two fascinating questions, and I'm going to club both of them. This is about the future of legal industry. There have been writings and reports on both these aspects. The first question is that it seems that businesses are increasingly, taking recourse to what is known as alternate legal service providers for different types of legal service, including, say, for example, non-traditional companies that specialize in providing high-demand legal services such as document review, contract management, litigation support, and what are the possible implications of this for the large law firm? Another question, but I think you can come and answer this. The big elephant in the room, in a way, the big four accounting firms, KPMG, Deloitte, PwC, and Ernst & Young, they have been gradually expanding the legal service offerings throughout Asia, Europe, Latin America, and Middle East. Now, this could also be because of the fact that increasingly companies are wanting to have a one-stop shop. It will be nice if you can reflect on both these developments and how it can potentially impact the future of legal industry, at least so far as India is concerned.
So let me take both questions separately. As far as alternative legal service providers, or ALSPs as they're called, so this is not something new. This phenomenon has been around now for over 15 years or more. And as I look at it today, I think they are very technology oriented, but they're solving a certain type of problem. In that horizontal view of the market that I described there on the other side, and as I see them today, maybe if you had asked me the question 10 years ago, I would have seen them as a bigger threat. I would have seen them as potentially having the ability to gobble up the entire kind of market for legal services. But as I look at it today, I don't see them. I think whilst they are servicing a certain segment of the market and are solving a certain variety of problems which are more process and technology oriented, I don't think that they have made any headway in the sort of arena where the kind of problems that law firms are solving, of complex negotiation, where there is a lot of interpretation and persuasion that is required. I don't see them. If you look at the list of top 100 firms in the world, you won't find even one against them. And then whether it is revenue or impact, so they have their place in the market. The legal market is like a zoo, and there is like place for every animal, and they have their place. I respect them for what they do, but I don't think that they are, at least currently, an existential threat to law firms. To an extent, the same answer holds good for the Big Four. The Big Four come, of course, from a slightly different angle. I think they are very strong on tax and certain aspects of compliance. They kind of nibble at the heels of the law firms on that type of work. But at the end of the day, again, same thing. I mean, would you use them for a big M&A negotiation, or would you use them in courts for a big, bet the company case? I think answer is no. They're just another animal in the big zoo. And they're different from the first variety of, they're different from law firms, and they're different from ALSP. Yes,
Thank you very much.
Entry into the market has changed the composition, but I think law firms are still safe.
Thank you very much, Cyril. It's a very interesting question from what you spoke a bit about technology and automation. This is about artificial intelligence. Now, of course, the talk about AI impacting the world of data and law has been there for a while. Now, Deloitte has predicted that 100,000 legal roles will be automated by 2036, and law firms will have to start using new talent strategies in the next several years. So my question to you is that how does a law firm prepare itself to respond to the role that artificial intelligence, robotics, and machine learning can potentially impact the world of legal services?
So artificial intelligence, robotics, and machine learning are three different things. And I think so far what has entered is more of the machine learning part. AI, or at least general AI, has not yet entered the world of legal services delivery. Even where we see AI in the law, it is on specific tasks that you see AI, whether it is on document discovery or specific types of tasks. The kind of general AI that can potentially, which we see in the movies sometimes, which can replace a human lawyer or human intelligence, that currently doesn't sort of exist. But to answer your question, what should law firms do? I think they should keep themselves on the journey of learning and curiosity. I think there is a big mistake that sometimes law firms work that I don't want to be the first. I want to wait for somebody else to solve this, and then I will come later. That's a big mistake, because every law firm is different. Every law firm's context is different. Its culture is different. So we took the first view that we don't mind being the first, and that's why we've been the first on almost everything. We know and we learn more from our mistakes than from our successes. So we have, if I look at our kind of journey over the last 4-5 years since we've been using some of these technologies, we're at a very different point today than we were 4-5 years ago. Do we think that this investment in technology has fundamentally changed our economic model? No. But has it increased our preparedness for facing the future? Yes.
Thank you so much, Cyril, for that fascinating response to us. Probably we'll just move into last two questions. This is a very interesting question on data. Of course, this is also very contemporary. On the one hand, technology is advancing and new things are emerging. And equally important is many countries like ours do not have a very strong data protection or data privacy laws. especially when it comes to online matters. Now, in this situation, how should law firms, including law firms that are at the vanguard of promoting leadership, continue their operations, ensuring proper security and confidentiality? What should law firms do in such countries when they are dealing with almost a lack of regulatory, compliance, but they'll have to have the trust and the faith of their clients when it comes to data?
So, we are, this very well. I think we are on the threshold of a law. I think just yesterday, the JPC, the term has been extended till the end of the session. So probably till the end of the year. So we are weeks, if not months away from a new data protection legislation, general data protection legislation. Of course, it will still go through the hoops of debate in Parliament. It will then have a 2-year waiting period. It might go through a customary round of constitutional challenges and all of that. But whatever it is, in the next 2, 3, 4 years, India is going to have a world-class data protection law. That's a fact. So I think for the future that will be solved, and then we will be like India is the only major economy in the world without a general data protection legislative regime. We've got the IT Act, which is kind of vague and general, which doesn't really count. But the kind of GDPR style or PDP style legislation is yet to come. So that will change the practice, the formal practice of. It's going to create a lot of opportunity. According to me, the Data Protection Authority, or the DPA as it's called, is going to be the most powerful regulator in the country. And I think part of the risk is the fact that so many powers are, and without any adequate legislative guidance, you are going to have all sorts of problems and litigation involved. I think there's no comparison between the kind of authority that they have. Now, in the short term, what should law firms and service providers do? Just keep their data properly and make sure that you are following commonsensical cybersecurity standards.
Thank you, Cyril. I have one last question, and that is from me. In my experience of working and observing leading law firms around the world, is that I have noticed a fair amount of intellectual investment and time investment made by leaders in law schools. They offer full-fledged courses, they spend time with students, mentoring, and they look at law schools not just as recruitment avenues for their own firm, but to create the next generation of lawyers and capacity building on that front. I'm afraid that most of Indian law firms, and I would say Indian lawyers and judges, have had a very indifferent, if not irresponsible, attitude towards law schools. And I'm not talking about the random lectures and conferences, but I'm talking about substantial engagement in law schools. What can we do to instill that among leaders of Indian law firms, including recognizing the importance of engaging with law schools and law students in a substantive manner?
I think that's a great question, and this is a topic that has been troubling me. We've discussed it many times as well. Is that there is a great opportunity for creating partnerships. So I think, as you rightly said, that the consumers of law, whether it's law firms or the profession, have to stop thinking about law schools as merely kind of manufacturing factories, but have to look at you as partners. And that we have to continuously keep kind of investing in you for making sure that not only our curriculum is designed appropriately, it has two-way street. So there is probably a problem at both ends. But I think you've been a pioneer, and therefore, I think you're doing great work. But if you look at the legal education sector as a whole across the country, there are only a few pockets of excellence, and there's much more that can be done. And I personally have always believed that the future lies in creating these kind of academic partnerships.
Thank you very much, Cyril Schroff, for this fascinating discussion, reflections, and of course, your candid responses to my questions and also the questions from the audience. Everybody who was part of this program absolutely enjoyed. I truly appreciate the fact that you came on board and be part of this Global Law School Summit. I'm grateful to you for your leadership. And also, it's absolutely critical for young lawyers to imbibe some of the values that has led to you becoming what you are today and your firm becoming what it is today. So once again, congratulations for all your extraordinary achievements, both including the opening up of the New Delhi new office of Civil Amachan Mangaldas, but also the fact that you have remained an inspiring figure in the world of law and legal profession. Thank you.
Thank you. Thank you, Raj, for having me today. I really enjoyed it. Thank you.
Thank you.
Welcome all to this morning's most exciting session called the She Revolution in Law, Women, Law and Social Change, with a fascinating name and a fascinating panel from across the world. We meet today this morning. We have with us from Bhutan, Professor Sange Dorji. Please correct me if I say names or the names of the universities incorrectly. Indians have this habit of assuming that we actually, like the Americans, know everything. So, Dean of Law School of Jigme Singhe Wanchuk, School of Law Bhutan. We have with us from Australia, across the continents, Professor Trish Mandi. Is that correct? Dean, School of Law, University of Wollongong, Australia. Then we have from South Africa, Professor Manage Reddy. She heads the School of Law in University of KwaZulu-Natal. And lastly, we have Professor Donna Young from Canada, from Lincoln Alexander School of Law. These are all from different, I am relieved to have said the names of the universities and of my panelists almost correctly. And that was a test of being a true world citizen. So I welcome all of you to this session. Since the name is given by Professor Shrijit, and which I thought was an exciting name, Professor Shrijit is the Executive Director, Executive Dean of JGLS. I am Professor Samina Dalwai from JGLS. So we are from these 5 countries sitting here together to discuss how women are faring in the current world of law. To begin this theme, I would like to state just 2 points, that we are actually living in a very hopeful era when we believe that we are surrounded by very capable, very dynamic young women. Especially in our students, we see that the girl students actually ace the class, they are taking the judicial exams, they are doing all kinds of social activities, cultural activities. So they are actually at the forefront of their lives. But then we don't actually see that percolating always. When they enter the professional lives and 10 years down the line, we see that men have taken over. So what happens in these 10 to 15 years of professional life? People have written materials that point to both push factors, push factors being discrimination, sexual harassment, belittling, mansplaining in the professional zones. Pull factors are family, children, responsibilities at home. There is also interesting material that says that cultural acceptance of women leaving jobs and job markets also in the long run become a disadvantage to women. Though while in the short run it may feel like they are expanding their choices, that they can leave a job, stay at home, but in the long run they are accepted as homemakers, and that doesn't actually help them in both their spheres. So all of these factors come in. On the other hand, material shows us in the last 10 years or so that employers prefer women. In the global law firms in India, there is material that shows that actually clients and corporates prefer women because they seem to be very serious. They seem to take their clients seriously. They also have better human relationships. So all of that actually points to a lot of hope. In an article in 1987, Mankal Meadow asked us whether women's entry into a legal profession, but we could actually use this, apply this to other professions as well, to a political sphere, to the social sphere, whether women's entry into all of this feminizes the profession, whether it actually puts into the profession the care, empathy, the feminine virtue, feminine value systems, And does that actually change the profession itself? It also asks questions about whether the whole system itself, law itself, tends to change because of this, how law operates, how, so there is a lot of material on how feminist legal theory, on how legal, letter of law itself, the practice of law, how they are male, how the perspective is male, how the natural is the man and the unnatural or the other is the woman. Does all of this change because women have entered the fora? So with all of these questions in mind, we will go to this fascinating panel of ours. I want to begin with Trish Mundi and the question. Each of our panelists have 5 to 7 minutes to answer the questions. And the first question to our panelists is, and I am hoping that while the questions are more to the point, our panelists will bring their experiences from their own law schools, from their own country and region, and enrich our experience here today. So to Professor Mundi, how has the world altered due to women's larger role in legal and political world?
Thank you so much, Samina, and thank you for the opportunity to be part of this wonderful panel. I'm really looking forward to the conversation. I guess for me, in terms of this big picture question, I'd probably want to talk about 2 points that are connected for me. So first of all, from a global perspective, I think it's hard to go past issues of sexual, domestic and family violence as key areas where I believe women are making really powerful changes and demanding legal and political transformation. So while the cultural context in which violence against women is experienced may be different in different parts of the world, there's a universality to gendered violence, I think, that we all share. So through sharing lived experiences, women have been advocating social, cultural and legal changes that really seek to, I think, shift the focus from victim blaming and shaming to really looking to hold perpetrators to account one way or the other. And so we've seen that through the Me Too movement, the everyday sexism hashtag movement, Time's Up, Orange the World, marking 16 days of gender violence. And in Australia, particularly, a really powerful hashtag Let Her Speak movement, making really critical changes. And so for me, I think that is something that is really striking to me and speaks very much to my own area of interest. But connected to that, and touching on what you said, Samina, connected to this is women's growing presence in the worldwide legal profession and their contributions in advancing social justice and law reform in areas that affect women, like sexual and domestic violence. So in Australia, like many other countries, we have around 65% of people studying law are women. And just this year, we hit the 50% equal participation of women within the practicing profession, which was terrific. But we also know from studies undertaken in Australia that women law students are more likely to study law because they have an interest in social justice and actually an interest in advancing social change. And I suspect that that's really a wider global experience as well. So what we're actually seeing in my experience is women law students and lawyers using their knowledge, their skills and their lived experience to actually put on the agenda in their working life and in their lives, giving voice to marginalised women, to issues that are marginalised, agitating for change on issues that affect women. and particularly advocating for cultural change within the legal profession, because as you said, change is slow and there are many cultural issues within the legal profession that are preventing women from entering leadership roles, to a whole range of, toxic culture within the legal profession. So for me, your question around, are women changing the legal profession? Do they bring a different, do they bring difference to the legal profession? What I certainly see is that right now there is this widespread movement for change. There's a demand for change. And certainly what women are bringing as they are increasing in numbers in the legal profession is bringing a different perspective on issues that affect women and affect themselves. And they're living that through their work and through the profession, through law reform, etc. So for me, I think there are probably two key ways I think that I connect with.
Trish, do you think the she revolution that we have named this panel, is it a reality or is it just a hopeful, futuristic term?
Yeah, I've thought about that. And to be honest, I actually think that it's both of those things. I think that it is a reality in that I'm seeing in my own country and worldwide an inevitable demand and revolution for change, but not only because women are demanding it, but and demanding a dismantling of toxic patriarchy, but that it serves us all. It limits women and it limits men, and so I think that it is inevitable in my sense, in my view, that we will see this change. But I also feel that until we actually get there, because the journey is hard and the journey is slow, it's also a hopeful, a hopeful frame as well. So I think I'd have to say both of those things.
Thank you, Trish. And we'll come back when the session opens for question and answer. Thank you so much to Professor Dorji, since he's the only token man on our panel. The question is whether this generally happens to women, right? On all panels, there is one token woman. So today you are in the position of a woman, Professor Dorji.
That's right.
And there is, what are the tangible changes that you see today? What do we witness today? What are the examples that you can give from your own jurisdiction?
Thank you very much, Samina. I think you're right. I like to be, it's quite I'm happy to be on this panel. And the topic is very exciting because the theme is exciting. And also actually to be representing Bhutan on this and on this summit and speak a bit, although I'm not a specialist on this topic, but definitely I think the opportunity to speak from my own experience, from what I see and what I hear, definitely. So first of all, probably I will like to congratulate the Globalizing Law School and the university for organizing this summit. And as you know, as I was mentioning just before the session started, I was just catching up with Trish, Manage, and Donna that Bhutan has, for the first time, a law school, and I personally feel that this in itself is a big achievement, actually, to have a law school, the first and the only law school in the country, and I happen to be the founding dean, although I do not possess the legal qualification. But we started work in 2013, and we have now a law school up and running and waiting to graduate our first qualified lawyers next year. And then the other thing is that probably when you look at legal education, I think as a non-legal, it also gives me the opportunity to look at legal education from a non-legal perspective. And And, probably thank you for giving me this opportunity to speak from Bhutan's perspective. I know my three other distinguished panel members will definitely make up for my shortcomings in terms of the knowledge on the topic and the subject matter. And therefore, with this statement, I'm sure the participants will definitely be able to manage the expectations from me. And, probably, I think it would be good to introduce this small law school to also the audience and the panel members here. The new law school, which we opened our doors to the first 25 students, happened in 2017 and by a royal charter. And we call it the JSW Law in short. And it is named after the fourth king of Bhutan to honor his visionary and glorious 34 years of reign. And as you can see in my background, I tried to put this on the. This is the permanent law school campus that is almost nearing completion in the western side of the country, to the west of the capital city where I'm right now here, and we're going to move there next year. And as you know, I think the biggest changes that came in the last few years is that His Majesty, the fourth king, gifted the country with the first constitution and ushered the country from an absolute monarchy to a democratic constitutional monarchy in 2008. And of course, he abdicated his throne in favor of his son before his retirement age of 65 years, which is again is very important to us. So, and then, as I mentioned, go back. So the introduction of the founding of the law school, with the first class of our students, 25 students, into our 5 years indivisible bachelors of law and postgraduate diploma in national law in 2017. And out of the 25, we have, you'll be glad to know that 13 are female. And as of 2021, this year, our student strength touched 108 and distributed across the 5 cohorts or classes. And again, 70% of them are female. So that is something that is really exciting.
Professor Dorji,
yes.
Would you be able to comment then on the future of these female students in the legal profession in Bhutan?
Yes, absolutely. And I was just going to touch on the number of female in our in the civil service and the judiciary. And I think over the period of so we will see that in the next 5 years at least, we will be contributing about 50 qualified lawyers joining the legal profession in the country. And that will definitely increase the capacity of our, judiciary and the practicing lawyers right now. And I feel that this is going to be really, really impactful role that the law school would have played. And even with the education that we have at the law school, we have what we call the clinics. And we are also these women and our boys also go out and work with live clients. And they have already been making very impactful, making impacts on the lives of the people who are actually out there, through in partnership with the various agencies, mainly CSOs. So I think in terms of the impact, some of them will join definitely the civil service. Most of them definitely will join the legal profession. And we see that Bhutan currently has not many number of lawyers and judges, and we see that our graduates will definitely be playing a very, very big role in the access to justice, and also in equalizing the opportunities that are there for both men and women. So
you have a very beautiful campus picture. We all want to come and visit. I echo, I'm sure, the feeling of all of us, and JGLS definitely loves to make connections with law schools abroad. So I'm sure Professor Siraj Kumar and Professor Shrijit, and I hope they will take all of us with them. So we will hopefully soon go to Bhutan and visit your beautiful law campus. I will move to Professor Donna Young. Thank you so much, Professor Dorji. And to Professor Young, my question is, what are the frustrations of our times? What remains unchanged, which ought to have been part of the real transformation that has not yet happened? And what has gone worse in this march towards the she revolution?
Thank you, Samina, and I'd like to thank the organizers for inviting me to this conference. I'm going to get to the kind of the negative things, but I do want to reiterate that a lot of positive has happened. So, like my distinguished panelist, Dean Dorji, I'm also the founding dean of the newest law school in Canada. This law school is really quite different, not only in the curriculum, but also in its makeup. So we have around 65% of our students are women, 80% of our senior administration are women. The majority of our faculty are women. In Ontario, in Canada, 6 out of 8 of the law deans are women. So there have been enormous changes. I'd like to acknowledge that I'm speaking from Toronto, which is on the land of the Dish with One Spoon territory, which is a treaty between the Anishinaabe, Mississaugas, and the Haudenosaunee that bound them to share the territory and protect the land. And I do think that it is important to acknowledge these as Canada is going through a reckoning with its Indigenous people. And part of what our law school is going to do and is meant to do is to reconcile our history of oppression and colonization over Indigenous people and bring that into the curriculum. That's just one example of what we're trying to do new or different at our law school. But I wanted to talk about a little bit about how I come to this topic. So for the last, I'm Canadian. I grew up in Canada. I went to law school in Canada, but I spent most of my legal career as a law professor in the United States. And so my expertise is in anti-discrimination law in the United States. And that anti-discrimination law really kind of proliferated in the United States in the 1960s. Constitutional law was developed over time from the 1940s. And the United States became a bit of a model for its anti-discrimination framework for a lot of countries in the rest of the world. But it was very clear by the 1980s or so, starting in the 1980s, probably a little bit before, that the anti-discrimination model in the United States was lacking in many ways because there wasn't this kind of recognition of systemic discrimination, systemic gender discrimination. And there was no way to legally deal with systems of discrimination. The legal system only deals with individuals who have been deemed to be the wrongdoers and individual victims. And so what we have is we've got the systems that are still intact, and we've got a legal system that really only attacks issues of discrimination in a piecemeal fashion where the systems continue to be intact. So this is where, unfortunately, we're not where we should be, especially in the legal profession. Even though we're making gains, I think all of our law schools are making gains in that we are bringing in more female students, more female faculty members, but we still have a legal system that is really quite conservative and quite discriminatory. So, for example, in Canada, we have a lot of discrimination that still exists in law firms and employment in general. Lots of sexual harassment. So the Me Too movement has, and before the Me Too movement, right, in the United States anyway, there was Clarence Thomas and Anita Hill, which popularized the concept of sexual harassment and made it understandable to the public. But we still have rampant sexual harassment in areas where men outnumber women. We also have a significant pay gap, a gendered pay gap in the legal profession. So equity partners in our biggest law firms make 25% more if you are a man, right, equity partners, than female equity partners. We have a lot of studies that suggest that in-house counsel in Canada, women are making, on average, $20,000 less per year than their male counterparts. We have gender segregation within law firms, right? So we've got the pink collar jobs. Those are the secretarial staff, the support staff, the receptionists, tend to be mostly women. The lawyers tend to be mostly men. And then this gender pay gap, of course, is felt differently depending on whether you're a racialized woman, your income status, whether you're an Indigenous woman. So we've got a long way to go. We're still seeing a lot of effects with all of this. Discrimination continues to be rampant. And I suppose, what has gone worse? That's the last part of the question. What has gone worse? Well, COVID. I mean, we're already talking about structural, systemic barriers to equality, rampant discrimination, sexual harassment. We don't see the same kind of the same kind of outcomes that we should be expecting by now. And then we have COVID forcing women into the homes where they are being subjected to increased domestic violence, increased isolation, increased mental health conditions, and also increased childcare responsibilities. We see a vast majority of the people who dropped out of the market during COVID, they were women. They dropped out the market to take care of the children that were at home. So we've got some very strict gendered roles within the family and society that are playing out in the marketplace.
Professor Young, when I'm in my class and I teach caste, gender, and the law, and so race compares to some extent to caste. And then I say to them that my subjects are training you or basically making you aware, opening your minds to all of these possibilities that exist. The discrimination that exists. And so I am hopeful that when you become judges and when you become lawyers in next 10 years, when I am at my ripe old age of whatever, I will see a new India. Do you feel that about your efforts that you're putting now, that you are doing all this to see something different and that you will possibly?
Yes, I mean, the reason I took this job, because I love being a professor. I love doing what I was doing, and starting a new law school from scratch is almost impossible, but it is thriving. We're doing well. But the reason I did this was because this law school there are a lot of advantages about building a law school from the ground up without some of the historical baggage that's there. So you can build a law school with a particular vision in mind. And one of the founding visions of the law school that I'm heading right now is this abiding optimism that we can change the legal profession, that it is our responsibility to change the legal profession as we are the gateway into the legal profession. All students who practice law have to go through law schools. So we are trying to do this really differently so that we can change not just the legal profession, but for the legal profession's responsibility to the public. So I do have an abiding optimism, even though I might not see it, right? But I have faith that our students are going to change the world. All of our students.
Thank you so much, Professor Young. My last question to my last panelist is what methods and approaches of law can obtain just social outcomes such that women can attain their full constructive social potential? To Professor Reddy.
Thank you very much, Samina, and thank you to Jay, to your university for this opportunity. I think the question you raised actually raises a far more fundamental question about why does it matter whether women attain their full potential. And in seeking to answer that question, I'm going to give a pretty broad outlook on the situation that women find themselves in globally. Although it's really inspiring to hear what both Tricia and Donna have said about the situations in their own countries, because it looks to me like best practices that hopefully other emerging nations will be able to look to for guidance on how to achieve things with minimum pain, one hopes. But coming back to the question that you've posed, what we do know is that previously, the advancement of women was regarded as essential to outcomes such as economic development and growth. However, we've now all come to realize that the empowerment and autonomy of women and the improvement of their political, social, economic, and health status are critical goals in themselves. And this shift in realization reflects a very human rights approach to issues of concern to women. Now, we know that human rights speak in very broad terms about the fundamental entitlement of all human beings to live in dignity and in conditions of social justice. They therefore provide a platform to launch a set of demands founded on the individual's inherent worth as a human being. So human rights not only create entitlements for right holders, but they also create duties for countries. Consequently, governments are required to ensure the fulfillment of these rights by taking steps to enable rights holders to enjoy the human rights to which they are entitled. However, we often find that human rights are criticized, for instance, in my country, as Eurocentric Western values which are not part of the culture of the country. I think this, to some extent, also exists in India. So what we find, however, is that this resort to culture as a reason to retain laws and practices that are harmful to women is widespread and overused. The argument that the call for gender equality results from Western domination, which does not respect cultural diversity, is flawed for so many different reasons. But a primary reason is that even though the conventional analysis of gender equality may have originated in the West, women are not equal to men in any Western culture that is known. Therefore, gender equality is not of the Western value. Equally true is the fact that the value of gender equality is not unknown in non-Western cultures. To credit the West with this norm would be to ignore that equality in all its diverse and dynamic manifestations exists as an ideal and partial reality in many parts of the world. So giving credit to the West for equality also marginalizes and insults the agency of indigenous movements of women for equality worldwide by creating the impression that their equality aspirations have been imposed on them. But regardless of their spurious nature, the criticisms of human rights, this kind of affects the approach to gender equality. Therefore, whilst there may be agreement that women and men should be provided with equal opportunities through policy programs that may focus on poverty alleviation or the equal access to health and education and opportunities for self-employment and economic empowerment, there still remains an unwillingness to adopt a coherent approach to gender-based discrimination in society. And Donna's touched on this quite extensively. There is thus also a failure to address complex problems about gender roles and relationships and the impact that these have in imposing disadvantages upon women because of their sex. Therefore, whilst there's no denying that progress has been made towards eradicating gender discrimination in various areas, for instance, more girls are going to school, fewer girls are forced into early marriage, more women are serving in parliament and positions of leadership, and laws are being reformed to advance gender equality, we find that the research reveals that a lot more still needs to be done. I'd like you to consider the following facts. An estimated 90% of countries, that's 155 out of 173, have legal provisions that discriminate against women. 30 countries still have laws that place men as the heads of households. 19 legally require wives to obey their husbands. 32 prohibit a woman from getting a passport without her husband's consent. 100 countries have legal restrictions on what types of jobs women can do. In 102 countries, laws or customary practices still deny women the same right to access land as men. About 35%, that's more than a third of the world's women, suffer from gender-based violence. Marital rape is not a crime in 32 countries, including India. In 18 countries, husbands can legally prevent their wives from working. And in 39 countries, daughters and sons don't have equal access to inheritance rights. And just one other statistic is that 1 in 5 women or girls have experienced physical or sexual violence by an intimate partner within the past 12 months. Yet 49 countries have no laws that specifically protect women from such violence. So the question is, as Donna has mentioned, conventional legal reforms continue to ignore gender inequalities. They tend to sideline the need to reform discriminatory personal laws, despite widespread recognition of substantial gender inequalities in this area. Whether intended or not, the reforms that we do have tend to promote adherence to discriminatory customary laws and traditions under the guise of supporting local laws or regulations. In other cases, we find that effective enforcement is difficult in the absence of secondary legislation, rules, and regulations to ensure that processes and resources are used appropriately. So what are the approaches that can be adopted to ensure just social outcomes for women to attain their full potential? In its 2012 report on gender equality and development, the World Bank suggests 4 priority areas to help policymakers understand and address problems associated with gender inequality. The first priority is reducing gender gaps in human capital, specifically female mortality and education. The second is improving female access to education and economic opportunities. The third is addressing women's underrepresentation in communities and political systems. And the final priority is understanding how gender inequality applies across generations. So fundamental to eradicating gender inequality and discrimination is the creation of gender-responsive laws and policies. And gender-responsive laws do several things. Firstly, they signal the state's commitment to gender equality and women's empowerment. They then create a framework for implementation and contribute to changes in social norms in favor of women and girls. And finally, they help to deter gender discrimination, to promote gender equality, and to foster the emergence of inclusive, equitable, and accountable institutions that are responsive to the needs of the wider population. So what forms must these gender-responsive laws take? In other words, what should their focus be? I suggest that the gender-responsive laws must be oriented towards establishing mechanisms for women's equal participation and equitable representation at all levels of the political process, society, and community public life. They must also serve to promote the fulfillment of women's potential through education, skills development, and employment, and give paramount importance to eliminating poverty, illiteracy, and ill health amongst women. The laws and policies must be aimed at eliminating all practices that discriminate against women and must assist them in establishing and realizing their rights, including those that relate to reproductive and sexual health. Moreover, appropriate measures should be adopted to improve women's ability to earn income beyond the traditional occupations and to achieve economic self-reliance and ensure their equal access to the labor market and social security systems. Included in the gender-responsive laws must be provisions for eliminating violence against women. The law must also eliminate discriminatory practices by employers against women, such as those based on proof of contraceptive use or pregnancy status. Through laws, regulations, and other appropriate measures, the legal provisions must also make it possible for women to combine the roles of childbearing, breastfeeding, and child rearing with participation in the workforce. So I just want to make one final comment, and that's in terms of Goal 5 of the UN Sustainable Development Goals. As of 2014, 143 countries have guaranteed equality between men and women in their constitutions. But 52, which is a hugely significant number, have yet to take any of the steps or many of the steps that I've listed above. I'd like to conclude with that comment. I'm willing to come back to this point if required. Thank you, Samina.
Thank you so much, Professor Reddy. I wanted to ask a question to all of you. With the larger scenario being like this, when we all teach in the law school or deal with students, do you have one particular story to share? I write in newspapers because I feel as academics, what is the point if 5 people, other academics read my articles? So might as well write for my students, for the larger public. So I try to do this, making one point through a story, some intimate story, something that tells, pushes my point. But I don't have to say the point, the theoretical point, because that I write in my academic work. So is there one story of one student? Because Donna mentioned a lot of Aboriginal women students are joining. In each of our jurisdiction, we meet students, females, but also people who were hitherto kept outside of the legal profession. So do you have, so just putting it out there, if anyone could bring in something that that humanizes our the discourses that we do in feminism. Does it come back to us from one student somewhere? But the questions that have come to me from the audience, I'm going to pose them to you. One is, how important is the critical mass of women in leadership position to bring in the she revolution? And that could go to Trish, who began the discussion. And the second question is to Professor Dorji, which is a very short question. Does Bhutan have laws that protect rights of working women? So maybe begin with Trish, please.
Yeah, thank you, Samina. In terms of that question, how important is it that, as we see, to have more women in the profession to achieve the change? Look, it's an interesting conundrum because on the one hand, the accepted position has always been that as we see more women enter the profession, we will see change in legal culture. And in fact, that has not proved true so far. And certainly that's the case in Australia and I venture to guess UK and America, where increasingly we're seeing more women enter the profession than men, or at least in equal numbers. So there is something about legal culture that is proving incredibly intractable, and potentially it's in terms of law school. I mean, I love what Donna had said, that actually this is a law school that is trying to think differently about teaching law and setting legal culture, because I think that's what we all need to do, because legal culture will not change in and of itself, I don't believe, simply by having more women enter, because we internalize a whole lot of culture that actually doesn't serve us, and so I think it is necessary but not sufficient is my answer to that. And if I may just very quickly, following on from Menegay, I just want to add something around, so clearly a gender lens to law and justice is really critical, but I want to just make the comment around intersectionality and the real importance of an intersectional focus, because we often live, our lived experience is often more complex than the binary of male, female, etc. And so we know that intersectionality increases vulnerability. We know that we experience oppression and disadvantage in multiple ways as women. So women of colour, lesbian women, women with disabilities. So I think my sense is that that increasingly, in terms of students, we are seeing much more diverse students coming through, and students with difference in class, in disability, in First Nations women. And we need, as both a legal profession and as law and advancing social justice, to really have a much more intersectional lens. And so I just wanted to make that point. I absolutely agree that many parts of the world we are still talking about gender equity, but I think really acknowledging the intersectional experience is really crucial.
Thank you so much, Trish. Professor Dorji.
Thank you, Samina. I think thank you for that short question from whoever came. And Bhutan, as you know, it's a Buddhist country, and traditionally, much of the laws, as you may understand, has its origins in our traditions, really, unlike our Western counterparts. So because of our rich traditions, where actually, based on the teachings of the Lord Buddha, there is no really discrimination distinction between male and female, and we see them as equal, the right and the left eye, basically, so the one doesn't function without the other. And just as I'm thankful to my mother for who I am right now, giving me this humanly, form. And, currently I work with, I'm surrounded by actually 6 important women in my life. The first one being my late mother, then my mother-in-law and my wife and my 2 adult daughters. And my boss is also a lady, a princess, and with a legal background, of course. So I really, I do not perceive much of an issue, really. And I think in terms of specific laws that really to empower women as such, I do not see one. But I think they are, what the parliament and the government is trying to do is actually trying to see where there are any laws that disadvantage women. And they're trying to create all those facilitating policies. One of which definitely I know is the last government, 3 years ago or 4 years ago, they increased the maternity leave from 3 months to 6 months. 6 months. And the current government is again now pro-women, actually, in terms of 1,000 days for a child, the mother, and then they increased the number of days for the paternity leave so that the father is there to support the mother and the child. And then, of course, the recent issues are, I think, rape related. And the parliament, everybody is trying to strengthen the, rape, the penal code, and then trying to really fix the culprits. And then, of course, in terms of the school education, no specific laws, but policies to encourage school. And if you look at the statistics in the schools, I think 52% of the high secondary school are women, actually girls. And the access to higher education used to be a problem quite 10 years ago, but I think now the access, just as you see in my law school, I think they are the top, they excel, and through the most robust selection process, I think I've been getting consistently high numbers of women in my law school. And, I'm confident that, so there is no laws, but except, of course, there are now, I hear some voices from some quarters, because I think there's a lot of influence from Me Too movements. They want big revolutionary demonstrations, not as such, but I think they want things to happen, but they want things to happen now in the most dramatic manner. But I always believe that we must be conscious of the changes that we need to make. And I am truly, as I said, I work with women most of my time, and I am very sensitive to their needs. And I have all the things that I do at the law school. It's very sensitive to the needs of my students and my faculty, 19 of them, 7 are women. And my job is to increase the number of faculty over the years with more women, if not equal. And consistently, of course, the same number of females. And I think rather than the dramatic changes that we see elsewhere with this and that, I like to believe in a very smooth and subtle transformations over the period of time, and which is much more actually sustained and a lasting impact. So I am sorry, I'm not able to actually pinpoint at specific laws as
No,
such. But
I think the question is answered. And
yeah.
if I may add to what you said, from an intersectionality lens that Trish brought to us, that, but just to extend that, to look at the world from the Western point of view does not serve any purpose. Because then, as Catherine McKinnon herself was critiqued by Black feminist theorists, that it is not more to Black women, it's different. So to believe that actually US, Canada, Australia will lead the she revolution and then India and Bhutan will follow is actually almost a funny way of looking at it. Because when I was in England, I did not enjoy the kind of status that I enjoy here as an Indian woman of a certain stature. I don't have to follow a lot of things. I always say to my students that wearing hijab and wearing high heels to me is the same. It decides for me how I should look, what I should wear by someone else. And how do you make the difference between, why do you think hijab is more discriminatory than high heels? So, and I am able to, sitting here, make those kind of rampant statements because I am actually experiencing the best of both the worlds being in India, right? So I find it very funny when I go to UK and then I'm told by UK academics how I should think about women and feminism, and I laugh. What can I say? I don't want to fight. I'm in your country, I'm your guest, and as a good guest, I just am going to smile. But I am actually in a better place, really speaking, because as we age, Asian patriarchies allow us to actually enjoy far more freedom. We don't have to remain young and beautiful. We just can expand bodily and in stature. And we enjoy far more freedom and far more authority. And we are not challenged all the time the way I would have been if I was in UK as a woman and as a woman of color. So I do see all of this that you are saying. I'm just expanding on what your points of concern are, that when we are thinking of women or the world from Buddhist point of view, it's different from the Western Christian Roman point of view. Similarly with Islam, with Islam constantly maligned, Hinduism constantly maligned in the Western hemisphere. It does not work like that. So, I mean, do you want to say something?
Just one point, Samina. I know. Also, I think Bhutan is associated with the gross national happiness philosophy.
Yes.
So I think we have a commission dedicated to that called the Gross National Happiness Commission. And not the laws, but I think it's not specific to laws, but all the government policies by the ministries and departments, and even the law school. We have to do a GNA screening of all the policies, so that not specifically trying to really iron out the differences between men and women, but I think we are all sentient beings. We all love to be happy and content. So therefore, I think all policies, by extension, rules and regulations, definitely be responsive to the happiness of all sentient beings. So as you're right. So, we are trying to ensure...
Goals itself are defined differently, and it's not equality always. We also say that Islamic feminism also has pointed this out, that the goal itself is not of achieving equality with men, because they are not actually better off than us. So I always used to say, but I don't want to be equal to men. We are anyways ahead of them. So they are trying so hard to get to our position. We are able to manage so many things. So that is, I'm going to come to Donna. I think we have last 3 minutes. And I think on her face, I see a story. So she wants to share a story of a student. So maybe we'll go to you, Donna. And if after her, if anybody wants to say something in a minute or two, we will go to any of our panelists. Yes, please.
Samina, I really don't have a story of any particular student, I'm afraid.
I was just hoping.
No, well, I mean, one of the things I'm learning as a dean, so I was an academic and now I'm an administrator, and I had never come to administration before. So all of my relationships with my students have been as a professor, and I taught courses on gender discrimination and gender and work. I taught courses on rape culture. And my relationship with my students was such that I was constantly learning from my students. That I think we're in such an amazing profession in ways, because we it's just not true that we are the ones that are imparting knowledge. We are we are absorbing knowledge as we impart. And so I don't really have anything about any particular student, but I do want to say that my students in their various backgrounds and their various experiences have made the law richer to me. I'm not a practitioner, right? I'm a professor, and they've made it more rich and meaningful, and they've given it content in a way that I'm not sure I would ever otherwise have imagined in any other profession. So I'm great. Again, I'm grateful to my students. I think all of our students are really they're going to change the world, right? The world needs a lot of change, and I think our generation of students is going to do. I'm just impressed. I'm just super impressed with them.
Thank you, Donna. I always start my newspaper articles in the class. They point something new to me, because I am not on any social media or on TV. They point out something, and then we start discussing that. It becomes a short article. It is always the case that without students, how will I write? I feel if I'm on sabbatical, there is nothing happening in life. So it is the students that drive us to feel hope, to feel anger, to feel everything that is needed for this profession. Does anyone, Manage or Trish, do you want to come in and say anything?
No, thank you, Seema. I beg your pardon, Samina, for the opportunity. I'm a little bit uncomfortable with something, but I think I'll just hold on for a moment and allow anybody else who wants to speak to articulate their views. Thank you.
No, thank you. Other than it's been a fantastic panel, I've really loved loved the conversation, and thank you, Samina, for being a wonderful wonderful host of the panel. Thank you.
Thank you.
Please feel free to share your comments. Manage? Yeah.
I think we may be out of time, if I'm not mistaken.
Yes, but we are running on Indian Standard Time. So I am going to say to my participants and the people who are listening in to us that please stay tuned, because the next session will start at 12:30, and that will be as exciting, hopefully, as ours was. Please continue to attend the conference. Thank you so much. And then, Manage, if you want to speak, please go on. The participants are welcome to stay on, but we are here.
Thank you, Samina. I think just one thing that as is making me a bit uncomfortable emanates from some of the comments that have been made in response to the questions. I'm referring in particular to Professor Dorji's answer to the question that were posed. I'm trying not to be controversial about the way I articulate what I want to say, but I think I would have been a little bit more comfortable had those comments come from some of the people that he purported to speak on behalf of. and not from a man. Let's put it that way. What I'm also a little bit uncomfortable with is that very often we find culture and religion being used as a mechanism to justify discriminatory practices. And those of us, women themselves are guilty of doing that because we're so inculcated with the dogma and the propaganda of our cultures and our religion that we lose a sense of objectivity in our approach to what it is about the culture or the religion that may be advancing discriminatory practices of which we are the victims ourselves. And then the other aspect that also makes me a little bit uncomfortable, and I put myself in this category as well, is that I think all of us are speaking from positions of privilege. And as a result, we talk of our personal experiences through that lens. And I know from research done in my own country what the lived experience of the women are in South Africa. And we have one of the most advanced constitutions, which gives everybody, I'm taking account of the intersectionality aspects here, but our constitution grants everybody rights which are just unbelievable in terms of the expansiveness. And it's very similar, I think, to the Canadian Constitution in many ways. But the experience of women doesn't translate into recognition that these rights actually exist. And that is because of cultural norms and religious norms and patriarchy and various other aspects of life in South Africa, which actually punish women, in fact, for the advances that the law is making or allowing them to make or permitting them to make. I'll give you an example of women who may achieve high positions in their places of employment. There is, because of very strong patriarchal views and because of the threat that this poses to men, to the way they view themselves, these women may be able to practice their profession with great freedom in wherever it is that they're doing it, but their experience at home is quite different. If you have a husband who isn't occupying a similarly high-level position, your experience at home is that you are in some ways sabotaged. You are diminished. You are brought down to the level that your husband may be occupying in his daily life at work. And similarly, where women have men who work under them, there is a certain resistance to what they're doing, to how they're being perceived, and to what they expect of their employees. There's a subtle sabotage of women's efforts. So the problem is that although we have these rights and we have very good legislation, which puts in place various provisions for women to soar, or for people to soar and to enjoy their human rights, we find that the experience of particularly women who are not at the same level of privilege to be able to assert themselves is slightly different. So I just thought I'd make those few points, which do give me a sense of discomfort. Thank you.
Professor Reddy, I think there is no controversy in what you said and what was said before, but, and I am a very controversial person. So believe me if I'm actually saying that these are, I think just what was said, that from Asia, the experiences may be different. They are all of patriarchy and of serious discrimination. It's just that the point of vantage points are different. And what may be experienced as feminism may be different. That's all. But the starting points are different and the experiences are different. So we may not be able to judge what is happening here from someone else's point of view. That is not to deny. Can I deny India has patriarchy? Then I will have no profession. So obviously there is. But the point of differences are not noticed by people who are making comments about India sitting abroad. That is all there is. Obviously, there is severe patriarchy, and we know that there is nothing that can be hidden, especially of a place like huge and so open as India. About Bhutan, though, since none of us have visited, I also felt that maybe its a vantage point is different. They think of happiness. Someone else thinks of equality. Someone else thinks of Amartya Sen thinks of freedom. So people are thinking of human potential in different ways. That was all. And so what you said is all taken in that spirit. That I think all of us agree with what you said in your first round and in your second round, and are most grateful for your comments and cognizant of what you have pointed out here. So thank you so much. If anyone else wants to say anything, otherwise I will close the session. Thank you so much for all of you for being present here. And I know that Trish had trouble entering, because I think we are also in different points, different time zones. And you are all possibly, many of you are sitting in the middle of the night to do this session, and terrible timings you have had to keep to be able to make this session. So I am truly grateful. Thank you so much for attending this session. Trish and Professor Doji, Donna and Professor Reddy. Thank you so much for attending.
Thank you,
Thank you very much, Siva. It's been a pleasure. Thank you.
Hope to catch up offline sometime.
Hello, good afternoon, everyone in India, and good morning, maybe good evening, maybe good night in some places. This is an international conference. It's the Global Law School Summit 2021 of the OP Jindal Global University, and we are in full swing with this conference, with one exciting discussion after another. I'm very happy to invite all of you to listen into a thematic session that's been titled Addressing Global Anxieties, Research in Global Law. My colleague Srijit said that the reason I'm here is because he also meant global policies, and not just global law. I'm the only odd person out. We have a fantastic panel of distinguished lawyers and law teachers, but I'm the Dean of the School of Government and Public Policy, and I'm generally referred to as a professor of practice. That means I'm not quite an academic, but it's okay because I've got some work experience for about 30 odd years in the Ford Foundation and the United Nations Development Program, and some education in, as it happens, in 5 universities, beginning with Mysore, then Bangalore, then Delhi, Oxford, and Cambridge. So thanks to the wonderful scholarship system and much less competition in my years than there is now for my students. So I'm delighted to have a wonderful panel to discuss this theme, and I'll say a few words about the theme before, after I introduce the panel. We have on the panel Professor Arad Reisberg. He's the head of the Brunel Law School and the professor of corporate law and finance over there. He's been a member of the Financial Law Committee. He's on the advisory group of the Bank of England on Brexit. He's the author of several books, including one called Derivative Actions on Corporate Governance. He's the editor of journals related to this field. So welcome to you, Professor Reisberg. Then we have Susan Karamanian, who is an old friend of India. We've just been talking a little bit about her first visit to Kolkata in this country. She's the Dean of the College of Law at the Hamad bin Khalifa University. And before that, she was Provost and Chief Academic Officer. And she's, I should say, also a Rhodes Scholar at Somerville College in Oxford in her youth. So welcome to you, Susan. We have Professor Sahari from the Ahmad Ibrahim Kuliya of Laws, International Islamic University, Malaysia. And he's, again, a specialist in oil field service contracts, which I believe was your dissertation. He's got several papers published. He's a member of the advisory board of the International Energy Law Advisory Group, and an advocate and solicitor in the High Court in Malaysia. Then we have our good colleague, Dr. Shashikala Gurpur. She's from my state, Karnataka. So I had to mention that, and she's again a specialist in international law, and has been taught in many universities, and she's been continuing with the Symbiosis Law School for some time, since 2007, and she's in a number of fields: jurisprudence, media law, feminist legal studies, biotechnology, law and social transformation, and so on. So polymath. Then Then we have um, Professor B.S. Chimney, who's well known to scholars both in international law and outside of international law. People like me read Professor Chimney to educate ourselves, and he's also a professor in the General Global Law School. I had the privilege of meeting him on campus, and he's very well known to all of us, so will not take time narrating a long list of achievements and the various places where he's taught. And so this is a first great panel, but I was trying to make some sense of the theme, global anxieties, and to figure out by listening to all of you panel members what we might do about global anxieties. Is there a role for law? What's the role for policy? And this is because we firstly there's the anxiety that's been caused by the pandemic, which is still not over. It's had very far-reaching implications around the world for public health in several countries, for multilateralism. We've seen that the pandemic has affected a spirit of global sharing that is very much needed, but there's been a tendency for countries to if you like, take the greater part of the vaccines that are available and leaving several other countries with much less. So that's one pointer to a problem that's been in the making, not just exacerbated by the pandemic, but even before the pandemic, the whole question of multilateralism. So we've found that some hard-won multilateral agreements and institutions are under stress. We had the COP at Glasgow following the Paris Agreement, but that's under stress. We are not sure what the outcomes would be, what each country would deliver. So that wasn't a ringing success in terms of multilateral cooperation. We've got problems with the WTO and its dispute resolution body, and we are seeing long-established international laws and multilateral practices that have been devalued by geopolitical tensions, a kind of unilateralism and ad hocery. There's a growing disconnect between people, government, and institutions. Trust in government is very low in many countries, and we place a lot of hope on the 2030 Agenda for Sustainable Development, but it would be fair to say that many people are losing faith in the capacity of their governments to deliver on those goals. And so we need to reverse these trends that have been exacerbated by the pandemic, because otherwise we risk damaging the values, principles, laws, and systems that have been the bedrock of the international community for a very long time. We need these a revival of these values and principles much more now than ever before. We've had the Charter, we had the International Court of Justice, both signed at the same time, providing a political and a legal form to the core of the international system. There are some successes. For instance, the Montreal Protocol is regarded as a success. Most air conditioners and refrigerators now don't put out the gas that they used to. The ozone layer is in a little better shape. So that's something to be noteworthy, but you might also say that the Nuclear Non-Proliferation Treaty has held out. In other words, there hasn't been a rampant expansion of countries wanting to go nuclear. Some countries did, but it still held out. So that's kind of, in some sense, it's worked. And then we have the Sustainable Development Goals, which are currently what we are concerned about. But there is, so these are the challenges, I think, that we face. They, if you like, they have to do with the future of multilateral cooperation. It has to do with post-pandemic recovery of the economies that have been badly hit. It's got to do with migration, the crisis of migration, not just economic migrants, but also climate affected refugees who can no longer eke a livelihood in the places they lived in because of drastic changes in climatic conditions that have already occurred. So we've got a severe crisis in inequality in the world, inequality within countries, which has increased. Inequality in India has been steadily increasing. And inequality in China has been increasing. So with countries like India and China that began with very low inequality amongst its population groups, in recent times, that inequality has drastically increased. We used to think it was a problem with developing countries in Latin America, Brazil in particular. It's no longer the case. India and China are in serious trouble with inequalities, and there's worries about unemployment. So I'm not sure how we are going to tackle it, but there's also, because many of you are experts in finance, in international finance, one of the concerns that came up after Glasgow is how are we to get some, what you might call just transitions, right? I mean, to support a low carbon or net zero world, which will stop putting the enormous and accelerating pressures on the planet. And so that calls for a vision of a reformed global economy. It calls for a transformation in capitalism, that has to happen. It also calls for legal frameworks for impact. Concepts of fiduciary duty and related duties at the core of financial regulation, they must be updated to take care of, our ESG impacts, as they are called, not just on financial reforms, but also the impacts of investments. So there's, no end really to anxieties and issues. So I'm not going to, go specifically and direct any specific set of concerns to any of my panel members, but I'll just ask them to lead off with some thoughts on what's uppermost in terms of the catalog, admittedly incomplete, that I just set out. So I'd like to begin with Professor Riesberg. I was thinking of him when I made the last point about transition costs and financing some of these agenda. I mean, development, SDGs, as well as climate finance, all of these issues. So over to you, Professor Riesberg, for about 5-6 minutes, I think, and then we'll go through the panel and then come back on some specific issues if others pick it up amongst you. Thank you.
First of all, thank you very much for this introduction. And it's a real pleasure to be joining you this afternoon or this morning from London. wow, where does one start with all these anxieties? I think a very good point to begin our journey, our quest, is to talk about trust. I think we are now at a stage where in the development and the global anxieties that we face these days, it's a foundation of everything that we do. So when we say that there is now a global crisis in all those areas, starting from the pandemic, financial institutions, politicians, government, there is a global trust crisis. And I think one of this interesting thing is we come to a stage, I think, in evolution, in societies, in global law, where we say on the one hand that we do not trust politicians, bankers, institutions, but at the same time, we can trust strangers to, we share a ride with them in Uber, or we view our Facebook friends, and we look at them as even more trustworthy than, I would say, than those that we put on institutions to govern us. So there is a question that I think we are in what some people call a distributed trust crisis. And it's a beginning of, we're in a position, I think, in the world right now, where there is magnitude, manifest of a number of issues that we need to come together, that we want, that are those who we put in a position of power to solve. At the same time, we do not really trust them to resolve it, whether it's the banks, whether it's governments and so on. And I think there is something to be said about what I call the genuine voice and the influence of the people on the ground, on institutions. So there is, I think, a lot of, I would say, voices on the ground, uneasiness. We see it a lot, actually. We saw that you mentioned Glasgow, in the streets of Glasgow and otherwise. And I think those sort of voices are sort of airing the concern. They're very genuine concerns. They're very real concerns. They are, I would say, existential concerns, whether it's to do with the environment, whether it's to do with the pandemic. So while there is more and more, the need is to work together, there is more and more fragmented, I would say, causes, interests, and so on. And I think, for my area of expertise in corporate law, for many years I've been, teaching my students and writing about that. The frustration is that there is this competition between jurisdictions to attract business, to attract corporations. Yet the multinational corporations are the ones who are actually dominating a lot of the conversations, but we do not hold them accountable. So, for example, on taxation, the recent treaty to try to hold account those big international corporations is one example of a way forward. It's not going to change the discourse. It's not going to change, but it's about symbolic gestures to bring back trust in those institutions. And so I think there is also, you mentioned that, you've been around for some time. I feel myself when I teach my students that I'm sort of in a different generation to them, the generation of the students and people that we see in the classroom. But they are really, really concerned. They really care about where we live, and they're asking us why we're not taking any action. And so I think I have hope that by them pushing and putting it to the agenda, there will be some change. There will be, a shift, almost by need, almost by to that. But I do not think that it's going to be the governments themselves that are going to make this, I would say, this breakthrough. In health, I just want to, it's not my expertise, but of course, this is the biggest crisis that we are facing at the moment, and it's an ongoing crisis. But unless you share knowledge, and the recent variant, for example, from South Africa, unless you actually act honestly, again, talking about trust, unless you're ready to come forward and say very quickly, we've identified something we know we're going to suffer the consequences financially and business-wise in South Africa, but we are honest enough. You gain trust. You gain trust. If you gain trust, there may be cooperation. If there's cooperation, we may get some solutions. But I think that's the only way forward. But there are, I would say, some contrasting sort of voices and streams at the moment. So I hope it's a good opener for the beginning of our conversation.
Thank you very much for those remarks. I'll quickly move over to Professor Susan Karamanian for her remarks on this broad canvas.
Well, it is a broad one indeed, and clearly the areas you identified, Dean, are important, and then of course the concept is, as Dean Reisberg just referenced, a lack of trust. I think it goes a little deeper than that, and also let me just respond to the suggestion of where governance can emerge, and this notion of letting the people on the ground sort of take ownership of this. I think it's, and this builds on the trusting, but what I'm very concerned about is the challenges to democracy and the questions about the value of law and unregulated space. We have Bitcoin, we have artificial intelligence, areas in which there's substantial activity. We have no sense of where it's taking us and the consequences associated with this. And if we were to let corporations, for example, start to help shape the agenda more on this without governments, I'm concerned about where the ultimate, where we will be with the ultimate result. You know, a perfect example, Dean Reisberg, just when I was listening to you, was like, if we think of, we can't regulate with regard to content clearly, and so we're going to let Facebook establish standards. We've seen the consequences of that and the like. And I was just thinking when you were speaking about that is to, we clearly want engagement of the of individuals. We need engagement of the private sector. Yet we need a structure for the resolution of these issues. And your example of the OECD G20 agreement on taxation, I think, is one that is a model. It's not perfect, but at least they were able to accomplish something that the United Nations has been struggling with in terms of dealing with the fact that multinational corporations have been able to shift assets and tax liabilities and the like in a way to avoid taxation. And getting back to what the dean mentioned earlier in terms of ways to address new areas and like the carbon emissions, there's been some conversation that the OECD model on taxation could be a way to have an approach to deal with carbon tax and the like. If you want to be able to establish trust, however, in addition to the political concerns that we have identified, and I think we have to be looking at growing nationalism too, as a challenge. We need to focus on, and we always say this, focus on education. But we have highly educated people who are studying, presenting papers and the like, yet for many individuals, that information is completely ignored. Sorry, I'm not going to respect this view. How did we get to the point that we have rejected science, for example? And we've had years of individual freedom of expression, focus on the individual. You know, you can look at it in the context of human rights and the like. Yet we also have this balance in terms of the community, and we're seeing it played out now with masks. Okay, my individual right versus the value to the community. So even at that micro level, we have an inability to govern. We have an inability to govern within local communities. So if we can't have standards for how we're going to treat each other on a simple question of perhaps a life or death situation and a very minor check of putting on a mask, I could understand where we are in terms of the daunting, the difficulties and daunting task of developing solutions. If I could just chime in one other thing, and in anticipation of this and the questions you submitted to us, I think we can gather evidence, we can assess evidence, we can have endless debates, but we need individuals with moral conviction and political skills to implement solutions. And that, I think, is where we are lacking. And if you look at what's getting rewarded today, it is the person with the loudest voice and the person able to get people behind them, not based on reason to a certain extent, but based on emotion.
Thank you for those observations. I now move on to Professor Zahari for his perspective.
Thank you to the Dean, Prof. Sudarshan, and first and foremost, I would like to thank to the Jeddah Global Law School for inviting me and giving me an opportunity to speak alongside all the prominent professors from all the reputable universities. I'm humbled to speak here together with Prof. Jimmy, Prof. Shashakila, Prof. Zaid Karmaniam, and also Prof. Resberg. Thank you very much. Okay, the way I look at it, actually we have as a push of law and also the policy at present, where there is a need to look what are the problems at present and how to solve it by having an ideal policy as well as policy context. So it will look into the present circumstances and also the policy that might be relevant for that particular context only, which is now. But as we go along, as you mentioned on the modernization and also even like IR 4.0 now, and those policy might not be relevant anymore in the futures. And I think to have a forward-looking policy somehow is a better solution. This policy, I think it will be much more sustainable somehow, and also will take into possession of the global development. So, for example, you give example on the United Nations SDG, Sustainable Development Goal. We have the 17 goals, and I think such initiative somehow would help the policymaker a lot to solve the global society problem. But we need to have a commitment on that. For example, on the SDG 13 on climate action, the initiative is important not only to solve the problem at present, but most importantly to solve the problem for our future generation. So then we have the Paris Agreement, we have the Kyoto Protocol, where the International Treaty, which was extended to 1992, United Nations Framework on Convention on Climate Change, which require all the state parties to reduce the greenhouse gas emission, the GHG, and also based on the scientific consensus. It happened now, and even it will affect the future generation based on due to the human carbon emission. So this Paris Agreement aims to increase the ability of the parties to adapt the climate change effects. So under the Paris Agreement, so each of the countries must determine, plan, and also to regularly report on its contribution. So when the state adopted the Paris Agreement, and the country would be responsible for their nationally determined contribution, the NDC. And this initiative would actually relate to other goal of SDG as well. For example, on SDG 7, affordable and clean energy, and also SDG 11 on sustainable cities and community and so on. So that is how the policy, the futuristic approach of the policy would come into picture now, and it is relevant. However, I think it requires the commitment from the state.
But thank you very much for those remarks. I'll now request Professor Shashikala Gurupur for her comments.
Thank you, Chair, Professor Sudarshan, and fellow panelists. We have already heard about the financial dimension, the theoretical insights, and particular dimension from the energy law perspective. I would like to combine the questions which were asked in the context of Chairperson's important pointers in the light of the pandemic, in the light of conference of parties on climate change, and the multilateralism's withering away to some extent. I was thinking about some recent developments of formation between Japan, India, and US in terms of looking at deliverables under the climate change commitment, especially decarbonization, looking at innovation, and looking at funding. So that's one aspect. Second aspect I wanted to look at is what Susan mentioned in terms of democracy. How the facet of democracy as digital public square was coming in with the online communities and spaces and interaction in a predominant way, getting reinforced with the pandemic situation. And the online hate speech resulting in worst effects on minority and others in terms of the pandemic generated vulnerabilities, further vulnerabilities. I was also going to talk about this whole idea of triangulation which came in as an approach to policy making in this direction. And where is our concern about large majority of people as academics or as advocates or as civil society activists in their visibility in this discourse, whether it is new law, whether it is policy making, whether it is global multilateral relationship and negotiations. So for me, the backdrop of international health regulations and the way in which it was manipulated rather, and the accountability issue there was never taken up. Maybe there was no time because we were busy in the innovation related to vaccine, in vaccine multilateralism or in vaccine nationalism, and also vaccine diplomacy. So where is the law and policy scholarship in terms of its response is the question that I always kept asking throughout this period of the last 2 years. So I felt that till then there was a world order which was predominantly imposed by a country or a group of countries who were strong in business, who had the know-how, who had the technology. And suddenly we started seeing some kind of fissure in that kind of, or some kind of seismic changes in that kind of international political landscape and legal landscape. There were new issues emerging in terms of accountability. Interestingly, I read articles written by the scholars coming from that part of the world who were justifying their approach as in support of multilateralism, whereas they were telling that certain nations were unilaterally declaring whether it is vaccination or trade policies or things like that in terms of shipping of masks or shipping of medicines. So there were multiple challenges coming in for human rights, particularly for the vulnerable people in terms of border crossing, in terms of challenges coming in sea trade, challenges coming in transport, and that issue has remained unaddressed as such. And we jumped into the next issue of addressing the side effects of pandemic and controlling the effects of pandemic. Now, I kept wondering, the large majority of the world, which is below poverty line, which lives on less than $2 a day, and not many treaties bringing in empirical realities of this, because as it is rightly pointed out, whether nations have failed us, whether the governments rather have failed us in bringing these anguishes or anxieties to the table. I will give you examples from the grassroots engagement that I have had with my students and different researchers. For example, we did a study on South Asian women, and we found that on reproductive choices or menstruation health, there were common anxieties, and these anxieties never got reflected in the policies or in the healthcare regulations and the exclusions. Number of domestic violence cases went escalating during the COVID period, reflecting that COVID did not create these pain areas for human rights, but COVID just exacerbated the existing vulnerabilities. I was looking at the plight of sex workers, in whose case we found that general international issues were there, but particular cultural issues which were compounded with the lack of policy or policy blindness, where triangulation was called for. So in this reality, I would like to posit before panel that we need to look at our academic research, our policy advocacy, and our government's action not to be in what we call as silos. They need to integrate, and that's exactly where triangulation dimension comes in, which very wisely was mentioned here. In the postmodern conditions, it is going to be the genealogy. I wouldn't deplore the fragmentation of approaches. I would say that it is by creating meaningfulness through this fragmented knowledge that we could search for the common denominator of global justice, reflecting the reality. Global justice not coming from one particular part of those who are articulate, who could speak English language and express and publish. It should come from the unpublished hidden voices, from those who are in the center, who are the beneficiaries, in my opinion. So policy making so far has been more of an armchair exercise, looking at beneficiaries as reported, rather than going and penetrating into the reality of beneficiaries. So whether it is the case of online hate speech, where before policy or law could respond to it, the global conglomeration initiative was the one which said that we will have our content code. Now, where is the democracy here? And where are the voices coming from? Who regulated them? And internet space is something which is cross-border. It is beyond the boundary. And in the beyond the boundary kind of space, we have this. And in the Google case, it was very clear in the EU that Google could only offload the content which is going against privacy only in the European context. And it did not do it beyond Europe under the right to forget or under the data privacy, because it said that it could be threatening to right to information in terms of human rights. So this kind of contradictions and conflicting dimensions of law at the global level, and predominantly lawmaking countries, regime being imposed through the global platforms. And as Chimi sir and other scholars have highlighted from the third world perspectives on international law, poverty being invisible in this discourse, inequality being invisible in discourse, where should the policy making focus? I would say focus on and cut through these multiple issues beyond the traditional approaches to put that, as Gandhi always said, put that Daridra Narayan in the center. Put that stakeholder. It could be a woman who is burqa clad all the time and has no voice. It could be the people who became invisible. It could be the terrains which became washed off due to climate change. Or it could be, as we saw, the human trafficking during disasters because of the invisibility of human rights within the disaster management discourses, for which COVID is no exception. So how do we look at this? Who is the vigilante on policymaking research? We need to create that kind of, I think, voice of conscience, which cuts across boundaries, law and disciplinary boundaries, as well as territorial boundaries. Thank you, Chair.
Thank you very much. Thank you for also reminding us that the first thing that for which we have evidence that happens with any disaster, and pandemic not excluded, is the steep increase in the trafficking of women, and so there, these are all complex issues. Tackling disasters in the policy making literature, we call them wicked problems because there is no obvious or clear solution. It's not clear that a nationwide lockdown was a good idea, but you don't have counterfactual evidence. You may claim that it saved lives, but then we know that a lot of people lost lives because they lost livelihoods and could not get access to normal medical care because of the lockdown. So these are all, it's a very, so for policymakers, it is an enormous challenge. It's how to deal with uncertainties, how to deal with what are known knowns, as Rumsfeld famously said, or the unknown unknowns. Those are real challenges for policymakers. But thank you for bringing a focus onto policy making in addition to the legal regime and law. So I now turn to Professor Chimney for his remarks, which we are keen to listen to.
Thank you, Dean Sudarshan, for giving me the floor. It's a real privilege to be part of this distinguished panel. My own sort of thinking is that in order to address the multi-pronged crisis that the world is faced with, we first need to identify the structural basis of that crisis. And in my view, the structural basis of the crisis is the global capitalist system, at least in its neoliberal incarnation. And I think it is the different sort of crises that you mentioned. Each of these can be traced back to the workings or to the operation of neoliberal global capitalism. It's important to address that. It is important to identify the beast, because unless we do that, we will not be able to, find the necessary responses in order to address the crisis that we are confronted with, and which is impacting, as all of us agree, on the most subaltern sections of the global population, the most marginalized and oppressed sections. Let me just illustrate the impact of neoliberal global capitalism on the different crises. At first, the pandemic, of course. Now, I think everyone is agreed that the only way that we can overcome the pandemic is to ensure that every individual in the world has access to vaccine. Yet the reality is that in some continents, for example, in Africa, less than 10% of the population has been vaccinated. But at the same time, while that is the reality of what the WHO chief has called vaccine apartheid, every effort by countries like India and South Africa to secure a waiver from the WTO TRIPS Council and, of course, from the WTO General Council for a waiver on the application of the agreement on trade-related intellectual property rights has been stalled. Has been stalled despite the initial support received even from the Biden administration. And the reality is that the interests of the big pharma prevails over the interest of the poor and marginalized peoples and groups in the world. And the whole idea of stalling it is so that that reality overtakes us, and we do not have, and the need for waiver itself goes away. Likewise, if you look at the climate crisis, I think the very fact of naming this phase in human history as the Anthropocene itself is symbolic of the crisis, and the hesitancy to call it what the Swedish economist Malm calls Capitalocene. And the problem is not simply with naming. The problem is that if the naming is not correct, then the answers that you come up with, which in this case is relying even more on markets, not yield the necessary outcomes. The outcome is more likely going to be what has been called carbon colonialism through carbon offsetting, and the refusal, of course, of the big capital to really take substantial steps towards decarbonization. Likewise, I can go on. In the case, as was just mentioned, in the case of the digital crisis, which emerges from the coexistence of what has been called surveillance capitalism by Professor Juba from Harvard University, and the surveillance state coming together. That crisis again cannot be addressed without global regulation. And global regulation is being subverted against the digital world by the likes of Amazon, Google, and so on and so forth. So whichever way you look, this is a crisis which is the outcome of neoliberal global capitalism. So that recognition can come back to a range of possible responses that can be put in place. You're right to suggest that there is a crisis of multilateralism, but I see this not as a crisis of multilateralism, a one-sided crisis, I would put it, of multilateralism. Multilateralism is not crisis in the sense that the G20 are that complex. The crisis lies in the fact that the weakest, that the poor nations, the weak nations, and the weakest sections of their population are no longer heard. That is the crisis of multilateralism. For the rest, multilateralism of the rich continues to function and function effectively. Now, how do we address this? Again, we need to go back to, and I'll stop there. We need to go back to first principles. So the first principle is what is called now in political theory as a principle of affected persons. That is, those who are affected by global governance regimes, as was mentioned by others, need to be heard. The democratic deficit that is present in the multilateral institution needs to be urgently addressed. Because for the first time in the history of humankind, of the weak nations that are going to be affected, if we do not address global warming, we are going to provide. We know the rich are already planning to move to others. they are already planning. They have invested sufficiently to leave for other spaces. But we do not know if that would work out. So we need to collectively address our problems, and that can be done only if we ensure the welfare of all the weak nations, the poor and the poor and marginalized peoples. I'll stop there. I'm sorry for going on for this long, but this is a troubling phase in our.
Thank you.
So,
Thank you very much, Professor Timmy. Yeah, in the next round, you may wish to switch off your video because your bandwidth is weak. So we lost, we got the drift of what you had to say, but we couldn't hear very clearly some of the words. They get elongated in some way when the bandwidth is poor. So when we come back to the second round, we'll alert you if you can switch off your video and then speak. We've had a very interesting range of comments and perspectives. One thing I picked up in this is that, there's always been, as Professor Chimney pointed out, there's been a serious dissatisfaction with what's described as neoliberalism, the international system, and capitalism in its current avatar. And there's been dissent. I mean, we've had it in Seattle, we saw it in Glasgow recently, and within countries. There have been many movements that where ordinary people have got together to protest at the injustices that they see around the world. But on the other hand, we've got governments that are keen to use all kinds of means, modern technology, and so on, to keep a watch on not just those who come out and protest, but those whom they think are likely to foment protest. And so a kind of preventive detention or preventive harassment of people is already underway in many countries in various ways, including India. So before we turn to some of the questions, connecting, the nature of democracy, people have, Professor Reisberg started with the lack of faith in institutions, in government, among different population groups within people, people who lived well and had harmonious community life are now looking upon one another with suspicion if they belong to a different religion or a different income group, class, all of that. So there's that, there's evidence of dissent, evidence of suppression. Representative democracy seems to have run its course. People think that elected representatives look to their own interests and don't serve the interests of people. We've got, John Keane famously called, we are living in times of what he called monetary democracy, by which he meant that the internet and new forms of asking questions and accountability are emerging, and maybe that's the direction in which democracy might go. So before we turn to questions that have come from the audience, I would like some reactions to this, because this is a very immediate problem of governments, not policymakers, as Professor Shashikala Gurpur pointed out, not really being in touch with stakeholders of policy to make policy top down, and then if it is politically expedient, to reverse the policy in just the same way, top down, without debate and discussion. We are witnessing these things all around. And then even within disciplines, and this is a question maybe you might wish to ask, there's a lot of churning going on, say, in a discipline like economics, which informs a lot of public policy, in fact, overly influences public policy relative to insights from other disciplines. But economics itself is grappling with what do you do in circumstances of uncertainty. There's no such thing as an equilibrium. There's no such thing as some price at which the market will clear. Then how do you revisit the foundations of that discipline? So there must be that kind of churning going on in other academic disciplines as well, because we've come face to face with growing uncertainty about it. So there's no confidence in the predictive power. Evidence-based policy making becomes a slogan. It's more like it's not evidence-based policy making, but it's policy-based evidence manufacturing that we witness in many places. So I'd like some quick reactions to this crisis. This is about people, their institutions, democracy, and of course, some ways by which these voices are heard, and there's some reform in the capitalist framework that all countries have now bought into. We thought that with that, free markets and so on, there'd be a corresponding opening up of the political space, but China is proving to us that that's not going to happen. In fact, the opposite will happen. So these are concerns. So some quick reflections on these. I mean, as to where do we see ourselves, where do you see the world going? So let me begin with you, Professor Chimney, and go in reverse order. You put your finger on what you call the structural problem. So reactions to my comments, and then we'll take some questions. But you may wish to switch off your video.
Okay.
Yeah.
Thank you, Dean Sudarshan. My own sort of view is that the structural crisis in neoliberal global capitalism is also reflected in a global, what I would call, epistemic crisis. So there is a crisis in knowledge systems itself. Let me take the example you gave, economics. You would have probably seen recent writings which point to the fact that even in the area of development economics, which is of crucial significance to global South nations, knowledge production, that is publications, are actually dominated by scholars from the global north, and this is a very worrisome tendency. And this sort of kind of crisis is reflected across disciplines. In my own disciplines in international law, all the critical theories now have a much greater presence than they had 2 or 3 decades ago. And by critical theory, I mean feminist international law theory, third world approaches to international law, Marxist international legal theory. They do have some degree of presence. Yet, the fact remains that mainstream international law scholarship continues to dominate the scene. Even within mainstream scholarship, it is most of the publications come from the global north. This is also true of critical theory, that much of the publications emerge from the global north. So the point I want to make is twofold. One, that this sort of kind of skewed state of affairs, so far as knowledge production is concerned, needs to be addressed urgently. The second, of course, is that we need to ensure that the voices, as you said, from the ground, as others said, from the ground, need to echo within global policymaking institutions. That is not sufficiently happening, despite the efforts of global civil society. So my sense is, and that the crisis in global capitalism is internally, if I may put it that way, related to the epistemic crisis, the crisis in knowledge production, especially the fact that much of knowledge emerges from global north and its academic institutions.
Thank you. Dr. Gurpur.
Thank you, Chair, and thank you, Professor Chimney, for those sharp insights. I would take it from where you left in terms of international law scholarship, in terms of global north being the citadel of knowledge production, whereas the global south hasn't been forthcoming. The main thing is the richness of global south's culture and the multifarious languages and expressions and the different stages of evolution of these academic institutions and scholarship who would have migrated like Rhodes Scholars and others, but they would come back and then how far their opportunities and their inclinations are going to be all inclusive is the question. So there it would come to decolonization of the mind, decolonization of approaches, and multiple truths, many ways of knowing, many truths to be unveiled, you know. What I experienced was that complementarity of law and policy, complementarity of law and economics, as you rightly pointed out, Professor, and even Professor Sudarshan, and other disciplines would call for this commitment to truth. When we talk about commitment to truth, let's not forget. Let's not forget power. Power in the main wielding forces of the state, in the form of governmental power or in the form of dominant voices or dominant groups. That would mean that the power has to shift, it has to diffuse, and that power and truth kind of conundrum which postmodernist world is talking about in terms of epistemes need to be uncovered. So the claims, the truth claims to be validated. So what we see here is what Sir pointed out in terms of Chairman Sir, producing evidences, you know, the idea of manufacturing consent, which Noam Chomsky talked about, or Walter Lippmann's rationality belongs to the cool observer. Can we be the cool observers as scholars? No, we have to be passionate. Our emotions have to come into the center. So when we were working on sex workers, I tell you what we learned from them. In Karnataka, we were asked to make the policy recommendation. We thought that what they needed was a house to relax and exercise their autonomy. But when we factored in their expressions and we statistically analyzed, of course, using all the modern technology, we came to the conclusion that what they wanted was dignity. So the paradigm of law and the reality and the truths of their lives, as revealed in their descriptive case studies and statistical surveys, showed us that what we thought as truth was not the truth. They had their own worldview, they had their own experiences, giving us the authentic truth. Therefore, today when the policy or the law in its democratic support from the public opinion is being manipulated through online mechanisms, interest groups, I think we are in a real danger. So the time has come for us to look at this. For example, the correlation between trade and labor, the whole gig economy, and the collaboration between WTO and ILO. Where is that collaboration? How strong is that collaboration? First. Second, what do you call as innovation in terms of intellectual property rights protection? Third world voices always spoke about traditional knowledge, the rich resource in biodiversity, but whether innovation has factored this in, if it has factored like we had the Jivani case in India, whether there was equitable access and benefit sharing. The third is the vulnerable people, like compounded realities of, let us say, those who are physically challenged or mentally unwell. These vulnerable sections, how have we factored in their realities? Our legislations might have done it, but whether we have seen those laws and policies in action. Look at the power of technology and usage of that power of technology to equitably distribute the capital, taxing the super rich, for example. Now there is the whole issue of too much of concentration of wealth in 2 or 3 companies or CEOs, and their rich lifestyles being the occupants of the space of the whole media. Now, where is the legitimate question of their authority to own this wealth? The legitimacy of democracy of allowing such concentration of wealth, and what could be the role of our law and policy in equitable distribution and regulation of such wealth accumulation. So I would say, as one sentence, the search for global law and global justice and transdisciplinary episteme in this area would have to go in search of a common denominator while looking at commonalities and divergences in a transnational collaborative truth searching. Thank you.
Thank you. Thank you for that emphasis on truth in this era of post-truth. Professor Zahari, a minute or two.
Thank you, Dean. Okay, to answer this question, I would agree with Professor Shikala on the finding the truth, and also the points made by Prof. Chini on the crisis of knowledge, and also the interdisciplinary, like on the economic aspects and whatnot. The way I look at it, so we have the problem that happened previously, where we look at things on the diagnostic approach. So we look at what are the law, where we need to look at the background for each of the circumstances related to the issue at present. So there's a need to look at the historical background and also all the chronological events, each of the case. And there is another approach to look at what is the law or the policy at present. So we need to look at what are the problems, what is happening now, and how to solve it by having an ideal policy, as well as the policy in context. But I think due to the late modernity, of course, we need to appreciate the interdisciplinary knowledge that I think is less as well, because there's the knowledge, be it legal jurisprudence or public policy on positive law, they support each other. For example, earlier on, I talked about the SDG 13 on climate action, and also I talk about the SDG 7 on affordable and clean energy. So no doubt that they are important to solve the present problems and also the future issues for the next generation. However, when it comes to the process of implementation, it must be appropriate. Okay, as for example, like while one is so eager with the education of knowledge, with the education of the clean energy, for example, taking into consideration the SDG 7, they want to implement all the latest technology and also the infrastructures. However, as a researcher, we need to, as a policy maker, they need to look into, they need to take into consideration whether it serves justice to all stakeholders. So in this regard, for example, the principle of energy justice come into picture. So the energy policy that must strike, the energy policy that to be implemented must strike the balance of the three triangulation from the perspective of economics. That is where the economics come is very, very important. The politics, especially when we deal with this energy security, for example, and also the environment, when we talk about the climate change and mitigation. And these aspects of the aspect of energy must serve the core three tenets of energy justice. For example, there's a doctrine, distributional justice, okay, procedural justice, and recognition justice. So we need to consider the social welfare of the affected community, whether the energy policy, okay, that will be introduced has been done with due process, and also there's a transparency where there's accountability and whatnot. So the legal jurisprudence and also the development of law and also policy supported by the interdisciplinary, I think, is a blessed and work in hand to solve the global society problem.
Thank you. Thank you very much. So over to you, Susan.
Yeah, I know time is very tight here, but I would like to just respond to Professor Chimney and a couple of the observations and think about another body of law we really haven't touched on today, yet it is, I would beg to differ, is it being driven by capitalism? That is the field of human rights, grounded in philosophical principles about individuals, reflected in constitutions, reflected in national laws, emphasizing the freedom of the individual. And if you think about how these rights have fundamentally transformed our engagement with our states, even with the non-state actors, and even at the international level. And through this, I think we've seen, thanks to technology, a fundamental transformation of the ability of the individual to be engaged at the international level. We can access evidence through a click on the computer. We can gather it. We can become, through Instagram and other TikTok, agents of change and call out major actors and the like. So with this ability to communicate, it's no longer within the hands of the global elite. It's no longer in the hands of the capitalists. It's no longer in the hands of government decision makers. It's in the hands of who are able to, getting back to the issue of gain respect, and to be able to, we would hope, act in a truthful manner. The concern is do we have an audience that is prepared to be as discerning? And it's on all sides. It could very well be people in the United States who are angry at government, who embrace this medium and aren't prepared to question and believe in the half-truths or the misrepresentations, and then it takes on a life of its own. I just think that in terms of international governance, we have a story on the human rights front that is a bit counter to what Professor Chimney said, and it needs to be part of the discussion.
Thank you. Thank you very much. Professor Reisberg, few minutes, 2 minutes maybe, or 3?
Yeah. Thank you very much. Gosh, you're touching on a number of, I would say, interesting and concerning issues. I will focus on 2 points. The first one has to do with my co-panelists talked about the global north and the global south and that intersection. There's interesting discussions in the UK at the moment about the role of the UK in addressing this rebalance. So, but there is an issue that very slowly governments and institutions and actually legal institutions and the Department of Development was discarded because of the crisis, because there's no money. So there is much more inward-looking sort of thing in the UK on the one hand, yet at the same time, the UK need to kind of, or claiming to take a bigger role. When politicians were asked about these questions, and whether there is any legal sort of enforcement mechanism, they basically only cite what I call saying, oh, but the UK is still the second or the third largest in terms of contribution. That's not good enough. It's not about that. It's about raising your voice and taking a. So the inward outward is a really interesting one. I think the pandemic has shifted that because there's so many, I would say, immediate concerns internally needs to be addressed. So many injustices within the society that have been, I think, exposed because of the pandemic. That the governments are looking inwards at the time when they need to look outwards. The second point about technology, which Susan just mentioned, I couldn't agree more. There's more and more voices. We have more and more tools to do that. Yet, even the tool that we are using at the moment, Zoom, I think there's too much power that is given to those companies to control certain things in action, in their actions. So to what extent, yes, we can use those tools, but without those tools, we will not be able to have, for example, this discussion, this really fruitful discussion. But at the same time, does any one of us know exactly where does the profit, where does all the issues that Zoom is using, and I'm not, picking up on Zoom, it's just for the sake of the argument. Where is this going to? Are they actually listening to concerns in terms of employment? Are they actually protecting those who are working in the company? And most importantly, what is the long-term effect of this of concentrating power in those sort of small organizations, yet very powerful ones that rival, I would say, governments in their power?
Thank you. Thank you. I think we've come to the end. When you remarked Zoom, I thought we must rephrase Descartes. Cogito ergo sum has now become cogito ergo Zoom for many of us. Yeah, so this has been a fascinating discussion. I won't attempt to, sum it up. There's no time either. But I wanted to, I've been listening to all of you, and particularly Susan's focus on the legacy of human rights that we've built up, that animates many constitutions and many movements, civil society movements around the world. I think that gives us hope. And so I recall a quote, I think it's from Martin Luther King, who said that the morality cannot be legislated, but behavior can be regulated. Public policy is all about changing behavior. And he said judicial decrees may not change the heart, but they can restrain the heartless. So I think we have to conjoin the values and principles that underlie the entire legacy of international law and human rights, and bring it to bear for policymakers, to inform their decision making as policymakers, because the kind of an amoral attitude towards policy making is not going to help humanity any longer. So thank you all very much. This has been a wonderful discussion, and I'm very, very honored and thankful to have been a part of this conversation. Thank you.
Thank you, everyone. Bye-bye.
Thank you. Thank you very much.
Thank you very much, everyone.
We are on air.
Good afternoon in Sonipat. I know we are all in different time zones. And a very warm welcome to all of the distinguished panelists today. The topic for the dialogue today is Culture of Constitutionalism, the Globalization of Constitutional Law. We have with us today Professor Gavin Phillipson. He's Professor Bristol Law School at the University of Bristol. We have with us the Honorable Mr. Andras Sayo, former Judge, European Court of Human Rights, Strasbourg, and Professor of Law at the Central European University in Hungary. And we have with us Professor Adrienne Stone. She's the Redmond Barry Distinguished Professor and Director, Center for Comparative Constitutional Studies at the University of Melbourne. So I'll just give a very brief introduction to the topic, and then I can address the questions to each of the panelists. And if you have comments, any of the other panelists would like to comment, that's fine as well. And in the last 15 minutes, we'll have questions from the audience as well. So globalization is the umbrella term that is used to capture the enormous increase in the flow of people, capital, goods, services, and ideas across national borders. During the age of globalization, many areas of law appear to be subject to some degree of harmonization and standardization. However, the field of public and constitutional law is often viewed as one in which public law arrangements they seem to be designed as much in dialogue with the past as with the future. And that past is likely to be pretty nation specific. So public law systems are often seen as being deeply embedded in a certain social and political history. And references to constitutions are seen as a return to the local and the national. States and their citizens have relied on constitutions whenever and wherever there was an overreach of globalization. However, certain contemporary trends that have emerged in the field of constitutional law reflect the effect of globalization. So, for example, there is the phenomenon of constitutionalization of international law through treaty becoming constitutions, and the internationalization of constitutional law through such means as incorporation of international human rights treaties into domestic constitutions. As a historical matter, constitutional discourses predominantly, but not exclusively, occurred in the domestic legal setting. However, recent years have witnessed an intensification of constitutional discourse in many sites of transnational governance. Increased globalization makes it more valuable for actors to enter into denser legal and institutional relationships, including constitutionalized relationships. Indeed, there may be a dialectical relationship between globalization and constitutionalization along the following lines. Technological and social change yields greater possibilities for beneficial international interactions, including international commerce, but also increasingly now international environmental stewardship, international cooperation to combat organized crime, and so on. International legal rules become more valuable to realize the increased benefits of these international interactions. This increased demand for production of international legal rules gives rise to an increasing demand for international constitutional norms and processes that facilitate the production of these international legal rules. These debates over transnational constitutionalism occur as the international community continues to adjust to the end of the bipolar era in the context of a highly diffuse and pluralistic processes of global governance, and at a scholarly moment which consists, as David Kennedy notes, a moment which is both of great unknowing and of disciplinary reinvention. The prominence of debates over constitutional orders beyond the state reflects larger patterns in international relations, including the increased density and reach of international norms, the increasing importance of new legal actors in international legal processes, and the rise of new topics of international legal regulation. And there is also an increasing sense that some of these developments threaten elements of domestic constitutional structures. So with this background, I'd like to go to the questions and perhaps I can address the first question to Professor Phillipson. Would you be interested, or Professor Stone? I'm not sure. I know that you didn't indicate preference for that. So I don't know if you would prefer to answer that, or if I could address that to Professor Sayo. So there are several influential strands of thought that suggest that pressures for international constitutionalization are a product of globalization and the accompanying increase in the reach and density of international legal norms. So how can this claim be examined critically? To what extent does globalization actually drive constitutionalization in international law? So I can ask Professor Sayo, or it could be Professor Phillipson, perhaps.
I thought Adrienne might be a better place to speak to this one than myself, certainly. I was waiting for one of the later questions. But
well, let me just say, I think briefly, because I'd really like to hear what Professor Shaiho has to say on this, but my sense is that it's important always to remember that constitution making has always been, to some extent, an transnational affair. So I live in a country with one of the oldest constitutions in the world, relatively unchanged for 120 years. So its origins are way back in the history of constitutionalism, yet but very much a transnational affair. Australia was particularly obviously influenced by its heritage from the United Kingdom, very influenced by the United States, and at critical points also very influenced by the Swiss constitution. So I think that this has actually always been with us, this transnational, the transnational nature of constitutions. There is this sort of myth that's in our constitutional theory of a constituent moment when the people come together and make their own political settlement. Now, it's an important myth, and it might be particularly appropriate in certain kinds of contexts, but I think it's always been much more complicated than that. So if you look at the Australian Constitution, it does not at all fit that model. If you can think about a constitution that was formed in a post-war context all the way back in the middle of the last century, like Japan's, also doesn't fit that model. So you don't have to look very far to look for really long-standing evidence of transnationalism in constitution making. And so I would say that it's not a new development, it's a fundamental part of the phenomenon.
Any comments, Professor Phillipson or Professor Sayo, or should I move on to the next question?
I suppose I was just thinking in relation to the UK's own constitution or lack of a constitution, that it was a sort of peculiar feature of Britain's colonial past, that it would kind of, as it were, give written constitutions to the countries, to the dominions as they were known, while refusing to do so for itself, and at the same, thereby kind of undermining some of its own arguments against having one itself, particularly in relation to being a common law system, which then gave birth to several successful constitutions in countries like Canada and Australia, while declining to do so itself. I'd say that Britain remained relatively, in that sense, kind of resistant to international influence until around about the 1970s onwards, when there was an explosion. Obviously, the European Convention on Human Rights in 1950, but that started very slowly to have influence and really kind of exploded into life, not till about 20 years later or so. And then, of course, the European Union, which despite Brexit, which I'm sure will be mentioned again, continues to have an enormous influence upon the UK constitution, as well as, of course, globally as well. I think the global reach of EU law is something that I'm sure will come to well beyond the European Union.
Yes, and in India, I mean, although, as Professor Stone was saying, we do kind of have this symbolic moment of, the Constituent Assembly sitting and drafting the Constitution and so on. There are scholars who still think that the Indian Constitution actually reflects the Government of India Act of 1935, which is a British statute, actually. And we had Professor Dr. B.N. Rao. He was the constitutional advisor to the Constituent Assembly, and he actually went around the world looking at constitutional precedents. So he has a book called Constitutional Precedents, where he went to the US, the UK, Ireland, Japan, and he came and kind of discussed all these ideas with the Constituent Assembly. So yes, so I think as Stoke was saying, it's not just at this point in time that there is this kind of transnational influence on public law. It's been happening for quite some time.
May I add something?
Yes,
to this?
yes, of course.
Because I come from a continent where there is probably more integration to at least regional network of constitutionalism. So first of all, the history of constitution making, at least, going back to ancient Greece, but certainly beginning after World War I, it was always related to comparative studies, and foreign influence did play a role, except that this was always something instrumentalized. So yes, there was always reference to foreign examples, but which one to choose, that was the really interesting issue. So it was a major source of legitimation. In many countries in Europe, and of course South Africa, the contemporary approach is, and this is constitutionalized to different extents, that foreign experience matters even in a normative sense. So either the Constitution has provisions that foreign or international experience has to be taken into consideration, or a judicial practice indicates that a pick and choose reference to international development. So it is present in many different ways. What I think is also very interesting to note that this more intensive presence of an international, I wouldn't call it global dimension, is multi-layered. So it's not just that you have a number of constitutions you refer regional human rights or other conventions. And once you get into these, you see that there is an enormous internal tension. And that creates a very specific new dynamics in constitutional law as applied and also as it is written, because it is so complex that a country that is supposed to exercise its sovereignty in reality chooses what kind of model to follow. So that's a new meaning of sovereignty. It's do you allow this kind of influence to enter or that kind of influence to enter? And with a re-emergence of the idea of sovereignty because of growing nationalism, this choice becomes even more important. It becomes a matter of rejection too. So in the name of sovereignty, you hear these days that this global constitutional influence or regional constitutional influence is contrary to sovereignty. We are not yet discussing the normative aspect, but I just wanted to highlight how complex this relationship became. Thank you.
Yeah, so usually I've also read that you have these legal families forming, where there's, from the disintegration of these previous colonial empires. So the German colonies would kind of look to Germany for the prototype, or the British colonies would look to the Westminster model as the prototype. And, so India, for instance, adopted the Westminster model with a little bit of difference, because we have a written constitution and Bill of Rights and judicial review and so on, and we have a federal constitution as well. So there is also, I think, in terms of classification, we try to kind of classify constitutional systems based on the prototypes that they followed when they drafted their own constitutions. But you're right, it's a very complex process in terms of asserting your sovereignty and at the same time trying to learn from the experiences of other constitutional systems that were kind of iconic precedents. Any further comments before I move on?
I suppose the example that comes to mind of a country that has stubbornly resisted external influence, particularly in constitutional and constitutional rights matters, is of course the United States, which has kind of fiercely resisted, and even as I think one of the questions we're coming to, but you get very heated debates in the Supreme Court as to whether it's even permissible to cite kind of any form of foreign law as kind of any possible useful guidance, and some justices and indeed law professors in the United States are kind of very, very resistant to that. But I think what's interesting is and the kind of prevalence of the big lie in the United States. So it'll be fascinating to see whether the US ends up somewhere closer to what you might think of as a kind of European/Commonwealth consensus on a more kind of moderate balance between, in that case, sort of free speech and reputation, but across a whole range of areas where the US has stubbornly maintained a very, very different course in many areas of free speech, including hate speech from international consensus and both international human rights treaties, and from which it always enters reservations, and also comparative norms.
Yes, we'll be coming to the problem with judicial, the judicial kind of, if the judiciary can look to foreign precedents, we'll be coming to that question. So perhaps we can move on to the second question, which is what are the significant sides of transnational governance and what are the implications of international constitutions? Are constitutional orders beyond the state conceptually coherent and normatively desirable? And what is at stake in debates over global constitutionalism? Professor Stone, Professor Phillips, would you be interested in?
I think since the Professor Shiho take that one, I would think.
Okay.
Just very briefly on the normative aspect. So if you believe in separation of powers as a tool against tyranny, then the internationalization or globalization, where you have additional veto players, is a great addition. So it's normatively justified from that perspective. It is just another element in this separation of powers dynamics. And I think that's a sufficient reason, notwithstanding all the complications and complexities and abuses. I think that there is a very strong reason to endorse it and consider it a major contribution to constitutionalism.
I've read of articles where the UN Charter is often seen as being, something on the lines of a world constitution. So, is that something that you would also agree with, Professor Samuel?
Well, I think that it set into motion or enabled a certain trends. The Charter itself, it's hard to say that it is of direct relevance. It gives certain inspiration about the use of force, for example. So it has a tempering influence, but I mean, in terms of being applicable domestically, I would say that is not a primary mover. What is a primary mover is the whole system that is developing out of the UN system on the basis and in the spirit of the Charter.
Comments before I move on to the next question?
I was just wondering, could we say that bodies like the UN and the, all the treaties that have come from it, including the various human rights treaties, are a source of international law, but only the European Union has attained kind of internal constitutional status. In other words, is a constitutional order beyond the nation state, whereas bodies like the UN and other international bodies simply are sources of international law, not constitutional law themselves. I just throw that out in case anyone wants to comment on that.
Yes, you have so many regional pacts, so you have ASEAN or NAFTA or something. So none of them kind of really approach the constitutional law-like features, I think, of the EU system, right? Is the development of constitutionalism beyond borders the most developed within the EU?
I would say so. Yes. I mean, I'm often struck when I visit other common law countries like, say, Canada or Australia, whether the fact, the kind of the deep interpenetration of European Union law directly into not only domestic law, but constitutional law. I mean, the EU claims that the EU law has a higher status than any national constitutional provision, which is obviously being challenged by several states at the moment. But I think that's a kind of unique, that's a unique claim made by an international body to actually override not just normal domestic law, which for dualist states would not be permissible unless they've chosen to implement it via domestic legislation, but also to override even core provisions of their own constitutions is a remarkable claim. And I can't think of another international body that seeks to make that claim.
May I make a comment just going in the opposite direction? I think it's important, if we think of Professor Scheiho's point, that what supranational constitutionalism can provide is another veto point, right, for the unitary state. But the same can be done by subnational units. And I have just been so struck in Australia over the period of the COVID pandemic of how it has been state government that has been really at the forefront of dealing with this and really, really prominent. And I would also like to say that I think, turning from my own country globally, that I think that cities and city governments is likely to become extraordinarily important over the next century with the growth of megacities throughout the global south that experience problems in their own distinct forms, that I think that there's good reason to both seek to empower cities and expect that cities will be seeking to empower themselves. So I wonder if the story of the 21st century, or part of it, might be a reinvigoration of the subnational.
I think Anne Herschel has just written a book on cities or megacities being the location of constitutionalism. I haven't read the book yet, but I believe that's...
I have read it and I recommend it to you.
Okay. Okay. Okay, so if there are no further comments, I can go on to the third question. I think Professor Phillipson said you might be interested. How is the emergence of international human rights treaties and conventions and regional arrangements, I think you've already addressed part of this question, arrangements such as the EU impacted or affected domestic constitutional systems? And what are the interrelationships that connect these systems? Would you like to go a little further in detail into this?
Well, again, I think there I'd be interested in Andres's comments on this, but I mean, I would sharply distinguish the impact of something like the European Convention on Human Rights, which also, of course, has a much larger and more kind of disparate membership, and the European Union. The ECHR, although it's been perhaps probably the most effective human rights treaty globally, in terms of actually kind of resulting in changes to domestic law in general. Kind of international human rights law suffers from a kind of chronic weakness of enforcement. So the right of individual petition, where citizens can themselves go to the court and then their countries will change the law in response or provide some other remedy, I think has been kind of uniquely effective. But it does operate within a conventional dualist system. So it doesn't require its own incorporation into domestic law. It operates for dualist countries in an orthodox way, in that the judgments of the court are binding on the state qua state, but do not themselves alter anything in domestic law. Although countries can choose to give effect to them, as the UK did in 1998. So that, as compared to the European Union, which claims obviously direct effect and supremacy as the kind of two fundamental features of its law, which is interesting, neither were in the original treaties. A little bit, I've always thought there's a little parallel there with the fact that the strike down power for courts in the United States was not actually written into the Constitution, but was obviously famously declared in Marbury and Madison. That neither the doctrines of direct effect nor supremacy over domestic law were actually explicitly stated in the Treaty of Rome, but were essentially developed by a court. So the fact, yes, it's a direct challenge to dualist states. It's a direct challenge to national sovereignty, obviously, and it's a direct challenge to the national constitutional order. If the national constitutional order seeks to see itself as being the supreme source of law in the country, which of course is the general view, and even in the UK with its unwritten constitution, membership of the European Union challenged the central tenet of parliamentary sovereignty, of the unlimited lawmaking power of Parliament, because it was necessary to find a way for Parliament sovereignty to be in some way restrained, so that the UK would indeed act compatibly with European law and would give effect to European law over domestic law, which was a major challenge even for the UK's unwritten constitutional order. So in that way, yes, I would see the EU as unique, as a regional system.
So do you think Brexit is likely to be, rethought at all, or do you think this is something final, in terms of just the assertion of British sovereignty, or something like that?
I mean, I think what we're realizing about Brexit is it's a continuous process. So, I mean, as to whether the UK would formally rejoin, I mean, I would personally hope so, but I'm done with predictions from the experience of the last 10 years. I think what we will see is perhaps a continued kind of struggle. I think, if a Labour government ever takes power, for example, in the UK again, they would want probably to seek a closer relationship with the European Union. You might then get another government coming in which wants to distance the relationship. So I think the relationship will remain one that is embedded in law through the withdrawal treaties, and will be continually, I think, may be continually renegotiated over the next 30, 40 years. As for the longer term future, I have no idea, but European Union law has been retained in the UK, so it will, even though we've left, EU law is still an enormous source of law in the UK, although it's now called EU retained law, and its exact constitutional status remains to be worked out. So even there, where you look like you've had an abrupt reversal, it looks like a kind of aggressive reassertion of national sovereignty over, a global constitutional system or regional constitutional system. It's a more subtle story than that, because European Union law will remain an enormous influence in the UK for the foreseeable future.
Professor Sayo, any comments? Would you have any comments?
Maybe I give a positive example how it can work and what can be a non-binding way of influencing a sovereign country. So in a complicated process regarding Turkey, the European Court of Human Rights decided that a person in detention has the right to counter from the very moment of being detained or arrested. This idea was very much present in France for 100 years, especially among members of the bar, and I guess among many criminals, but I'm not sure about that. And the police always resisted that. And of course, France is France, so the police had the last word. Now, once this judgment was applied to Turkey, and the Turks were ready at that time to follow it, this became a matter of embarrassment for France. It became a major weapon for the bar to push through with what they always wanted to have. And they were successful. So the French law was changed without ever being found in violation of the European Human Rights Convention. So I think there is a non-binding but still normative influence coming from globalization. Again, it can be very selective, it goes through resistance, but there are institutions which are capable of generating at least common principles, if not standards. And I think that is one of the very important elements in this globalization of constitutionalism. So it's not just the binding treaty, it's not just the EU setting for a region what is the law and influencing even the constitution, but there are these more subtle ways. And of course, the UN may have a little bit of that, because again, with the reporting system, you have a certain pressure on states which do not like to be shamed. There is an international prestige element, but I think it's much more important the influence this kind of standard setting or shaming has on domestic constitutional politics, because each country has a public opinion that is divided, and some groups would like to move in one direction, others in a different one, and this becomes an argument, and a very important argument for the legal community and for society at large. So I think this is one way to, or one element of this interaction. Thank you.
So I think this leads into the next question, which I think Professor Stone, you mentioned you might be interested in. We often talk of, as I was saying, even beyond the European Union, of this migration of constitutional ideas, right? Ideas around constitutionalism across borders and across jurisdictions, and they kind of have unpredictable influences in a domestic constitutional system. And there have been, a lot of metaphors that we've used to describe this kind of travel. Sometimes it's been called transplant, sometimes it's been called borrowings. Now it's, migration and, a constitutional dialogue that is supposed to be happening between different jurisdictions. So would you like to comment a little bit about this phenomenon, what you think about it, and then we can also ask Sasayo to speak.
I do think migration is a particularly good metaphor, actually, because it captures the idea that something comes from a place and it always, in a sense, has a memory of that place, but it then becomes something new again in the new place. And I live in a society that you can call an immigrant society or you can call it a settler colony, right? But I certainly feel that all around us all the time, that sort of sense of people having come from a place but making themselves anew in a new place. So, I think that captures a lot of what is happening. And if you think about an idea like proportionality, structured proportionality analysis, certainly there's been no idea that has been more successfully migrated around the world, and yet it becomes something quite new in each place. Australian proportionality resembles not really at all proportionality as it's practiced, for example, in the Federal Constitutional Court of Germany. It's quite a different thing by the time it has migrated all the way to Australia and been taken into a very different judicial culture, a very different form of constitutional review, where we've got diffuse constitutional review through the courts rather than a specialist constitutional court. All of these things, in quite surprising ways, make proportionality analysis something really quite different. So one of the real kind of joys of studying comparative constitutional law is to actually trace this development and understand both the roots of an idea and yet also its local resonance.
I had another example to that of a recent idea that's been propounded by Stephen Gardbaum, who is in fact a British academic, but who's had his entire career, I believe, in the United States. But he's proposed a model of what he calls New Commonwealth Constitutionalism, which he sees as essentially seeing a kind of role for courts in protecting constitutional rights that lies somewhere between the kind of the British and to an extent Australia when it comes to human rights in the absence of a federal Bill of Rights tradition where essentially rights are primarily a legislative matter. The protection of rights is to be achieved through statute primarily or through common law. And on the other hand, the kind of German or US tradition of full-blown constitutional review, also, as I believe practiced in India. And he's kind of located this idea of an intermediate stage, of which the first main example was obviously the Canadian Constitution and the notwithstanding clause, where in theory the legislature could override a decision of the court, not ever used, of course, at the federal level. I believe it has been used at the provincial level a few times in Canada, and there's a lively debate about whether or not it still ever would or could be used. And then he says the UK Human Rights Act, which has been copied by some Australian states at state level, the New Zealand Bill of Rights Act, are all kind of variants of this, where there's an attempt to give stronger protection for rights than you would get merely under kind of traditional common law approaches, but with still leaving, in theory, the final word to the legislature if it wishes to exert itself. But again, as Adrienne was saying, when you look closely, the differences in the scheme can be actually, I think he does successfully trace a kind of common intellectual inspiration for such schemes. But actually, when you look closely at them, the differences, you could argue, are at least as significant, if not more so, as the similarities. If you compare, for example, in particular, the two ends of the spectrum, the powers of the Canadian Supreme Court as compared to the New Zealand courts under the New Zealand Bill of Rights Act, which is the sort of weakest of the models, are remarkable. So it's very interesting. Scholars kind of engage with it and dispute whether or not it's sort of the differences are more significant than in fact the overall similarities. And the final point, I think the whole thing in a sense drew its inspiration from a negative source of influence, which is observers looking at the kind of politicization of the United States Supreme Court as a kind of famous example of an extremely powerful constitutional court. And also the way in which there's been, appalling decisions by the Supreme Court at times in its history, or extremely controversial decisions that effectively can't then be undone through democratic means. So then you end up with this squabble over who shall appoint to the Supreme Court, which has become, as we saw, particularly for a long time, but reaching its apogee under the Trump presidency, becomes the kind of, the defining feature of a president is to get some judges on the Supreme Court. So democracy will still try and have its way, in a sense, but unfortunately, this is probably one of the worst ways you could try and have democratic control in this terrible squabble over who appoints to the court. But I think that was part of the inspiration, actually, the negative example, and countries like Canada and Britain not wanting to have something better than they would have had just under common law, which had proved itself to be kind of very weak, but not wanting to go as far as the United States. Because of the sort of several negative constitutional examples that are well known from that particular kind of system.
Yes, I was just wondering, so migration in a way, especially if it's happening from the global north to the global south, because many of the former colonies and so on didn't have a tradition of democracy and so on, but they looked to these iconic precedents, the US or UK and so on, to the extent that they felt that constitutionalism meant having something like the Westminster model or something like the US Constitution. It was a kind of a conversation stopper. So it didn't let the regional or indigenous ideas develop to the point where it really had enough significance. So I don't know if it had a kind of a chilling effect as well. Just looking at precedents that were already out there, if constitutionalism was so closely associated with these iconic precedents that you couldn't think beyond that and think of constitutions in a different way, which might have been better suited for local conditions.
I think you've just made a really, really good and important point, and that is this process of migration reflects real political and cultural power. And it is the politically and culturally powerful who are influential. And part of our job as scholars is to be very critical about that power dynamic. And you're absolutely right that it is migration from the global north to the global south that has been the dominant dynamic. One of the exciting things about, if you read Ran Herschel's book about cities, for example, is the very possibility that it is the dynamics of the global south that in fact could be really important also for the global, not for the world, including the global north. And I think that's a very, exciting turn for comparative constitutional law scholarship to take. And it's one on which I certainly hope global south scholars will lead. And that global north scholars will be critically attentive to.
Professor Sayo, any comments before we go on to the next question?
I think we have a lot to cover, and we
okay. Okay, I think the next question really is for you, Professor Sayo. So these are about how the question is about judicial references to foreign precedents. How appropriate do you think they are? Because you have this, we always, I talk to my class about this, the Justice Scalia versus Justice Breyer debate about, how democratic is it for you to be looking at, precedents which were developed in a different legal system. The domestic, there is no consensus on, the kind of approach that you have in a foreign country. So are judges justified in looking to foreign jurisdictions when they're deciding, some new case or new issue, which might not have the consensus, from their own populations, from their own countries?
My perspective is very provincial because the European Court of Human Rights has its own area of jurisdiction, 47 countries, but they have a certain legal commitment because they ratified this convention, which refers to some common traditions in its preamble. So there is some ammunition to argue that at least some minimum standards can be developed from what is out in the field. Other countries are not bound by a similar legal obligation. So whatever I say is is difficult to extend. Now, for the 47 countries, and of course the same applies in a very different way to the European Union member states, which are all part of the Human Rights Convention. The development or finding of common traditions is a very complicated matter. And it is, of course, based on precedents of different countries, although in reality what the European Court does most of the time is just positive black letter law and much less a systematic comparative study of the jurisprudence of the state. So cases may be cited, but this is not typical. In the member states of the Union, not because of Union membership, or in many countries that I know because of this European system, the 47, there are very often references to other countries, but I think this is not different from what happens in India and Pakistan in particular, that these are very selective choices. These are not systematic. These are intended to serve a specific argument. They are supportive of what the court concludes. So it is inevitably somewhat biased, even if you see a certain review in many constitutional court judgments of it, it remains selective. I've seen this even at the level of quoting the case law of the European Court of Human Rights. So many constitutional courts in Europe do analyze, they have to, the judgments of the European Court. This applies to the Supreme Court of the United Kingdom as well. They do a decent work, by the way. But other countries, they tend to forget some of the judgments we used to. The court renders are not anymore there. So it is, again, rather selective. That's part of the game. And we should be aware of what is going on. I mean, this is not a theoretical statement, it's just a practical observation that precedents are selected. I guess it happens even when you refer to specific precedents in your domestic system coming from your own constitutional history. Some cases are just not mentioned. And this is even more true when it comes to comparative references in both constitutional and in international bodies. So that's I think, a part of the reality.
If judges tend or select certain jurisdictions and look to foreign precedents, is it possible that because of their unfamiliarity with foreign modes of analysis or the context, there can be some illogical or inconsistent applications of foreign law. Is there a danger of that happening at all?
Well, that's exactly what I was implying, but it's better that you formulate.
Okay. Professor Stone or Professor Phillipson, any comments?
So let me say, I think that is a problem. It's just not an insurmountable one. I think, I can think of instances where, looking at the Australian courts referring to foreign jurisprudence, that they can sometimes forget really critical things like differences in jurisdiction between the courts that can really affect outcomes. But what it requires is just a careful, critical comparativism. It's a very difficult task for judges, and I really believe that on top of all the law of their own country, suddenly they need expertise in the law of other countries and the capacity to compare them. I really think one of the things that scholars need to do is devote themselves to providing some of the research infrastructure that enables courts to make good comparative decisions. I think there just simply is no point in kind of like pulling the shutters down and say we're not looking anywhere else. It denies the reality of the globalized world we're living in. But we also have to be sensitive to the difficult task that we're placing on judges and also on litigants if we're asking litigants to argue in this way. And it's one thing that, as a scholar, I want to take seriously, that the part of what we need to do is provide others with support to understand the comparative enterprise.
May I add something?
Yes, please.
Having those going.
Oh, well, I was just going to agree strongly with what Adrian just said, and particularly the role of academic scholars to try and provide a more systematic and, as it were, cautionary basis for comparativism. In other words, pointing out the possible pitfalls, because when you just leave it purely to litigants and judges, you get the danger of kind of opportunistic comparativism, because obviously counsel who want to win their case will reach, if they're reaching for something, they'll reach for something that is helpful. The judges may reach for things that support what they wanted to do anyway. So that can be very kind of opportunistic and not done with any kind of, not done in a systematic way and not done in a critically reflective way, as Adrian was reminding us, is essential. And that, I think, is where the role of academics can come in to try and provide an architecture or an infrastructure for that to be done in a much more systematic and critical way, with awareness of the dangers of constitutional transplants, because it can happen rather opportunistically and almost sometimes by accident in the course of litigation, because of the fact that counsel just want to win their case, which is their job after all. So they will use anything that they think is useful, and judges may may be receptive to that, especially if it confirms the way they're thinking anyway.
So if I may, and I promise for the other questions, I will not take the time of colleagues. Take the decision of the European Court of Human Rights on abortion in Ireland. It's called ABC versus Ireland. So there is a comparative study indicating that 94% of citizens in this huge space do have access to reproductive services. There are five countries which do not allow that, but one is San Marino, 30,000 people. The other is Malta, I think 300,000. Biggest is Ireland, with all due respect. The ordinary standard of the court is that where there is a European standard, then there is no large margin of appreciation. So from the perspective of comparative studies, I think even a most court-friendly academic will say, yes, there is European consensus, this is an outlier island. So what is doing the court? After having presented impeccable overview of the European scenery, they say, well, but this is a different problem because this is a sensitive matter. And therefore, because it's sensitive, European consensus doesn't apply. So, even where there is compelling empirical evidence, there might be legitimate or less legitimate. I was not part of the composition, so I don't want to burden you or bore you with my take on this, but it is clear that there is a, against the empirical normative power of what emerges from comparative studies, courts just, which may claim that this is relevant, suddenly invent a new normative perspective. So I think we really have to understand that here the comparative study pushes courts to new normative assumptions. And I think this is part of the realities. It's not just that the academia has to be critical of the methodology, which is very poor. Here I can be very open, very poor in this area when applied by courts. But I think criticism shall include the normative aspect. So to what extent is this of normative power? That I think is really part of comparative constitutional law or constitutional studies. Thank you.
Unfortunately, we have 3 minutes left. I don't think we have too many questions from the audience. And the one question that we have is, I think we've pretty much addressed that. So maybe we have time for one last question. I think I can kind of condense 2 questions. And this is more about, comparative constitutional law research. And so you have these methodological approaches that we often talk about, classificatory, historical, normative, etc., functional, contextual, expressivist, and so on. So what would you say is the best, for comparative public law scholars, the best methodological approach? And I know Rand Herschel has a lot of criticism about, problems with case selection and research design as far as comparative public law scholars are concerned. So how do we come up with a methodology that is rigorous enough in this area? And just to end, what do you think would be the value of doing comparative public law research? So is it to arrive at certain universal truths, to improve or reform the quality of one's own constitutional jurisprudence? Is it to get an insight into the experiences of other legal cultures, including non-Western legal cultures, so as to better understand certain notions of, say, equality or consent? These are kind of inherent elements of constitutionalism. So do we get a better understanding of these, normative ideas by doing comparative study? Is it also to, improve the quality or the state of the law in one's own country? So that would be my last question. And I would ask perhaps all 3 of you to briefly comment before we end today. Professor Phillips, would you like to start? Or Professor Stone, would you start? Would you want to start?
I think Professor Stone was just about to speak then, and she's far better qualified than me to speak on this topic, so I'd defer to her.
Excuse me for jumping in. So, look, there is no one comparative constitutional method. There are many research questions that you might ask in the course of studying constitutional law globally, and then you need to make sure that the method that you adopt is the one you need to answer your question. And I think you referred to Rand Herschel's wonderful book, Comparative Matters, where he makes a very strong case for adherence to case selection principles, which is really, really important if you're doing inference-oriented comparison. If you're going to draw a kind of causative inference from your study, then you need to make sure that you've selected cases in ways that can support that. And that's very valuable to bring those social science principles into comparative constitutional law when you're doing that kind of comparative constitutional law. But you may not be, right? You may be doing something that's more normative. So one really important thing to do, and my scholarship tends to take this moment, is actually to use comparison as a way of uncovering competing normative ideas about constitutional principles, right? So, and if you're doing that, not trying to draw a causative influence, but to try and understand moral fundamentals, then you might draw case selection principles in quite different ways. And so it's really important to look at that. That was an incredibly significant intervention in the field. But I do think that there are actually more than one method that we ought to be considering as we do our work. And the question is, how do you answer your question? And if your question requires you to look comparatively, then you think through the method as to how it is that you do it. So I don't think there's one method because there are too many interesting questions.
Right. And just a brief comment. So what would you say is the value of doing comparative public law research? Because sometimes we think, every country is so different, how do we even start to compare? It's so contextual, and you have to look at the social and political histories to even understand where all these public law arrangements, where they come from. So is there a purpose to doing comparative work? Is it something, we can look to understand normative concepts better, to draw lessons for our own jurisprudence? What would you say would be the value?
There are many purposes, right? You can do all of them. It may help you construct your own constitutional law more intelligently, precisely because it might dispel a false sense of necessity by understanding that things actually can be done differently, and see that what you think is necessary is not necessary. That's just one thing it might do. It may help you in constitutional design. It may help you kind of unpick different moral visions of constitutionalism. And it may help you draw causative inferences about what causes success and failure of certain kinds of institutions. They're all really different questions. They're all really good questions, and they're all really good reasons to do comparative constitutional law. I really think that calling the field comparative constitutional studies, and I want to pay tribute here to the foundation director of the centre that I direct, which was Cheryl Saunders. She founded it in 1988, and she called it the Centre for Comparative Constitutional Studies because she understood the breadth of this field. And so I would encourage everybody to think of it as a really plural field in that way.
Any further comments before we end the session today?
Just to harshly second that, yes. I think
Sure,
multiple
absolutely.
different purposes can be served by comparative public law. You might be wanting to solve a particular problem that's arisen in your own country, looking for ideas elsewhere. You might be wanting to uncover historical or normative roots that are common to several countries or differ sharply. I think, yes, open-mindedness to that. It's a very rich. There are several rich possibilities for which you might engage in it.
Thank you so much. I think we are, unfortunately, there are so many other questions, but I think we have reached the end of this session. Just a 1 hour session is absolutely not enough to address all these questions. But thank you so much, all the panelists, for taking the time and to be with us, Professor Sayo, Professor Stone, Professor Phillipson. I know that it's different time zones for all of you, so it was quite a task to kind of fit all of you in together. I just hope we have another chance where we can, meet again, maybe for a more extended session, now that we've connected with you. But thank you so much again, and it's been a wonderful session, and thank you for all the wonderful observations. And I think we have to end the session today, and I hope we keep in touch and we can have another round at some point in the future. Thank you so much.
Thank you to all the distinguished speakers, and thank you also to Professor Sarbani Sen. So audience, please stay connected. Our next session will start soon, which will be Law and Other Things, Widening the Disciplinary Scope of Law. Thank you, everyone. We are on. We are on.
Thank you, Sridhar. Hello all. Welcome to another session of this conference, the Global Law School Summit. The panel for today that we will be having right now is called Law and Other Things, Widening the Disciplinary Scope of Law. And we have an excellent panel, quite a unique panel in many ways, that will be helping us think through this particular topic. What is remarkable about this panel are two things. One is that all our scholars who are scheduled to speak for our panel, who are on our panel, are from the Global South. A very rare occasion that we have two scholars from Africa and two from Asia, and and a couple, and one from Latin America as well, who will be there, and all of the speakers who are supposed to be on a panel have been dean of a law school, or are currently dean, or have been in the past. So that leads us to interesting possibilities in our conversation today. So the theme, like I said, is interdisciplinarity, and that has been a kind of a buzzword in legal academia for a long time now. It has risen rapidly as a trend in the last few decades in various aspects of legal education in India, which is where I'm located. This has led to an overhaul of the legal curriculum in the last 3.5 decades, with the introduction of the 5-year program starting in 1987, which made it mandatory to study non-law subjects as part of the law school, and that has become the norm at some level all over the country now. So this has led to interesting challenges to legal education, and both legal research and pedagogy has had to adapt to these changes. And simultaneously, there's been a massive kind of a renaissance in scholarship around law in social sciences and humanities as well, besides, of course, in the law schools. So, while obviously there has been a kind of a interdisciplinary revolution of sorts, which has been going on in the field of legal education in the last 25, 30 years, it would be interesting to reflect on whether it has actually permeated the realm of professional legal education itself, which is in most of the world continues to be the main thrust of legal academia. So it would be interesting to reflect on how and if interdisciplinary has been able to find a place in professional legal education, or even to think about whether there should be a need to distinguish between professional legal education and academic legal education, whether they have to be taught differently. In any case, these are all interesting questions which our distinguished panel for today will help us discuss. And I'll just introduce them briefly. I'll just be brief with introduction. They're all distinguished scholars, but the first person who I would introduce is Professor Dr. Amita Dhanda, who is currently a Professor Emerita at the Nalsa University of Law in Hyderabad. She's a very well-known scholar who's, generations of law students have learned from her directly and indirectly from her scholarship as well as her pedagogy. So we're excited to have her. We also have Professor Hartini Sarippan, who's the Dean of Faculty of Law at the University Technology Mara in Malaysia. So these are the two Asian scholars we have. Then we have Professor Lynn Briggs, who is currently the acting executive director at the Nelson Mandela School of Law in the city formerly known as Port Elizabeth in South Africa. I am not familiar. I couldn't catch on the new name. So Professor Briggs is also here, and there are two other scholars who are supposed to join us. I will just introduce them when and if they're able to join. They may not be able to join because of time issues, etc. So let's start without any further ado, because we have limited time. We have just an hour to discuss this issue. So I will start with a kind of an open-ended question with regard to: do you think, firstly, there has been a rise of interdisciplinarity in legal education, and particularly in your specific journeys as a law student, as a law professor, as a legal academic, and as deans in your respective places? Do you see that a kind of a rise in interdisciplinarity in the field of law in general? So we can start with whoever wants to speak first. I think Professor Dhanda, you're muted. Sorry.
Yeah. No, I was just saying, I think that the moderator will have to work that one out. We are not raising hands.
Oh, sorry. No, that's fine. That's fine. That's perfectly fine. And so please. Yeah.
I suppose maybe alphabetically, I do work out as the name-wise I am, and I can begin.
Yes, please do.
So I would say, Anuj, it will depend upon you're asking the question for where. Like in India, interdisciplinarity is definitely on the rise when it comes to the national law schools. Basically, because of these being 5-year programs, your social science courses and your law courses are, are meant to run together. Different schools have worked it out in various ways, that you have maybe the first 2 years you spend much more on social science and humanities, and the next 3 years then it becomes like a pre-law, post-law kind of thing. But progressively, at least I can say for Nalsar, and I think it's happened other places too, that you've started running them like parallel tracks, so it's not like you study your social science courses in the first 2 years and then you don't visit them again. We have, like, at least in our school, you can't get your degree if over and above the mandatory social science courses, you do at least 9 credits worth of seminar courses in social sciences. Also, kind of with the course, we had brought in a whole range of visiting electives, getting people from all disciplines to come and teach. So consequently, you've enhanced the engagement of legal education with other disciplines and what they have to say on issues which concern the law, but which don't only concern the law. So one is stressing on the fact that this doesn't only concern the law. So if I was to make it as a statement, I would say that yes, in these law schools, it has increased. I don't think in traditional legal education that much of a dramatic change has happened.
Mr. Biggs.
Okay, well, the situation in South Africa, hello to the other panelists. The situation in South Africa has also had quite a historical development because of the history of South Africa itself. And in the early 2000s, the Bachelor of Laws degree legal education was actually under a lot of scrutiny and criticism from the profession. So there was a complete overhaul of the Bachelor of Laws degree. And what happened was that the various law deans from various the public universities got together and drafted a qualification standard for the law degree, and that was introduced in 2015, and then soon after, in 2016, there was a national review of all the law schools and of all the law degrees that were offered and legal education offered across the country. And of course, we all had to apply for reaccreditation in terms of the reaccreditation criteria from our Council of Higher Education, as well as our Qualifications Authority, and in line with the standard. And this qualification standard clearly it required that the law degrees, we also have 2 different versions. We have a 3-year, whether it is a social sciences or even a humanities type of degree, followed by a 2-year degree and a combination. But that is more in the minority of the type of degrees, law degrees that are offered across the universities. The bulk of the degree or students that do it, we have a 4-year law degree. And the 4-year law degree is obviously more popular because of the funding issues related to a 5-year degree. But be that as it may, the standard required that the other disciplines other than law had to be incorporated into the law degree, because in order to provide the additional scope and to introduce these students to different disciplines other than just law. And then from the national review, it became quite evident that, law, that was the way it was taught and the way in which the various institutions were approaching the legal education was almost very much like in only law, and the students needed their horizons to be broadened and introduced to other disciplines. So there's a 2-fold approach. There's the combination of a law and another degree kind of approach, and then there's the the 4-year degree that where we are required to introduce more disciplines into the degree itself.
Thank you. Professor Saripan, do you want to reflect on this as well?
Yeah, thank you so much, Professor Anuj. Hello, Professor Biggs, Professor Danda. Greetings from Malaysia. Well, in Malaysia, I think I agree with the rest of the two panelists that we are witnessing the transformation of the direction of the legal profession. And I think I am very, very excited to also mention here that part of the factors or the main factors of this transformation is the fact that we are moving from what we call content-based to skill-based as far as the legal education is concerned. In fact, it is not just for legal education. We are speaking about the vision of the Ministry of Higher Education in Malaysia. So the content-based curriculum has very much influence on the tools and the techniques that the law schools choose in order to deliver our curriculum. As far as the legal profession is concerned, it is very interesting to note that in Malaysia, we are quite traditional in the sense that the professional body only recognizes the 4-year program of our LLB, that is the bachelor degree in law, and the integration of law and other disciplines are not recognized to practice in Malaysia. So as much as the rise of interdisciplinarity in Malaysia, I think, you know, it is safe to say that we embrace and we acknowledge the importance of social sciences, you know, into our field or into legal education. But what we are emphasizing is basically how to use social science technique as our tool and technique in terms of teaching pedagogy to deliver our legal content more effectively. It's just, I think, you know, there's a famous saying says, we are playing in the playing old game in the new playground. So I think that is what we are doing in Malaysia. In terms of the legal content and the emphasis of the doctrinal or what we call black and letter technique, you know, of delivering our legal education, it's very much, you know, traditional in a sense that we are focusing on the understanding of rules and laws. But more importantly, I am saying that how the law school in Malaysia incorporate social sciences techniques and skills into our curriculum. And we may not translate it into a program as I think all law schools in Malaysia in terms of the law program, since our professional body only recognizes our LLB. So in terms of the program, we only have one program that is Bachelor of Law Honors. So law and other fields are actually basically, not to say that they are not important, they are important, but graduates cannot actually practice. So law school, in the public law school, we are focusing on our LLB program, but taking into account how we want to incorporate other skills, referring to a variety of models that we have in order to produce high quality law graduates. You know, we have Delta model, M model, you know, we have so many models producing good high quality law graduates, we are incorporating all that because we embrace the fact that mastering the basic legal knowledge per se is not enough for our graduates to shine in the industry. So the feedback that we receive from our partners, particularly our industry partners, they want more. They want more than just criminal procedure. They want more than just civil procedure. They want more than just traditional legal knowledge or legal body of knowledge. So these skills, I can name few. We talk about entrepreneurial skill. We talk about definitely communication skills, and all these require deep understanding and a mastery of other fields. And I think incorporating some techniques that we borrow from other fields would definitely benefit us in the legal education.
Thank you. Maybe we could reflect also on, do you see this changes as an unqualified good? Do you see any dangers with this kind of rise of interdisciplinarity, or do you see it as overall a positive development? And it's because all of you obviously have had long careers as students, as practitioners, or as pedagogues, and now as institutional as former or current deans. It would be interesting to hear your opinions on this question. So we start with you, Professor Danda.
Okay. See, if I was to process what my other two colleagues had to say, and especially what Harthini was speaking about just now, wherein whilst you are stressing on the fact of the need for studying and being aware of things other than the law, you're still saying that foundationally you stay with a kind of a strong legal base. And I think to some extent that's what Lynn was also saying. At least the way I comprehended the presentation, the way I was just reminded of one of the comments which Professor Upendra Bakshi tends to make in relation to students from the national law schools. They're saying they don't know the law. So it's like one of the things that he says that, because they have gone peregrinating to other disciplines, they can give you a spiel on a number of things, and they have an opinion on everything, but they don't know law. So now, one way of processing it, of course, is that is if you're going to operationalize law necessarily as a positivist enterprise, something which has its own, its own way of studying, which you need to be knowing. So one of the difficulties somewhere, Anuj, which I think we all need to be reflecting on, and I would somewhere, let's say, like much more in the recent past, I have started to appreciate the importance of positivism. To be saying that when you speak in terms of a rule of law regime, and when you say in very black letter terms, this is the law and this is not the law, are there situations and circumstances where you want that kind of definiteness, where you want that kind of, because there's this possibility of opening up the world and understanding the discipline of law in very many layers. And I definitely, for me, I've been like a committed interdisciplinarian through my entire career. And I don't think I'm abandoning that in any which way. And I also do think that bringing in that extra version or getting people to understand that the law doesn't just fall from the sky. There are a whole range of other interconnections that you need to make if you need to have a rounded understanding of the law. So that would be my pro-interdisciplinarity, proposition, let's say. And but unqualified good, that's the part that you asked. And for that, I'm saying I deliberately started the other way. One of the difficulties that you run in with sometimes, or maybe often, is that when you go the interdisciplinary route, you land up losing your way in your own discipline. And that's what I meant by not knowing the law. It's not like there isn't critique inside the law. And there's also the necessity of making those connections. What we basically want is that our students should have both. You have this kind of a, like a vice-like grip of the law, but you also have a contextual understanding of that law. That context gets created for you from other disciplines. But exactly how that knowledge that you get from the other disciplines, you need to navigate in the law. You need to have a pakka kind of knowledge of the law also. And I think that's wherein I would somewhere want to say, if I say it as unqualified good, then we don't ask so many questions on, okay, with how much depth do we teach the law? Do we only teach legislations, or do we also get students to look at rules, regulations, notifications? Do we look at the entire, there's the entire gamut of, do we say that what happens in Parliament or the entire extrinsic aids, how much attention should be given to them or not? But that entire legal process has a great bearing on how you understand the law. And if you don't have it, I know for a fact as a teacher of interpretation, that if you have that extrinsic aids ka knowledge, the manner in that will influence how you read a statute or how you read a judgment is extremely important. And I'm a little bit kind of wary on that count, that if we go too far, okay, let me make a different point, just make a little bit of a step back and say that along with interdisciplinarity, I think why it's extremely important to have a grounded legal knowledge is the whole area of intradisciplinarity. You can't be saying I'm only a right here specialist, that I only know constitutional, not even constitutional law, that actually constitutional law is one of those areas of law which you can't do any area of law without knowing constitutional law. It's as simple as that. But saying I'm only an IP person, or I'm only a corporate law person, and not seeing these interconnections between other areas of law, to say, okay, and that's wherein, for why I would want interdisciplinarity is, if somebody comes and tells me I'm only a court law person, and you don't know that corporations are the new state, and you don't understand the interconnections between how corporate law operates in gender, or between corporate law and caste, then your understanding of corporate law itself is very superficial and hollow. On the other side, if I only know the gender and corporate law thing, and I know the caste and other things, but I don't really know my legal marvels, then I'm not going to be able to really use all of that, the point which Hartini was making, that the corporate law firms want people to have deeper knowledge and stuff. The reason is, if you want to make first principle arguments, if you want to be getting people to traverse new arenas, it's not going to come necessarily from only the law. That wider background knowledge or foundational knowledge comes in from other disciplines, and it's important. So I'm in for wanting these to be melded in some manner. So, and interdisciplinarity in a manner wherein law doesn't, or at least law people or law students or law teachers don't lose their grounding in their own discipline altogether. That is problematic. That is problematic. I don't know whether I've satisfactorily answered your question.
No, that was really very, very interesting, and I'm quite sympathetic to your point of view on this. Mr. Biggs, you want to also reflect on this?
I think I could agree with Professor Danda in that regard as well, in the sense that the whole reasoning behind the overall of the LLB qualification in South Africa was because of the very narrow approach that the students, the kind of knowledge that they came out of, with graduating with, was very law specific. And even within, as you say, with the interest perspective is within the qualification, the students tend to look at the various subjects or modules or in silos, that they couldn't, go from the basics of the law of contract and incorporate, the other aspects of the law of contract, like with regard to a specific contract, in the corporate field, so they would look at things in silos. So it was a twofold and manyfold actually approach to really look at each institution was given that ability to, well, what are we going to do to our qualification to make it relevant and current and adaptive and flexible, so that you can produce knowledge for graduates that can be flexible in their careers. So that and in order to do that, the students need to be exposed to more than just the law. And very interestingly, the preamble of the LLB qualification standard specifically, I'm going to just read a little sentence here for you. It says, it's necessary to have the appropriate legal education as the foundation to foster the ideals of transformative constitutionalism. Legal education as a public good should be responsive to the needs of the economy, the legal profession, and broader society. It must produce skilled graduates who are critical thinkers and enlightened citizens with a profound understanding of the impact of the Constitution on the development of the law and advancing the course of social justice in South Africa. Moreover, the law graduate must be equipped to discharge his or her social and professional duties ethically. And therefore, higher education must also be responsive to globalization and ever-evolving information technology. So it's a lot broader. You want you want to expose and ensure that the content is a lot broader and gives students a broad range of skills, so that it's not just necessarily strictly law bound, because we utilize the law and we turn to the law, and it's in a contextually based situation. So the students would need the ability to practically and consider the law in that particular context, and to ensure that the education that they have is relevant, and that it's current. So it's for that reason as well that the qualification, as I indicated previously, to say that we have the basic discipline of the law, the fundamentals of the discipline of law need to be incorporated in the qualification. But together with that, some other aspects of other disciplines need also to be incorporated, so that the graduates do have the ability to problem solve, make use of the skills that they've acquired from the other disciplines as well, in the context in which they are then going to be utilizing the law to solve those particular problems. So it gave us all the opportunity to really reflect on our qualification and take it through a process that we could look at it from all angles, and develop something where hopefully, because we've only just introduced our new qualification in 2020, the graduates are more well-rounded and have the skills and the competencies to adapt and transfer their skills and knowledge, depending on the context, the environment, the whatever areas within which they are functioning. So yes, it is important, vitally important for the different disciplines to be incorporated. I do want to pose a question to you as the moderator, though, is the understanding of actually what interdisciplinarity actually means. Because I think we might all have a different interpretation of what it actually means and the context within which it operates. But I'm going to stop there and hand over to back to you.
Thank you, Professor Biggs. I would definitely like to react to Professor Biggs' question, but perhaps we should let Professor Sariban also reflect first, and then we will to continue the conversation.
Thank you, Professor Anuj. Yeah, in fact, I am very thrilled to hear from Professor Danda and Professor Biggs, the fact that you emphasize on the importance of the foundation and the basics. And that is, I think, all of us agree today based on our responses that approaching law using social science techniques, for example, should not be diluting or annulling the specific legal contents or the fundamentals of law amongst our law students. And I think that is also the reason why we are still playing the old game in the new playground. The new playground is where we understand this generation. We know that there are more innovative tools of teaching delivery without compromising the fundamental of the old game, that is to produce high quality law graduates that definitely equipped with a very strong legal content. And I think I would also like to add one more point here, that it is I think it is also relevant to include the understanding of how we actually bridge what is the law in the book and the law in action. Because bridging the law in the book and the law in action would, to me, would really reflect what it takes, to really produce law graduates that are able to translate what is the law in the book to the law in reality. Because, all of us, we know that when they actually go to the real battle outside after their graduation, there are things that they may not found during their law schools. And this is where law schools are important, to give them the right tools. And I think to relate back to our direction here in Malaysia, that skill-based rather than content-based. Not to say that we dilute the legal content. Legal contents are there, but we embrace and acknowledge the fact that when we give them the right skills, and that is definitely start with the right foundation, the right substantive law and procedural law, and our accreditation body. I think, one of the main reasons for not recognizing programs that integrate law and other fields is because of this reason. They don't want to dilute the fundamental legal body in our program, and for that only LLB or the what we call the 4-year law programs in Malaysia are recognized to practice. And I think, another point is, Professor Danda mentioned just now, when we expose too much to, other disciplines, there's a danger that our students might fail to see the real picture. They might be seeing the big picture, but eventually there's a danger of not seeing the real and the right picture, and eventually forget what is basically the core competencies that are required, for them to master during, their years in the law school. So I think interdisciplinarity should enhance the legal skills. And that's why I always like that Delta model, where substantive law or the law part or the legal skill is a foundation forming the triangle, whereas other skills are actually, at the sides of this. We are talking about interpersonal skills, that I think is very important. But the bottom line is that we need to again go back to the purpose of training our law graduates. That is to make sure their ability to bridge what is in the book and what is in action. I think I will stop there first, Professor Anuj. Yeah.
Thank you for this, Harpa. So yeah, this was very interesting. I think a good question was asked because what do I mean by interdisciplinarity at all to begin with, right? That we didn't do the definition of move at all, and we just moved straight into like in media res, and just move straight to the. So yeah, I think perhaps the classic definition of of this kind of question of counterposing legal approaches to the professional legal approach to study of law versus the kind of social scientific way of thinking of law, probably by Max Weber, sociologist Max Weber, writing about it 100 years back, where he talked about as a legal scholar, you're interested in the classic sense. Obviously, now it's become all very, things have changed a lot since then. But the kind of pure sense, the kind of ideal type, would be in the sense of, you're trying to figure the normative dimension of law, right? In that the focus of a legal scholar, and a social scientific scholar would perhaps be more interested in the kind of the sociological element, in the sense of how it is intersecting with the world as it is, and the kind of, this is of course highly simplistic at some level, but just to kind of place it there. Now, what has happened is that over the last many decades, especially in this country, which I'm most familiar with, in India, we've had institutional attempts to actually successful in the sense of institutionally being able to do an overhaul of attempts at professional legal education being significantly forced to have a significant chunk of social science courses as part of getting a degree in as a practicing lawyer. While in some ways successful in the sense that, as Professor Dhanda said, it started with the national law schools. Now it's pretty much all over the place. It's almost difficult to find a good 3-year degree, and the old 3-year LLB degree, which used to be the norm, say 35 years back. It's become more and more difficult to find a decent, to the extent that, interestingly, the place we started the interdisciplinary approach, the so-called interdisciplinary approach, the National Law School Bangalore, is actually now introducing a 3-year LLB, which will be interesting to see how they go about it. But I just wanted. I'm actually very sympathetic to the view that President Handa and Artini also just mentioned. All that I see the challenge of interdisciplinarity also in terms of, I think of them as two different languages of thinking about law, and the problem is that people think of it often as a kind of easy way out. It's really a much harder way to study law, to be able to do both. You try to learn two languages as opposed to one. It's actually much tougher. But somehow the way, because of there's a kind of too simplistic way of doing the kind of shortcut way of towards interdisciplinarity, which I personally have experienced in various capacities, which worries me about this turn actually at some level. Because often I feel like the students neither know law nor sociology or economics or political science or any of the science. So that worries me, because I feel like, that's Professor Dhanda said, these students, including Professor Bakshi, that that they don't seem to know much law beyond a point. They're good at talking and they're good at being able to hold forth, but do they actually understand? And that's something I feel particularly, because there's kind of a normative world behind law also, right? So this, I'm obviously most familiar with India, and here there's a kind of wholesale experimentation with the legal system that's been going on for many years now in all kinds of ways, in which somehow very often departments certain fundamentals, certain normative fundamentals of the legal system, the common law legal system that is prevalent here, and somehow I don't see the legal either legal academia or legal professionals or the legal complex, broadly speaking, react in any kind of. They seem to be open to all kinds of experimentation, which is very interesting at some level, and perhaps that's where, this is a long discussion, I think we should move on to, but I think this is partly connected to the question, the fact that all of South Africa, Malaysia, and India are all, of course, ex-colonies ex-British colonies, and the British model of legal education is very specific. It's a very minimalist model at some level, right? It's, of course, you could do a 1-year degree and you can qualify with practical experience. And of course, you parallelly had research-based legal education, which is also there, but that's for training legal academics largely. So the legacy of that, and how, as Hartini also mentioned in the context of Malaysia, how, and I think even in India, however we may claim of the triumph of interdisciplinarity, actually at some level, the profession has very little patience beyond the point with all this. So I just thought, maybe we could reflect on the aspect of what do you think, locating your respective country or the context you're most familiar with, the experience of interdisciplinarity in the context of the global phenomenon and global a la British or American kind of the global north. How do you locate that, in the conversation of interdisciplinarity in your respective countries with that in the global north? Yes. Professor Dhanda.
I just wanted to, for a moment, Anuj, seek your indulgence and make a little bit of a response to what my colleagues had to say after me.
Yes, please.
And possibly that will also kind of, sort of flow into the question you're raising now. What I was saying basically was that in our foray or entering into the whole arena of interdisciplinarity, we somewhere kind of made this, I would say, a little bit of an error. Even in the all national law schools, you still have true-born traditional black letter law teachers who only teach that. And at the same time, you also have teachers who try to, place the law in context and teach it from there. You also have a third body of people who just teach the context and don't really then spend as much time comprehending that there is an entire technical critique of the law. In making that first proposition, what I was saying is this, that if you land up just doing only context, or you just kind of only teach black letter, both of those are problematic. So for us, the challenge is, how do we do the melding? And as Hartini was speaking, I was reminded of, a few years back, I was almost consumed by, there's this book by Edmund Kahn, where he talks in terms of the sense of injustice. And in his wanting to settle up what the legal curriculum should be, he talks in terms of developing in students what he calls a sense of injustice. That is, you should be able to see when injustice happens, that this is unjust. And then what you need to be then devising and working out is how you're going to get people to move from this place of injustice to justice. And in doing that, in traversing that area, you need to have good, hard legal, Harini's he's been using the term skills. I wouldn't say necessarily skills, but at least, all of those techniques that you require to know, how do you read a legal text? How do you, if you want to be questioning a specific situation, how do you argue for it that the way of reading the text or what you read in the text is addressing the injustice before you? And Kahn also speaks in terms of just not informing the head, but also informing the heart. To say that because if you are not going to develop people's emotional intelligence, that sense is not going to come. It's not about the reasoning of justice. It's talking in terms of developing a sense of injustice. And I felt that was the other component one was trying to stress on. So when we speak in terms of we've had journalists and, what should I say, people who dramatists and, people who work on the stage, entire performance people coming in and talking to students, because you felt sometimes a well-performed play on critical issues of justice and injustice takes the student way further than however many Supreme Court judgments you may teach them. So now the question is then, okay, this is the objective you wish to achieve. In reaching that objective, what are the places that you need to traverse? So when we speak in terms of okay, what is the kind of theorizing which is coming in from the global north, or the fact that we are living in this globalized, liberalized world, whatever. I somewhere do feel that at no point of time should we be in the whole realm of scholarship, and especially legal scholarship, which is divorced from asking questions of whether this is fair or unfair. Is it just or is unjust? Is the entire, if I'm studying international law, I mean, why do we all go for the third world approach to international law? Because we are being told that if you are going to study, and if you're only going to, that's where in a little bit I wanted to make it clear that, Hartini, when you were saying, I did want this to be understood that when we teach them also what is in the law, we need to be saying that this entire realm of international law, which is being handed out to you, has been constructed by a certain power system. And if you are not going to be cognizant of the fact that there is a power system behind it, which causes for these international law norms to come, then you're going to uncritically sort of engage with it. So to develop that critical, let's say that critical sense in our own students, we have to constantly do these both. Sometimes what happens is, because the whole technical realm of law is also so huge, and be so overwhelming, and to be sort of saying, oh, you need to be like masters in it, we forget all the things which have happened behind that, what has caused for this to become the norm. And I think for me, the entry point for interdisciplinarity primarily comes from there. So whatever may be the context, whether the context is you're looking at the injustice which is happening because of the manner in which global forces are operating, or the injustice which is happening because of the way in which, say, caste or color or religion is happening, you need to be constantly telling your students, how do you get the two to converge? You can't do one without the other. If you have that sense of injustice, if you really have developed it well for them, then you also need them sort of impart to them the skills by which they can get people out of that injustice and to a fairer and a more just sort of place. That's how I would address the question with which you were starting this particular segment of the discussion. But I also wanted us, I think in some way or the other, at least I can definitely speak for, as somebody who's at all points of time come to law by looking at what other disciplines or other sectors or other people have to say about the law. At the same time, one is enough of a proponent of the whole autopoietic way of looking at things, that if the law people themselves don't see that there is something not right, all the critique can come from every other discipline, but change will not happen in the law. For that to happen, it's important that critical understanding has to be cultivated within the discipline of law, within the institutions of law. So I think for us, this business of looking at law and other things has to be a two-way traffic on a constant basis. The other thing also is, as law people, we are very comfortable in pronouncing on the whole world. But we make it very, very difficult for people from other disciplines to pronounce on the law. So if critique has to happen of the law, it necessarily has to come, in the first instance, from law people. That's how I see it. But I've always found, you and I want to speak about whether it's architecture, whether it's engineering, whether it's anything, as a law person or psychology or philosophy, you have an opinion, you can say it. But if anyone from any of the other disciplines wants to have a critical understanding of law, you will turn around and tell them, no, but you don't understand legal language. This is not how the law operates. And you constantly terrorize everybody else. So making it more difficult to critique what happens within the, whether it's the legal institutions or the creation of legal norms. And I would sort of say that how we look at the global north too, if critique has to be coming in, we have to firstly comprehend what are the power dimensions which cause that.
Thank you. Professor Biggs, you want to take it?
That's thank you, Professor Danda. That was very, very interesting. But to go back to the question about the global north and the influences in with regard to South Africa, and with regard to legal education, as I've mentioned, the national review of the LLB in 2016, 2017 at the same time was taking quite important, there were major activities and taking place in the country at the same time. You know, with regard to the whole decolonization, the call for decolonization of legal education, that was really got going, you know. In South Africa. It was earlier, much earlier, but, you know, there were, you know, lots of emphasis in 2015 with, you know, the lots of different calls and, you know, for the fall of various you know, roads must fall and those kind of things that happened, as well as then, you know, the request and the deep discussions and regarding the decolonization of not only the legal education and the law curricula, but the entire higher education, you know, system. So those discussions have been taking place throughout the institutions in South Africa, and has been, you know, at the forefront of many a conference and research. And then at the same time as that, while that was happening, we then started with the fees must fall situation, and in South Africa as well. So we constantly needing to reflect and consider whether our legal education is relevant for the society within which we live in South Africa, and to ensure that it is that the way the legal education and the law degrees and the graduates that we have will be able to provide that service to community. You know, to identify the injustices of everybody within, you know, and to ensure that the values of our Constitution are forefront of the mind of the legal scholar or the law graduate that we're producing. The values, those intricate values, those need to be. It's part of, you know, they need to be installed in the students, and of course with our university namesake being Nelson Mandela, we also, you know, it's part of our teachings and our you know, practices and behaviors is to live the values of Nelson Mandela as well. So we hold forefront the Constitution and the values of the Constitution, and at the same time, it's about being a Mandela. So in order to do that, as you say, Professor Danda, that, you know, the graduates, when they need to know what those injustices are in order to ensure that those injustices are eradicated. And as you know, and that is part of our role as the teachers, to constantly evaluate and critique and review and reflect upon our teachings against the past and the histories, but historical perspective, but also the context in which the current situation and where we are going, to ensure that, you know, yes, we are a university on the tip of the African continent, the bottom tip of the African continent, the global south, taking all of those aspects into consideration. And if we go right back to the very first question is, you know, is it important for interdisciplinarity within legal education? Yes. We've all said that students need to know what is going on in other disciplines in order for them to properly be of service to the communities within which they will be practicing as legal practitioners. Thanks.
Thank you. Professor Saripan, you want to go next?
Yeah, thank you, Professor Anuj. I think I would like to add by sharing, you know, our practice or our initiatives at the university here. One of the focuses of UITM is to make sure that our graduates are able to practice not just locally in Malaysia, but also abroad. So we have put efforts in bringing in experts around the world, either as our consultants and from time to time we receive feedbacks in order to make sure our curriculum is current, and more importantly, our curriculum is sufficient or even more than sufficient to prepare our graduates, to practice globally. So yes, we do locate ourselves within the global practice. And speaking about to what extent this interdisciplinarity is taken into account in locating ourselves, I think, that is again goes back to what is the purpose of having this interdisciplinarity. Professor Biggs, asked a very important question to you, Prof. Anuj, as to what is this? And I think from our discussion, it can be understood from two perspectives. One, either we are talking about specific programs marrying two fields, law and other fields, or another spectrum that I believe, that has become our direction also, is to what extent these tools and techniques are being infused in order to enhance the quality of law graduates. And that is where UITM, that is where, I am going into our discussion. And I think I would also like to add the fact that another important emphasis of UITM is to be able to share our expertise and our legal knowledge with community. And this is where social science research technique is seen to be one of the tools that is used to make sure that our legal knowledge is able to reach out to the community. So we have been discussing here in Malaysia about how translational research will be able to be used as a tool for law teachers or even law students to reach out to community and to really translate our legal knowledge into practice and make sure that this will be able to be shared with community. So this is also one of the focuses of the higher education ministries in Malaysia, that is to make sure that that is to make sure how university will be able to touch the community and share knowledge with the community. And speaking from the law school, I think, the Malaysian law schools in general, when we have discussions amongst the law deans in Malaysia, we agree that some of the techniques in other fields may be used in order to achieve these objectives. For certain reasons, for example, community, there's a challenge for community to understand legal jargons, and all that. So translational research technique is also used in order to make sure that whatever legal contents can be shared with the community. And I think another point that I would like to also share here is how we at UITM equip our students with the other skills, because we at the faculty, we have 162 hours, and these hours are mainly, for the legal body traditional law subjects. So we have to think of the ways of incorporating, other skills and tools in order for our students to shine, especially when they graduate. So what we do here is to incorporate law experts and law professionals with us in order to become the mentors for our students throughout the years of their studies in UiTM. So eventually they get mentoring from these law professionals, and they are basically judges, experienced lawyers, and these experts or these industry players will whisper, to them and tell them what are the things, other than law that needs to be made aware, to these students before their graduation. So I think that's from me. Thank you.
Thank you, Professor Arpan. And I think we are out of time now, so we will conclude now. And I just want to thank you all for sharing the kind of interesting pedagogical experiments going on in your parts of the world and reflecting on them critically. I think this was an interesting conversation for all of us. Thank you all. Thank you, Professor Arpan. Thank you, Professor Tanda, and thank you, Professor Biggs. Oh.
Thank you. Thank you to all the distinguished speakers and also to the moderator. Thank you very much. And audience, please stay connected. Our next session is the Lawyers Colloquium, Global Lawyering, Globalization of Legal Profession. We'll start at 4:15 Indian Standard Time. Thank you very much.
Thank you for inviting me.
Good evening to our friends in India. Good morning to our friends in the US, and good afternoon to our friends in Europe. It is such a pleasure to welcome all of you to the second day of the Global Law School Summit. And we are entering into a new thematic session entitled Global Lawyering, Globalization of Legal Profession. We have with us an absolutely fantastic group of leaders in the world of law. Let me begin by introducing Ms. Pallavi Shroff, Managing Partner, Shardul Amachand Mangaldas and Company. We have with us Mr. Sudhir Mishra, the founder and Managing Partner, Trust Legal. We will be having with us very shortly Mr. Nishit Desai, founder, Nishit Desai Associates, Mr. Chris Parsons, Chairman, India Practice, Herbert Smith Freehills, United Kingdom, and Mr. Gautam Narasimhan, partner, Allen Overy, Singapore. Let me begin by briefly introducing the theme of this afternoon's panel discussion. For all professions, globalization had brought in responsibilities as professions were called upon to become part of global governance, the management of the affairs of the nascent global society. Global society being postmodernist in character, a larger level of reconstruction of society was required, which prompted professions to extraordinarily reimagine the socio-political and legal order. For professions, this era was a post-professionalism, that is, a rediscovery of professional values, approaches, and indeed frameworks. In this session, we tell the story of legal professions' self-transformation and its role in transforming the world. Particularly in the context of legal profession, there was a large-scale segmentation of legal functions. This is due to the exponential increase in the number of global deals and transactions at all levels, which demanded regulation and control. This development coincided with the loss of exclusivity of professions over subject matters which were previously within the exclusive remit and competency of professions. Such a loss has prompted professions to remark their disciplinary and functional perimeters, which is in addition to a new inclusivity professions have espoused. At the proverbial surface, this has manifested in the form of the rise of limited liability partnership firms, which have legal professionals with specialist and super specialist knowledge and skills. They offer transnational services of global standards. The work is characterized by speed, efficiency, and optimal outcomes, all of which are essential for the sustenance of global society. The ecosystem of work these firms have been able to create attract large number of young law graduates to become part of their function. This primarily owes to the sense of participation in the global process and opportunities to contribute to that process law firms have been able to create. Lawyering, too, has had its own transformations. There was a dramatic change in the nature of disputes before the courts as society had moved on to a new mode of production which created and defined new social relations. There was also a broadening of public consciousness at various levels, primarily because of the public concern that a global society, which is the neoliberal society, might overdo in pursuit of capital, and it is the civil society's responsibility to exert control over global forces. For example, the rise of environmental and constitutional consciousness and the increasing awareness and invocation of public rights are all sound examples. In the wake of these transformations, lawyers reorganized their knowledge and skills. There was a spirit of renewalism and reorganization which enabled them to steer the legal profession through these challenges. The globalization of legal profession has changed not only its institutional framework, but also its patterns of function. The profession today is highly dynamic, requiring upskilling and mastery over new areas of law. This has prompted law schools also to understand the needs of the profession and redefine their academic curriculum and pedagogy. The legal profession's collective response to globalization has to be seen in its totality for a better understanding and appreciation of its role and functions. I hope this colloquium will fulfill that ambition. Let me move to some of the questions that we intend to discuss during the course of this panel discussion. My first question is to Ms. Pallavi Shroff. First off, let us build a perspective to look at the transformation of legal profession. Now, we understand that rather than a gradual transformation, these changes were triggered by a big bang. That is the liberalization of Indian economy in India in response to global demands. This was a political step. So my question to you is, what was the initial response of the legal profession to these changes? How did the professional reorganization start? Over to you, Pallavi. Hi, Nishant, and hi, Chris. Good to see you.
Hi, Raj. Nice to see you too. Nice to see Pallavi, Sudhir, and Nish as well.
So, Raj, if I just step back into 1991 and what was the legal profession then, and then from then on, we can see what changes have happened. So 1991 was essentially a time when you had a few corporate lawyers, but essentially when you were a lawyer, you were a litigating lawyer, you went to court every day, and you argued your matters. Either there was a dichotomy in the legal bar, which was the senior counsel and the junior counsel, or you had solicitors and non-solicitors, which of course luckily that got sort of abolished way early. So you still had the litigation perspective. A client approached you when you essentially the client had a problem. Now I need to go to court, I need to see a lawyer. With the liberalization and the inward flow of funds and the complex structuring, because we still have the foreign exchange laws, I think a whole new gamut of laws had opened up. And that is when the real corporate practice in India started. So some, I think, firms were earlier, if I may say, off the block and realizing this opportunity of a whole new practice of laws, if I may call that. Not that it didn't exist before, but it was very restricted and very limited. And now there was a whole vast scope of how do you structure investments into India, how do you navigate Indian laws, what are the regulatory issues, and things like that. So that was the first change, the realization that a whole new perspective was going to be required. So the acquisition of that knowledge became quite important, if you ask me, at that stage. And how did firms do it? Firms worked together with the foreign law firms as, maybe co-counsel, maybe just a support role initially till they became sort of competent in their own right to handle the deals. Or you got people who were working overseas, decided to come back and work, so they brought that knowledge of how the global world runs and what these deals meant. And you started understanding the client needs. So even though I think that era started with chartered accountants still trying to run corporate deals and with their limited perspective on legal issues, I think that was the first beginning that happened, and slowly realized that they need lawyers rather than just chartered accountants for legal issues. I think the second evolution, if I may look at within the period, the second phase, if I could call, is typically when sole proprietorships became part. Even if you had to do a very large dispute, or you had a corporate matter and you needed to work together with, you did a due diligence, you needed 5, 7, 10 people. So that's when the second phase, I think, of the growth of the concept of a firm. We had just the old firms, and then the new firms sort of started in 1991. As the size of the firms increased, I think people realized that they needed to sort of do different things with the aspirations of the people inside the firm. So then the focus started happening on governance of the firms and the challenges that firms met as they grew larger. And it said that with every 100 people that you add in any organization, you need a new set of, you need to review the existing rules. Will the same rules get you any further or not? So I think that was a whole phase too. You started specializations. You had done enough power projects, so to have a better depth of knowledge of power projects. Part privatization started happening, so that depth of knowledge came in. You had understanding needs of young and the aspirations of younger partners. More partners were brought into the firm. So that was that whole second phase of growth. The third phase of growth was probably some mergers and amalgamations within the firms itself, acquisition of talent. Talent became more mobile than it was ever. And I think in more recent times, I think I've seen, more I think 3 or 4 aspects which are quite important recent in the last 3, 4, 5 years. One is Indian law firms have started opening office overseas. Nishit has had an office for a long time. We've seen Khaitan and Cyril Amarchand also opening offices. So that's been one big phenomenon. I think second is the adoption of technology. One fine morning, we were all working from home instead of going to offices. Huge, huge change. So I think the phase is now for looking at technology, law technology and innovation. Then the concept of growth of governance and management of organization of your law firms. I think, and how even senior counsel, for example, will organize themselves. And the fourth important point is the onset of social media. And all of this has impacted the practice of law, if I could say that.
Thank you very much, Pallavi, for setting the tone for this discussion. I think you've really given a historical and contemporary evolution of the growth of legal profession in India and the new challenges that have emerged. Let me quickly move to Chris Parsons. Chris, you've been a long-term both observer and participant in the Indian saga, both having an insider-outsider look at what is working, what isn't, and how it has changed. So my question to you is that how did a law firm like you and somebody like you in particular see this kind of inherent contradiction that was constantly playing in the Indian arena? At one level, there was a strong appetite to see that opening up happening from 1991. At another level, there were signs of protectionism at multiple levels, including entry of law firms into India. How did your own firm and you position yourself in this Indian context?
Great, thank you, Raj. Look, as you said, I think Pallavi set the scene perfectly and actually covered a lot of the very radical changes that have occurred within the legal profession since the significant liberalization of the economy. And what hasn't happened, of course, is that there hasn't been the liberalization of legal practice within India. And so the way in which international firms have looked to play a role, I guess, are in two most obvious ways. One is in relation to inbound transactions into India. So whether that's a strategic acquisition by a Facebook or a Google, or whether it's a private capital transaction from a SoftBank or a KKR or Goldman. So that's the inbound transaction. And then on the outbound transaction, Indian companies doing things around the world. And you know, perhaps one of the most famous being Tata Motors buying Jaguar Land Rover, for example. Now, on both of those sorts of deals, there is often what I might refer to as a sort of an umbrella agreement, an umbrella transaction. And that umbrella agreement may be subject to English law. And so both on the inbound and on the outbound, there is a role for international law firms to advise on English law. We do not advise on Indian law. So that's the way in which we have looked to get involved. That's why we have, along with a number of our peer group firms, very strong India desks. So we're looking after Indian clients doing things outside of India and international clients doing things inside of India. And then in relation to both of those aspects, we would need to work alongside our friends in India because both of those will have Indian law aspects, particularly on the inbound arrangements. That will be subject to Indian law and Indian regulations. So we will work with our friends in those circumstances.
Thank you, Chris. Thank you very much for that. Let me move to Nishit. Nishit, of course, I want to shift gears a bit and talk with you a little bit about reorganization of legal profession. I mean, as we know, there has been a reorganization of legal profession, which has happened at a macro level through adoption of new values and goals. Whereas at the micro level, there has been emphasis on redesigning the patterns and styles of function. Your own firm is a very good example. Now, this obviously includes adoption of a governance model by inculcating a larger sense of accountability, both individual and collective, professional ethics and teamwork. So my question to you is that, how did you achieve this in your own firm and functional domains? I've heard you passionately talking about the Wachtell-Lipton model. And how did that come about within the context of what was seen to be an Indian law firm which had a global ambition?
Oh, thank you so much, Raj. Sorry, I'm sorry, I was on mute. Okay. So thank you, first of all, Raj, for inviting me here. And Pallavi, Grace, I think you have made very good points and recall the history that we have all seen. We have seen almost all now, right? Right from even 1973 when I finished my law. I'm not that old, by the way, but we have seen all how action controls operated and then got liberalized for NRIs, and then 1991 comes, one set of liberalization, 2000 comes, and then Y2K, and then there are other things coming up. So as I see, what happened for me personally, because you asked me that question, was that it was in 1984, I got some opportunity to do corporate philosophy study for one of the large multinationals in the US. Most of my work grew in the US because my specialization was international tax and globalization. So 99% of clients were there. But when in 84, I got the opportunity. And then from there, I learned certain interesting aspects of organizational behavior. And then I looked at over 100 law firms. I was suggested to set up a law firm. I was solo, like I'm a counsel. And, and then I had to, I said, let me also try to learn from other people. So I studied histories of law firms, great law firms we had in UK, US, etc. So 4.5 years I studied law firms, their behavior, their ethos, principles, and stuff like that. And I was a small, so idea was to have look at what could I learn from others. So Wachtell-Lipton, one of the examples that struck me, and that was very good. But imitation is best form of appreciation. That's one thing. But I said, if Wachtell-Lipton is there, then I have to do something myself as well. And apart from the traditional kind of work which we all were doing at that point of time, and most of the work on Wall Street, etc. What happened was, I said, what can I do different, and how can I add value to the existing firms? Because we have all the firms, Amachan and everyone else, little company at that point of time will not. So if I can be complementary, I'm a supporting star at the end of the day, right? I'm a small person. So I said, let me do one thing. Most of them were looking at as was mentioned, the regular practice. So I said, they can look back with pride about 100 years, and of course they are very dynamic now as well. But then let me look to the future and build practice on that. So combining with Wachtell-Lipton model, I thought, let me build practice based on the future of law. And the philosophy came up that every new technology, every new business model, every new social, political, economic development brings along with it a new strategic, legal, tax, or ethical issues. So started doing research, because I've been researcher anyway. So I started doing research and looking at new technologies coming over a period of next 3, 5, 10, 15, 20 years from now, and see what will be future legal, strategic, tax, ethical issues that will be coming up. I started writing papers and stuff like that. So when actual time comes, then I'm somewhat ready to meet those challenges. That has been the major model. So it's a mix of different law firms. Every law firm has its own beauty. And I've tried to see, let me find out some beauty spots, and at the same time create some new model. So that is how I set up law firm in 1919. And luckily 1990, 91, India opened up. And whatever I learned in the US or elsewhere in the world suddenly became handy. That gave me a little edge. And then came 2000, which gave me a little further edge in terms of technology, understanding and stuff like that. And fortunately, what happened, I couldn't hire too many people. So I got people from engineering, from medicine, from MBAs. So assimilated all those talent, but everyone had to do law, okay? And because legal professional ethics are very important. So that's how the practice grew. So generation Now we believe, and I just close here, it has been almost 30 years, 1990 at a law firm. And so at that time, we had to teach people on commercial law because that was the element that was missing, and the global project management. But now I think that we have, all of us have done reasonably all right, And next phase that I'm looking at is that we have to create next generation of socially responsible lawyers. And that is what I'm currently paying a little more attention to, because there is no end to growing big, no end to doing everything. We have to continue adding the value. But I think both we have to combine and have a holistic growth. So next phase that I am looking at is, and based on that, organizational models have to change. And I don't want to get into details at this point in time. Happy to do some other time. But this is just a little perspective to, and I think Pallavi and Nick and everybody talked. Chris spoke very well. So I don't want to add too much, but I thought
Thank
this.
you. Thank you, Nishit, for those very valuable comments. We will come back and revisit some of those issues. Gautam, let me come to you. Now, of course, you are a bit of a poster boy for the globalization of legal profession. You went to law school in India and then studied at NYU Law School and then got yourself admitted to New York Bar. And now you are in Singapore working for a British law firm. In a way, can we say that this is a kind of a quintessential model that is going to become more and more common in the future? Is this what the future of globalization of legal profession is going to be, where geography and the original jurisdiction in which a person has earned his or her law degree is going to matter less and less, and more the opportunities for one to work in different jurisdiction is going to emerge, particularly in the context of international law firms?
Thank you, Raj, and thank you very much for having me participate in this panel, and privileged to be here. It's a very interesting question. I mean, there are two parts to this. One is, the sort of internationalization of sort of a practitioner's, opportunities in a sense, because I obviously, went to the National Law School, graduated in 2000, and then literally my journey has been eastbound in a sense. From New York, after spending a few months working there, I spent 6 years in London and then came to Singapore. And I guess, firstly on the mobility across different sort of jurisdictions, unfortunately, I don't think it's gotten easier, right? If anything, I think, the localization requirements have gotten more. So, for instance, the ease of foreign practitioners qualifying into the UK, which was, I had to literally do half an exam to become a UK solicitor. That's now become a lot more of a involved process. I got, again, when Singapore opened up the ability for foreign qualified lawyers to become locally qualified, I got locally qualified, but that also has become tougher. So in some sense, I think law as a profession, whether it's transactional law or particularly litigation, doesn't lend itself for ease of mobility, when you compare it to some of our clients, like investment banks, PE funds, etc., right? There, the practitioners just chase the opportunity, whereas for us, local qualifications is still a challenge. But having said that, if you ask me, is sort of, chasing opportunities across different parts of the world, is that going to become some kind of a, normal course for particularly, Indian law students, Indian lawyers looking to work overseas? I think I would hope that is the case, right? I think, in my instance, I went to the US. Obviously, had the good fortune of getting to know you in the US there, and then obviously London, around 2000 to 21 years ago, the British firms, the English firms, were opening up their training contracts for, Indian law students. That was a good opportunity. But also the London as a financial center really literally exploded at that time, the whole private equity leverage finance market, which is an area that I follow. That's grown. And then in some ways that opportunity brought me to Singapore. So it's the internationalization of our client pool, the products that we work in. That's, that has grown now. I feel Asia is an opportunity that is a real opportunity for all law firms, right? The scale of that opportunity is depends on each law firm and the appetite they have. But growth of places like Singapore, if you look at Singapore and how it's grown over the last, say, 15 years, today it houses probably the largest number of new arbitrations anywhere in the world. The SEAC takes in, of which India constitutes more than 50% of all new arbitrations. So I'd say that my journey has been a journey which has in some ways also tracked the growth of some of these financial hubs like Hong Kong and Singapore. I hope it's a blueprint. I hope it's something that continues on. But I believe that opportunities, my own personal view is places like Singapore will grow because there is, the sort of the hub status is growing, and that could be, opportunities. Who knows? I mean, later on in the future, you could have, I'd see Dubai could be a potential sort of, they're investing in growing that as a hub as well. So there could be other places that come up, not just New York and London.
Great. Thank you so much, Gautam, for that. Sudhir, let me now move to you because we've heard the story and evolution of major Indian and British law firms here, the Indian law firms going global and the British law firms themselves coming into other parts of the world. Now, of course, your own journey is about what I call the new age entrepreneurial law firm. So my question to you is that what is the scope and the, a future of these entrepreneurial law firms like yours, which have emerged, which are in many ways creating new sets of opportunities for a range of bright young working professionals in law who want to aspire to, pursue excellence in legal profession, but need not necessarily be doing that working in a large law firm. What is it that makes the opportunities that a firm like yours offers quite unique in the Indian context?
Thank you, Professor Raj, and good evening to everybody. I primarily did environment climate change for 21 years, and first 10 years was mostly in national park wildlife sanctuaries. And that was a time we didn't have even a website, or we were not supposed to have a website. That culture started. But something called LinkedIn in last 5-6 years has changed the entire legal landscape for most of our small or modest law firms, which are very sector specific or focused in one single specialty. And what LinkedIn has done, and because Palvi also mentioned the power of the social media and the digital landscape, which has completely changed, that LinkedIn gives you a platform which basically leapfrogging the website space. So whatever practice you are doing, whatever updates you are doing, and I'm doing it since 2011-12, never thought it will become an engine of growth for a firm. So suppose there's a World Plastic Conference is happening in Bologna in Italy. Somebody approaches you because they think you are an environmental lawyer in India. You go and participate in that conference. And from there, a multinational Indian company hires you because they know that you are an environmental lawyer in India. So that's the power of this whole digital media which has happened. Now you are not beating the Bar Council rules also, you're not changing them. At the same time, when you become a mainstream firm or you try to become a mainstream firm, now we do virtually everything. We have a large media broadcasting law practice. We realize that most of our work is happening because you are leapfrogging certain stages. You are being judged. You cannot just write something on your website or say something and that will be seen in isolation. Your transactions are being weighted in real time. All your updates are coming in real time. There are multiple platforms which all is getting focused, and that is keeping you open to probe. So if Nishit Desai has a great website and great research papers are coming there, others will have to go and compete with that. They will have to learn the kind of standards which are being set up. And that is a real open world. At the same time, there are 4 big audit firms which have no restrictions on them. They have 10,000, 12,000 people working for them. You have Facebooks, we have Walmart, we have Amazon coming to India. their general counsels have 100, 150 people working under them. So globalization has already happened. I'm a door tenant in an important UK chamber, which has given the Attorney General of United Kingdom right now. There are a lot of reports which we prepare here on climate change are being seen there as well now. Because they want to know what we are doing about a particular river, about a particular thing. And back then in 1970s, Rajkumar, when MC Mehta started his environmental litigation, he started with river pollution. All that came from Europe. Now the same reverse thing is happening from India to other parts. So basically it all has got mixed up and the opportunities are in real time. It's like a OTT revolution. The same thing is happening. The last point is we are at a very critical stage, like the Chitrahar when we used to see in 1983-84, one TV channel, one Wednesday you will have music. Similarly, artificially you have closed the legal profession. So you can, when you go to an International Bar Association conference, you know that in 2010 or 11 in Vancouver, there'll be 10 firms or 12 firms. Today, there are 70 firms which are going to South Korea when it happened physically for the last time in 2019. So you are artificially stopping it. Eventually, you'll have to open it because others are taking advantage, whether it's Bangladesh, Sri Lanka, Dubai, whosoever. So there we are at the crossroads.
Okay. Thank you very much, Sudhir. Well, that's a fantastic first round of discussion. For all those who are watching us live on Facebook and YouTube, do send in your questions. I'll be taking up those questions with our panelists. Let me move to Pallavi. Pallavi, so having established this evolution, I want to ask you a question about the concept of an advocate. Now, of course, while I don't mean to say that it's no longer court-centered, there have been new sites of functioning for a lawyer, can we draw a distinction between the functioning of legal professionals in these different and varied sites? Sudhir talked about the kind of the big four involved in a bit of law. Then there are, of course, in-house legal counsel who are doing legal practice. Then, of course, there are lawyers and law firm partners like you. So do you think that this diversity of the legal profession transforms the identity of legal professionals? Does everyone feel being an advocate as the functional phenomenology of advocates as we classically understood, or for that matter, appreciate?
I think over the last 20, 25 years, I think there has been a really phenomenal change. And that's not to say that if you are a corporate lawyer, you are not a lawyer or an advocate. So all of us who pass out from with a law degree, we enroll at the bar, some after giving, the younger people after giving exam, we just sort of enrolled at the bar. Some of us practice law in the traditional form, which is go to court. There is a dispute. Your client comes to you and you take the matter to court or to arbitration or to a regulatory authority. So that's one aspect. But today what has happened is even if you are a disputes lawyer, you find that your client is coming to you way ahead of a dispute starting. When the client feels that there is something that's not right from starting from, if it's a contractual dispute on a contract, managing a contract, say, of a large infrastructure potential dispute. What do I write? How do I write? Should I respond or not? So you start thinking strategy right from the time the problem sort of begins. So I think that is a huge difference that we are seeing. So even pre-contractual, pre-disputes, actually, you start coming in and playing a role. On the corporate side, as Chris mentioned, the transactions are both inbound and outbound. They are private equity, they're strategic, they're venture capital. You can classify them and slice them and dice them in different ways. And a lot of them have got very sophisticated. You know, there are nuances to each of these games. And I think having done so many deals, people have now sort of learned how to deal with these things, you know. Certainly in the beginning, we all worked with the foreign law firm. We've done deals with Herbert Smith and with A&O and other firms. But so that's how we all got into the game. And if you think that these guys don't practice law, I think we are mistaken. They have to do as much research on positions of law before they can take, because somebody is going to challenge them and they're going to have to answer why that position. Take particularly things like reps and warranties or indemnities. You know, they are not going to be able to negotiate their positions well enough unless they have actually researched this and know enough about the law. So I think they both do the law. I think the third aspect that we all need to look at are the in-house law, in-house legal departments. A lot of the bigger corporations have massive in-house legal departments. You know, sometimes the larger global firms will have 100 lawyers in their legal department, which are sometimes bigger than law firms in India or many of the other countries. So I think, how good are they? But they have to, under Indian law, of course, they suspend their license to practice. So traditionally, they're not practicing, but they have internal clients whom they advise. They are also expected to know the law. And finally, the one sort of group that I understand a little less is the LPOs. You know, there I have my own doubts. How much of law do they practice? Because what goes to them is something that's more routine. It's business process outsourcing, or the process outsourcing, anything that can be done in a repetitive manner by use of technology or other things. So I'm not sure much about them, whether they feel they're practicing, but in any of the other forms, I think at the base end of it, I think you still practice law and you get the feeling that you are practicing law.
Thank you very much, Pallavi. That was a fascinating set of responses and reflections about the nature and the contours of the legal profession. Let me move to Chris. Now, Chris, one of the things that has motivated many people to enter into law itself was the fact that law is a means of social change. The classic notions of law being a public interest, the pursuit of public interest is the larger focus on the role of lawyers. Now, corporate law firms generally, particularly in the US and maybe in other parts of the world, have used the pro bono framework for promoting this particular aspect. Do you see that the globalization of legal profession, as lawyers tend to work in multiple jurisdictions, the possibility to continue to be committed to these social causes, pro bono or otherwise, has the potential to be diminished? The public interest aspect of the role of a lawyer, does it run the risk of it being undermined, not just in corporate law firm settings, but even otherwise?
Yeah, look, thanks, Raj. So just a few observations in relation to that, and I'll try and be as candid as possible. I guess the first observation is that, and I'm sort of really speaking to the students who I hope are listening into this, 99% of what we do day to day is not about social change. And I certainly know that when I was at university, I had some, dreams that the lawyers were about being part of society and helping society to change in some way. And so if that's a dream that others have, I'd like to disabuse them of that for the most part. What we do, whether it's dispute resolution, whether it's banking and financing, whether it's corporate, whether it's competition law, etc. These are about meeting client needs, and so it's not really about social change in the classic sense. So that's the first point. The second point is that the way in which we meet needs, two needs really. One is, I think, a perfectly legitimate need that a major organization should play a responsible role in the world, that they do that through various pro bono and sort of diversity initiatives within the law firm itself. And increasingly, international law firms allow the people that work within them to actually spend quite a lot of time on some projects that they may be passionate about. And so that's a point about the firm being responsible, but I think there's also a really important point that if we are to meet the aspirations of junior people coming into the law, we need to find ways in which they feel that not only are they earning a very good living, in terms of the law, but they can also contribute in other ways. And they do that through what I would call sort of extracurricular activities rather than through the thrust of the day-to-day mandates. All of that said, I think India is fascinating in this respect because we've all seen that the Supreme Court is rather more creative in India than it is in a number of other jurisdictions. And I'm thinking of some of the decisions made by the Supreme Court in telecoms or in coal allocation, for example. And judges, I think, have looked to step into what they've regarded as something of a lacuna in the governance of India and thought that, look, if government is not going to step in and provide guidance, rules, regulations, and laws to deal with this, then we, the Supreme Court, will do that. So to the extent that there are law firms like those with Pallavi's firm or Sudhir's firm, etc., who are active in that area, then I can see that that is something, and Nishit's firm as well, of course, that is something where you could be saying that you're involved in something of social importance. And so I think India is an interesting melting pot in that respect, and probably more so than a number of other jurisdictions.
Thank you very much, Chris. That's fantastic. And I think the law and policy element is something that our courts have grappled a lot, and many of which has a potential bearing on the public interest that we talked about earlier. Nishit, over to you. Listen, Nishit, you are, of course, you have time and again told us that you are not only running a law firm, but a university. The global transformation demands newer skills and knowledge from legal professions. That is due to the reason that transactions and functions have become global in nature, a quite natural outcome of globalization and the social integration. Now, this has brought about a new approach towards skilling, continuing legal education, and professional development of knowledge. So my question to you is that what ought to be the new generation of skilling methods when it comes to continuing legal education that happens within a law firm? And what is your message to law schools when it comes to creating the ecosystem for which knowledge and learning is a continuous process, and one experience helps them to move into the other in a seamless manner?
So once again, I think wonderful, exposition by Pallavi and Chris and everybody. But as far as continuing education is concerned, your question, in our firm, every single morning we have continuing education, 9 to 10. Everyone needs to attend, including myself. Okay, that is non-negotiable. Rest of the day, what you do, I'm not too much worried. But now, from that continuing education that happens, we have to understand that the ecosystem is now moving to have roles of different other factors. For example, role of innovation. How do you make your people creative? Okay, how do you make them? Just to give you a perspective in the context of information age. It started with data age. You had all the data initially. That was the one thing. When you organize data, it becomes information. When you interpret information, it becomes knowledge. And when you add experience to knowledge, it is wisdom. So we are somewhere at the cusp of information and knowledge. So information is becoming free and all the. But one sideways that came up is between information age and knowledge age, the creative age, which was not originally envisaged. So now everything goes on to innovation. And I think even in our profession, you must have seen that there is increased importance of innovation. So I think this is what we need to teach people, how to think creatively, how to build innovations and everything that we do. Everybody is doing it, we are not the only one. Everybody is doing it, but I think that pace is to accelerate, and the whole ecosystem for creating this innovative, mindset has to be inculcated. Second role is as lawyers will be of being thought leaders. Okay, we are so far used to address this advice will be probably this. Okay, we are so far we used to advise this. Sorry for the echo. Sorry, no problem. So I'm saying that, until recently we used to advise based on what law exists. Now we have to do visualization as to what law is likely to be. So merely advising based on the fact that today this is the law, you read it and advise on these, I think those days are not gone actually, they coexist with the thought leadership in our own way we'll have to do that. Next will be role of AI and technology. A lot of work that we are doing will become automated, machine age again, and of course use of technology that is becoming very critical. In fact, one other thing that law firms have to imbibe now is to put in a lot of security system. I was sitting with about 20 managing partners yesterday, and one thing that was coming up was that has become a minimum standard. So if the audit, the actual technology audit, client information, security system, all those things are taking a lot of importance. A role of ethics, of course, I just alluded to because that is what is going to be the next driver, as I can see. And one other thing that evolution I see is convergence of business law with human rights. I think that is what I know modern day slavery, for example, and the other kind of thing that we talk about. I think those issues will become more important. So those who understand both sides will, work around. I already talked about the future technology and other. I don't want to go in. And as far as the firms are concerned, more and more firms will become global. And globalization is different from internationalization. Internationalization having offices in different places. But to me, globalization is a matter of mindset. So, you'll be able to do a lot more, just as Sudhir mentioned, others mentioned, that simple website. You can be still global. You can reach out to the world, unlike earlier days. So I think this global mindset is learn something good. All the foreign law firms taught us very interesting principles in 90s. First of all, talk about how do you compete? How do you manage global projects? How do you do other things? So you learn from them and create and put in place your own processes. So globalization, art of globalization, we'll have to learn how to go in different countries, culture assimilation, tax laws in those countries, and immigration. Immigration, in my view, has been the biggest impediment to professional services organization, globalization. It is immigration restrictions are the worst form of human rights protectionism and human rights violation. Because we are building those territory. We are human, we are animals. We can go anywhere in the world, right? So I think this is my little pinch at the end of the day, but not. But
Thank you
I'm
very
very
much,
much
Rishi.
against this immigration regulations, and I hope if other countries open up, our lawyers will go out and do a lot of things together.
Thank you, Nishit. Thank you so much for that. Gautam, before I get into questions, so there are many questions that are coming up, and I'm conscious of the time. Gautam, if there is anything this pandemic has taught us is that the natural sense of resilience that both organizations, institutions are able to adapt to new situations. So my question to you is that uh, do our law firms in general, but maybe your firm in particular, do you think there are practices that you have adapted and adopted during the pandemic? Some of them will be carried forward in the post-pandemic world. Are there learnings, particularly what we ended up doing during this time? Can it be translated and transferred to a post-pandemic world, or that we will redraw and pretty much go back to old ways?
Raj, I think the one thing there's a lot of known unknowns about the pandemic because everything evolves every day, right? But I think one thing all of us, at least in ANO, we all agree is that when we have offices, in the last count, I think we have more than 34 different offices in different parts of the world, in every continent per se, other than South Africa, South America. We will definitely, the way we work is going to be different. Once, if and when things go back to normalcy at a number of levels. One is the concept of remote working. Yep, that's here to stay. I think this has been in an unfortunate but, you know, I'd say a test case for how our, you know, infrastructure can hold up and how lawyers can work, you know, outside sort of our customary concept of how we thought we should. I mean, I started my career sharing an office, you know, because that was the old sort of, you know, training contract concept where you sit with your supervisor, right? Now, in the last 2 years, you know, we've rolled out the same number of trainees through this, but everyone's done this virtually. The whole training program has happened virtually. Now I'll come to sort of that aspect separately. But from a pure business continuity point of view, I think there's a lot of learnings from how we've learned to work through the pandemic, one of which is the ability to work remotely. Now that's particularly relevant for people who work out of Asia, right? People, for instance, working out of Singapore and Hong Kong. Part of our DNA of working here was to get on a plane and go and meet clients, because Singapore is a hub. You know, you have to go to Jakarta, you come to Mumbai, go to Hong Kong, etc. In the last 2 years, nobody in my office has done a single business trip, but we've had, you know, a very productive and successful year. Deals have come in. Have we had, therefore, I think, you know, if you look at sort of just the raw data that's coming out of international law firms, most law firms have actually financially done very well over the last 18 months, right? Leaving aside the business opportunities with clients, I think the, you know, sort of the people have responded well, and there have been a lot of good learnings from it. One of which is, I think you can sort of meaningfully do a transaction virtually, right? So I think that is here to stay. I think if you look at, and I can only speak for my firm on this, and we have globally, you know, announced that we will be reducing, for instance, our office footprints all over the world, right? We don't need such big offices, because that, again, from a purely, and again, you know, one of the things, I mean, as a segue to, you know, Chris mentioned about sort of, you asked Chris about the ethical aspect of what we do. I think one of the things that is a very real issue for law firms is, you know, especially in light of some of the ESG changes that are happening to the world, you know, some of the clients that we historically worked with are themselves moving out of, you know, some sectors which, you know, from a reputational point of view, from an ethical point of view, for instance, fossil fuels, coal, etc. You know, those are sectors that a lot of industry participants are coming out, and a lot of, you know, law firms now, and including students who are applying to law firms, are asking the same question of law firms, saying, will you actually service clients who are in areas that, you know, for instance, you know, you know, with this whole sort of the environmental summit that's happened, you know, a lot of financial institutions have come out and said they don't want to be, you know, doing these kind of transactions anymore, right? They want to be more environmentally friendly. And that's, again, you know, if you look at it from the impact of the pandemic, is we are traveling less. We are reducing our office footprint. There's been a lot of sort of, I'd say, you know, some, you know, probably not planned, but positive effects coming out of that. Now, I think those things will continue, the remote working, flexible working concepts will. However, I'll tell you the one thing that we are very concerned about is the point I think Nishit mentioned earlier is, you know, learning is a big part of what we do, right? Because we are, in a way, in the knowledge industry, right? People come to us for advice, and that can, you know, the ability to train junior lawyers, the ability to have these kind of really knowledge sharing sessions, the ability to have sort of a team based approach, that suffers if you only work virtually. That's, again, been something that all of us agree. So I'd say that we will, you know, have some kind of a hybrid model, but, you know, the concept of learning and team-based work at, you know, working, that shouldn't suffer as a consequence of some of the practices that has happened through the pandemic. And those, I think, will be something that we'll look at carefully when things go back to normalcy.
Thank you, Gautam, for that. Sudhir, quickly, since you have been a pioneer in the environment and social and governance type of work, as you can imagine, worldwide, increasingly ESG is becoming a major area of legal practice. European companies and corporations are suddenly talking about sustainability in a very big way. Law firms are reimagining their own role. How do you see this providing a new area of legal practice within India. Because we, of course, know that we need a huge mindset change among our corporations, companies, business enterprises, regulators, and the larger ecosystem. Can the law firms lead the way to create a more responsible, way of conducting business through sharper focus on ESG?
Raj, before I reply to that, just one point on that entire feudalism slavery part, because see, we have a lot of law students who are listening to this. So one of the areas we really need to improve is the soft skills as lawyers, as law students. And when I say soft skills, two major issues which India suffers on the both laughter index, we are one of the lowest in the world. And trust issues also, we are one of the lowest in the world. These are the two major things. And why I'm saying this, because as lawyer, you need both of them really. You need to have a sense of humor. We are too rigid about it. We are absolutely, nobody talks about it. And when I do a show and I bring lawyers now and we just talk about what kavita you read and what music you listen to, it's one area we need to invest. So that's one. The second thing is fundamental changes. When I was doing law, law was a last refuge in 1997, 98. Today, 10 years back, bureaucrats, doctors, engineers, their children used to do law. Today, politicians' children are doing law. And they don't want to become only lawyers, senior advocates and judges. They want to own law firms. So now the owning of law firm is a new culture which has happened, which shows that there is a lot of potential for thousands of young law students who are coming out of it. Having said that, on ESG, again, it's a fundamental DNA change you have to do. I'm just reversing the NDA. You have to do fundamental DNA change. When I do my environmental practice, I have an ecosystem. Because I'm an environmentalist first, then I think about climate in a very different manner. So I work with TERI, Indian Institute of Forest Management, ex-members of National Green Tribunal. Like you do a corporate deal, you have your bankers, you have your auditors, you have an ecosystem. So for doing environmental law practice, you can't do just a litigation advisory, or if you are taking a pharmaceutical company, you just can't be looking at a term sheet in a detached manner. You have to feel the flora and fauna. You have to hear the voice of the bird. So unless you go in the skin of the game, it would be difficult.
Thank you, Sudhir, for that. Well, we are almost coming to the end. I have one last question to each one of you. The same question. Pallavi, now we are, of course, talking about the globalization of legal profession. If I were to ask you a bit of a blue sky thinking about the future, what do you think is going to be some of the big implications of technology, including artificial intelligence and robotics and machine learning, on the way legal profession is going to be structured for the next couple of decades, and what should lawyers and law firms do to be adaptable to that change that is inevitable? You need to unmute yourself, Pallavi. You need to unmute yourself, Pallavi. That's the most important line of the pandemic.
Okay. So, sorry. Well, I don't think I can, I follow Richard Susskind as much as to see what is the future of law. But what I can see is two things. Technology, adapting to, use of technology, adoption of technology, fine-tuning technology is going to be very, very key for the sustenance of any law firm that's growing, wants to grow, or even remain in the same place that they are in. For a couple of reasons. The pandemic has taught us that we can work from anywhere in the world and we can get deals done, as Gautam just mentioned. The last year has been an eye-opener because one fine morning, all of us started working from home. And we did things that we could never have imagined or dreamt of. And all our firms did billions of dollars of deals, all getting onto Zoom calls through the day and through the night. Financing deals happened, huge deals, IBC deals happened. A whole lot of things kept happening. So I think, and that was all because all of us probably invested in technology in a very big way and continued to invest in technology through the years. And the way I see the use of technology is it is more facilitative
than substitutive. It's not going to substitute the human mind. It will make things very simple for you, make you do things better, faster, more efficiently. Today, any case, clients are demanding more for less. So if you want to give your quality service, you want to give the client what he needs in a far more effective way, I think adoption of technology is important. I think the second thing which Chris touched upon is our social obligations. And today, a lot of younger people are actually asking us, what are your CSR activities? What is the pro bono work that you do? Will I get an opportunity to do something? If I have a proposal, will the management of the firm look at it? And how can we do it? So to that extent, we all have to change what we think at one point of time was not very useful expenditure is going to become over the years. Because I have a number of people in my firm who are constantly asking us, what can we do? Can I do this? Can I do that? So I think that is also going to be a very important thing. And the third thing which I did want to mention in the context of what others have mentioned is learning. I think, Gautam, you rightly said learning, training, knowledge, the one-on-one thing, that's not going to be possible because flexi working, partially working from the office is here to stay. We cannot wish it away much as we may want to, which if you are thinking the traditional way, we all have to accept that the future is going to be flexi working. You want to come in 2 days a week? I don't think we should expect our people actually to come in all 5 days in a week or 6 days in a week to the office. People have been efficient from working from home. Let them work from wherever they want to be. So long as if they are needed, they are available to you at the times that you need them. And I think therefore in that context, training and growing people, the one-on-one communications that people, seniors have with, that has become important. So how are you going to adapt yourself and the firm to learning, training, and knowledge sharing is going to be critical. We at the firm have developed a learning platform. We call it Clementine, where most of the training and development and CLE that we do is now online. You log into the platform, there are videos which are live or recorded, which are available. There is a whole course curriculum that is set in, and people have to log in and do that. It's mandatory, and we keep a watch on how many people log in, what they do, what is it. We get feedback. So we improve on those videos, podcasts, all of that. So the new age technology, how we use them to our benefit is going to be key.
Thank you very much, Pallavi, for those very, very valuable suggestions and perspectives for the future. Let me move to Chris Parsons for his reflections about the future.
Yeah, look, thanks, Raj. I'll be brief because I'm very mindful of the time. Look, I'm going to take a slightly contrary view, but suggest there may be a big opportunity here for some of the young, bright lawyers who I hope are listening to this. So the contrary view is that I don't believe that law firms have really embraced technology in a major way. I think sometimes we convince ourselves we have. So, are we connected around the world? Yes, of course we are. Do we use social media effectively? Yes, of course we do. I mean, we've set up a number of centers around the world dealing with legal process outsourcing. So it's repetitive tasks that can be more effectively done through the use of technology. And we also have a tool called Digital Analysis, which helps to allow clients a better insight into how a piece of complicated litigation might turn out at the end of the day. So we are embracing technology, but it's not nearly as far reaching as I think we sometimes think it is. And I think that if you had a lawyer in India in 1950 and they were placed within one of our law firms, one of the law firms today, I don't think that they would see the job as that different. Are the numbers bigger? Are there more complications because it's more global? Yes, but the underlying principles of what we do day to day are exactly the same as they were in 1950, and probably even right to the turn of the century. And so I think there is a really wonderful opportunity when you look at what is happening, especially in India, around the unicorns that are growing up. The use of technology to deliver food quickly, deliver products quickly, help people arrange their holidays effectively. All of these things where technology is absolutely at the heart of the business. And for me, technology is not yet at the heart of the practice of law. And if somebody can do something in a way that I can't even begin to imagine, I think it could be transformative. And so I can't imagine it because, like Pallavi said, I still think that the business of lawyering is about our individual ability to find solutions to complicated problems. So if somebody out there listening, Jindal Global Law School or any other of the leading law schools in India can come up with some really out-of-the-box thinking about certain aspects of lawyering, and they can express that in a digital way, I think they could become very wealthy indeed.
Thank you very much, Chris, for those fantastic comments. Let me quickly
ultimately, technology is an aid to our own mind to make us think differently, use technology to be faster, quicker, get more information and more knowledge in a shorter time frame. It cannot substitute the human brain or the human mind. That's my belief.
Yeah, well, Pallavi, so that's exactly what Chris seems to be challenging, which is to some extent what one can talk about is to how artificial intelligence and robotics and machine learning can potentially take away some of the things that currently lawyers and law firms and individuals are doing, which might potentially have a change in the legal profession. But that's a future that we are all waiting to see to happen. Thank you, Pallavi and Chris, for that. Nishit, over to you. Nishit, please unmute yourself.
I'm so sorry for that. So the way in which I look at is that there are two parts. Every business or profession, I think it's both an art and a science. I think first thing we have to start an art side, that is, your philosophy of the organization, the purpose for which the organization exists, and the purpose for which our profession exists, and the purpose for which, so purpose-driven approaches will be taken as we move forward, and more and more people will recognize the importance of that. Similarly, there are specters of psychology, understanding people. So in any business or any profession, there are 4 dimensions. One, you got clients. Okay, so if you're good clients, number one, then you need good people. Okay, so how do you take care of the client? How do you take care of the people? You may have great clients, you may have great people, but you don't have processes. So you connect them through good processes. So if you do these 3 things right, balance, what is called, it's called balance scorecard. The finance is a lagging indicator. So we'll have to do innovation and both in terms of philosophy, psychology, all of the factor, anthropology, everything goes into building a client actually. And use of technology, as Pallavi mentioned, and this also mentioned to some extent, that technology is the greatest social leveler. It allows smallest player to work, compete with the largest. Of course, the whole ecosystem of competition will undergo change. It will be not just competition; it will be competition. You compete and cooperate and work together to create a better world for everyone. Same way, you have to look at the people. Okay, and there are a number of things that Pallavi mentioned. All of us, like education, but similar to people education, we have to educate client. I think so. We have one program called Client Continuing Education Program, CSAP. And but if you want to do that globally, obviously you need technology, and a lot of things can happen through that. And of course, the processes. Now we'll have to revisit the way in which we manage ourselves. Just to share some example, I'm not just teaching or talking. For example, we removed process of leave policy. We said no leave policy. You take as much leave as you want in the whole year. We don't care, okay? Just focus on the purpose and what deliverable are, right? Freedom with responsibility and accountability will be the new model. Hierarchies are falling down. It's very difficult to manage, centralized system. So we have to learn those new techniques. I don't want to again bore everybody with too many things, but I thought these are few things that processes are very important, but processes cannot take over people. Otherwise, people will be bogged down in process, and these are balancing, and that's so. I think if we can learn some of these things and learn from each other, I think we'll have a better place in the
Thank you,
world.
Nishit. Thank you so much, Gautam.
Yeah, I think I'll sort of, I think like Nishit mentioned, I think there are two parts to this. One is process, the other is sort of the substantive aspect of the work we do, i.e., tomorrow can artificial intelligence or the internet replace legal advice, right? On the first one on process, it's quite interesting. I think the legal profession, there was an article a while ago in the Financial Times that in terms of if you were to pick an industry that is least progressive when it comes to change, the legal industry is bottom of that pile. And it's not just embracing processes to become efficient, but if you look at even the way we are structured, we are probably among the last, we're literally dinosaurs in our organizational way because we still, we have 500 partners. We are a partnership, which I think is our strength. But if you look at other big players, other industry participants, they've corporatized, they've brought in external capital, they've innovated even when it comes to their organizational structure. I feel law firms, traditionally have been least receptive to change, and that also factors in on embracing technology when it comes to process management. Having said that, I think in the last 5 years, I'd say that has massively come under scrutiny, and I think the sole reason is the focus on profitability, the focus on sort of the gulf in profitability between some firms and others has grown so exponentially that everyone now sees technology as a must-have to be economically, financially survive, in a marketplace, right? Especially if you're talking about big law, right? So I think law firms are embracing technology not out of, sort of forward thinking, but in some ways, a lot of them are reactive to seeing it as tools to make themselves more efficient and more profitable. Okay. And therefore, I feel there are areas of law which from a there will be areas, there'll be the use of lawyers will be, there'll be a requirement, a natural upward movement towards the more sort of high sort of involved work, right? Discovery, diligence, those kind of things can be kind of processed out. Now when it comes to the whether legal advice can be entirely automated, honestly, Raj, I don't know the answer to that. I mean, can medical advice be automated, right? Would you trust sort of, taking your child and getting medical advice and giving them medicine after seeing the internet and Googling? I just think at some level, right, the human element is the reassuring factor. And I think on that second point, I think I'm just unsure, right? I'd be interested to see how that changes, how that
Thank you,
evolves.
Gautam. Thank you very much. Over to you, Sudhir. You have the last word.
Yep, Professor Raj, I think one of the biggest challenge which at least Indian legal fraternity will face, law firms will face, courts will face, is lack of employable people, lack of lawyers who will be skilled up, upgraded in their knowledge. The problem is most of the law schools in our country, 7 except the 5-7 like yours, they advertise and bring a student with fair and lovely kind of advertisements that you will pass out and a merchant will recruit you or Nishit Desai will recruit you. But are they in a position to be recruited? That's your biggest challenge today. The second thing is, how do you make them employable? How do you make them ready for training contracts, which is normally which happens in Herbert Smiths? So nobody in India understands that you need to be trained properly to work in a law firm. So these are the two major areas which I feel: employability factor of the law students beyond 400-500 or 600. When you are talking about 40,000 or 50,000 young lawyers coming out of these law schools every year.
Thank you very much, Pallavi and Gautam, Chris, Nishit, and Sudhir. What a fascinating panel discussion. I deeply appreciate your time. On a more personal note, I want to thank Pallavi and Nishit in particular for inspiring me long before the establishment of our university. You both have been pioneers in that for inspiring me, and thank you for that. I want to thank Chris in particular to be a big champion of our evolution since early days. And of course, Gautam and Sudhir have been dear friends. So thank you to all of you for joining us in this panel. I know for sure that everybody who watched this and who will be watching it will have immense things to learn and in many ways reflect about both the past, the present, and the future of legal profession. Thank you.
Thank you. Thank you, Professor Raj. Thank you.
you.
Bye-bye.
All right. Good evening, everyone. Good evening, good afternoon, good morning, whatever is the situation that you are in. And welcome to this discussion on clinical legal education. The topic of the discussion for this panel is outreaching the rights, globalization of clinical legal education. So we have a very distinguished panel before us. My name is Ajay Pandey. I am a professor at Jindal Global Law School, and I also work in clinical programs as its executive director. And I've been doing clinical programs for quite some time now. And it's indeed my pleasure to be a part of this discussion. The panel that we have today for this discussion includes Professor Vishal Domingo, who is the Executive Dean, Faculty of Law, University of Johannesburg, South Africa. Professor Deepika Jain, who is a Vice Dean at Jindal Global Law School, OP Jindal Global University. Professor Tanya Sodin, who is the Dean of Newcastle Law School, University of Newcastle, Australia. We have Professor Wang Zikang, who is the Dean, Fudan University Law School, Fudan University, China. We have a lot to learn from this very, very eminent panel, learning from the experience that you have of organizing, managing, administering clinical programs in your respective law schools. Of course, when it comes to clinical legal education, we gather that it's a method of teaching and learning law by doing it primarily. And as it is done, we also look at the larger objective, the larger purpose of clinical legal education, which is social justice. Now, when it comes to some of the realities that we face, as far as various larger promises of law and their the disconnect between those promises and their reality. What is promised to people, what is promised to masses, what is promised to those who need the support and the agency of law the most, and the grassroots reality. Now, of course, if legal education has to think in terms of ensuring that law is inclusive of masses, law is able to serve the masses, law is able to serve the underprivileged, the poorest, the weakest, and serve it in a way that it becomes a tool of empowerment, rather than a tool where people would be fearing law. And that is a scenario that we see. We see that scenario a lot in our context, actually, in India, when we experience that people generally are afraid of law. Law intimidates people. In that line of thinking, clinical legal education has tremendous potential, especially, of course, it has potential in other ways as well, but as far as the social justice context is concerned, the potential of clinical legal education is certainly tremendous, and it needs to be effectively realized if legal education has to be socially relevant, especially in that sphere, in that context. Law and its instruments, its mechanisms, its language, etc., for them to be inclusive of masses. I see a lot of potential in clinical legal education. And therefore, I have a couple of questions for the panel today. And of course, the panel would be sharing their own experiences, their own thinking and thoughts with us as far as their clinical programs are concerned. My first question, if I am to ask this question directly coming to the main concern of the disconnect between what law promises and people and grassroots reality, etc., and in what form and in what ways clinical programs can really respond to those challenges. And that question would be, who really decides the agenda and priorities of clinical programs of law school. And is there a thinking to involve the underprivileged neighborhood communities in deciding the content and direction of CLE, that is clinical legal education, and how can it be ensured? So that's my first question. And I can turn to our first speaker, Professor Visal Domingo. Professor Domingo, over to you.
Thank you for that question, and hello everyone. And thank you for the organizers for inviting me here. It's a privilege to be speaking to you today. Those are huge questions. Who decides the agenda and priorities of clinical legal education? And so I'm from South Africa. I'm at the University of Johannesburg. And I want to say that we celebrated our 40th anniversary of our clinical law clinics this year. So it was a proud moment for us. And I say 40 years because that's important, because the question asks who decides that agenda. Our agenda initially with the starting of the clinic started during the apartheid era. It was access to justice for poor and vulnerable communities at that time. And it was really fighting a political system of apartheid during that time. And that's how I want to say the clinics at that time was organic. And that's the way in which they started. It was a movement in terms of thinking, what kind of law graduate do you want? And what kind of legal system do you want at that time? However, since I want to say almost this organic rising of the law clinics, the question today is who sets that agenda? So we at the university, we have 3 law clinics, and they sit at different campuses. So one of our clinics is in a very vulnerable poor community, which is Soweto. So we have a Soweto campus. We have a Doornfontein campus, and so that's another group of vulnerable people within that community. And then we have a campus at a clinic at our main campus. So we serve 3 units. So what we've done with our particular university is we've taken the clinics to the communities. And we were fortunate that we do actually have campuses within those communities. Now, setting the agenda would depend on the resources of a clinic. So I was previously also the head of school of the University of Witwatersrand. There, the clinics are situated on the main campus, and it's divided into different law firms. So they do criminal law, they will do labor law, they will do divorce. And for me, the agenda is being set is really the resources and capacity that a law faculty has or a law school has, and that really determines the agenda of that. And the operation of law clinics can take place in a different way. We have attorneys, we have what we call in South Africa candidate attorneys, and then we have the law students who partake in our law clinics. It is a compulsory final year course for the law students to partake in what we call applied legal studies. They are divided into groups and assigned to a principal attorney. They meet real life clients, and that's the best part of this, that they are able to engage with real life legal problems with the guidance of a clinical supervisor. So I want to say the curriculum is decided in South Africa amongst different law faculties according to that particular law school. We provide services to indigent clients. So we have a tariff level. So someone coming in, we would say, are you unemployed or you do have a certain earning, and we calculate whether you are allowed to have access. But access to justice is the most important thing for our law clinics as well. And I think in a society like South Africa, and one of the things that you've mentioned is people fear the law. And you have to remember, in the psyche of South Africans, we have always fought the legal system. And so there's been almost a dislike of that processes that takes place. And so now that people have rights, we want to say, well, you can access those rights. And one of the places to do that is the law clinics. So that in a nutshell. I mean, I can go on forever, but let me stop there. Thank you.
Thank you very much. Thank you very much. I think one of the things that we really aspire for law school-based clinics is that any member of the community, neighborhood communities, anyone who is looking for a legal advice or legal service of any nature, any kind, should be able to walk into a law school and get that support that one really needs. And I think that kind of a scenario is something that we really envision in our law schools in India, and we have many law schools actually. And therefore, I think this learning is really important. I would certainly like to learn more from your experience, especially in terms of what is the impact of the clinic going to communities. This is what you said, and those questions. So I'll save those questions for your next turn. I want to now turn to Professor Deepika Jain. And my question, Professor Deepika, is about the potential that CLE has. And what is the thinking that, what is the true potential of CLE, and are law schools really prepared to realize that potential?
Thank you, Professor Pandey. Good evening, everyone. I'm delighted to be on this panel. I'm going to be speaking in the context of India and my own experience of teaching clinical legal education for the last 10 years, mostly on law and marginalization, and from my location of being an academic in the Global South. We know that the potential of clinical legal education is multi-pronged. It has pedagogical, social, and political value. CLE teaches students empathetic, critical, social justice, and collaborative lawyering. Although the traditional clinical legal education is mainly concerned with skills training and experiential learning for law students, the agenda in a country like India that is rife with social inequality has to be different and reimagined. There is no one-size-fits-all approach for legal empowerment or access to justice for communities that invariably experience intersectional discrimination based on various aspects of their identities. There is need to reimagine clinical legal education beyond sensitization of students. Therefore, first, it is important that legal clinics indigenize pedagogies and practices to create spaces for decolonizing work that is indigenous in nature. For example, in the Indian context, draw from indigenous and Adivasi people's perspective and anti-caste politics. Such clinics should be based on pedagogical approaches that question the state's colonial framing of law, as well as students' understanding of justice, which is mostly drawn from that frame by the state. The community in this regard is the primary source of goals of the project, keeping in mind the complexities, debates, and disagreements amongst the members. I have some more reflections, but I can come to that later, Professor Pandey.
Certainly. Thank you very much. I think being community-centric is so important for clinical programs, especially in a society like India, where we see this clear disconnect between law and its promises and its reality. Certainly. Let me now turn to Professor Tania. Professor Tania Sodden, my question to you is about as we collaborate, as there are different possibilities of collaborations between law schools globally, what are the learnings and benefits, if you can share some of the learnings and benefits of collaboration? Any thinking on the aspect of how clinical programs can be more impactful if there is effective collaboration amongst law schools?
Thanks, that's a wonderful question. And I think it's probably a deficit at the moment in relation to law schools, in that I don't think that there is as much collaboration as there could be in relation to clinical programs. There are, of course, vast differences between law schools internationally and even within my own country in terms of what is offered with clinical law schools. And it's the question of at what point do you encourage and foster collaboration internationally. So from my own law school experience, we actually start our students even in year one with some clinical work where they're at least observing in the clinic, and then they'll moot before live judges, and then they'll have other experiences. And by the time they get to fourth year, they all have a placement within our own clinic, which is run by our own lawyers. And it's similar, I think, to what we described in terms of a group of lawyers with a small number of students, which will go with each lawyer, and they're carefully supervised. In relation to collaborations with international clinics, we have had, I think, a bit of success. More recently, we've been collaborating, for example, with Coventry in the UK. And we do that because we have 2 robots that assist, and those robots have been used recently also with our international students. And that enables the student to actually be in the room of another clinic and to consider, for example, how the law might apply in another country. And I think this is a fascinating extension for our clinical students who've really enjoyed that experience. And for our international students who haven't been able to return to Australia because of lockdown, it has also meant that they can engage with clients. And so these sorts of collaborations, I think, are really interesting because we can see what happens in other parts of the world and then see how we might improve our own clinical experience. From my own perspective, we have a number of different clinics that operate. We have generalist clinics as well as specialist clinics. So we have an older person's legal clinic to work with more vulnerable groups. And then we have special interest clinics, so environmental or special interest cases clinics. And some of those are collaborative clinics in that we will work with social workers and others. And from a global perspective, it would be interesting for us to find out how many clinics are operating with a multidisciplinary approach and how well is that working. Next year, we extend into a series of innocence projects with our criminology students, and all of this is very beneficial. And of course, we're learning from some of the US experience in relation to innocence clinics. What is successful within clinics is really building on local roots. And coming back to your first question, there does need to be human-centred design. You have to very much consider really what are the local conditions and what's going to work for your population in a local area. And by far our most successful clinic is probably our Law on the Beach clinic, which runs every summer. And it runs out of a surf club on the beach. We're surrounded by beaches here, and people literally come out of the water with their swimming costumes on and go and get legal advice. And that clinic is much loved by our local population. And because of, I think, the way that it's set up, it's casual, it's informal, people are not frightened about going to the clinic, and it runs extremely effectively. But we're able to do that because it's a reflection of local conditions. And so there are some, I think, clinical ideas that can be readily transported from one country to another, but then there are others that are probably more problematic. The final matter that I'll raise is we also do special project work in other countries. So, for example, as part of our clinical extension, we've done some really great work on legislation in the Cook Islands, and our students travel around the world supervised by staff and do really interesting work in other countries. And I think that's a fantastic extension in our region. Again, it's really got to respond, I think, to what the local regional conditions are too.
Right. Thank you. I'll certainly come back to you and learn more, especially the experience of the students that you may be wanting to share with us. At this point, I want to turn to Professor Zikong. And my question to Professor Zikong is about the benefits of clinical legal education for communities other than the students, especially during the pandemic. Of course, we tried and we found different ways to still do clinics during the pandemic, and there was several limitations and challenges. And I'm really curious to know how law schools have really fared in terms of what benefits were accrued through various things, new things that we learned to cope with the conditions of conditions and certainly those several limitations and challenges of pandemic. So over to you, Professor Jikam.
Yes, thank you. It's a great honor for me to attend this panel. And yeah, it's a sad time for the pandemic spreading all around the world. But fortunately, it's not so fast for Chinese campus as well as law professors and students. We are not under such pressure of COVID situation. We so far have 5 cases in Shanghai, which is 23 million people city. So it's lucky for us. In terms of special condition, we are not so special now as we feel. But as a Chinese law professor, I want to share with my colleagues some of the background of the clinical legal education in China. The teaching method of clinical law is an imported or transplanted teaching methodology since 20 years ago when I just started my teaching career. It's imported from the United States. As I know at the very beginning, the Ford Foundation was advertising this methodology, teaching methodology of law schools in most elite law schools in China, and that time, from that time, it's welcomed. But I have to admit that we saw the tension between different goals of the legal, clinical legal education, meaning the tension between training experiential skills and serving pro bono ideas. On one hand, through clinical legal education, we can train students practical skills. But on the other hand, if we just focus on those underprivileged societies or groups, we will miss some part of those skills, such as those existing in the cases like IP, disputes, or corporate or bankruptcy, so on and so forth. So our colleagues in China basically focus on the benefits that we can take from the clinical legal education of training practical skills more than serving its pro bono ideas. And for the latter part, that does not mean Chinese law school does not pay attention to that focus. We provide other channels like setting up legal aid societies and carrying out activities by students and offer legal ethics courses and so on and so forth to serve the other focus which was originally served by clinical legal education. So my key point is by the term clinical legal education, we may have different focuses and serving different purposes.
Thank you very much. I think pro bono ideas and working on pro bono ideas is certainly much required. And I think clinical legal education can fill that area to a great extent. There are several good stories and success stories and learning of students and empowerment of communities. And we are talking of when we really talk in terms of clinical legal education, responding to the needs of social justice. We have this entire vibrant community of students trying to do good work and also trying to make sense of law as to what they are really wanting to achieve. And also assume that larger leadership role that we want our law students to really assume to respond to some of the problems and challenges that we face, and we really do not know where to go and how to resolve those serious issues and serious concerns. When one really looks at that scenario, and of course the disconnect that I keep talking about, that's something that really worries me a lot, because I see it and it's too obvious to be actually overlooked. That clear disconnect between what we do in law schools, legal education, and all of that, and what's the state of access to justice and legal aid and things like that, and community empowerment. And of course, one of the larger goals that we also envision in our minds, and that is of including people in the language of law, in mechanisms of law, such that it becomes truly inclusive of masses, right? In a way that masses should be able to appreciate. Now, along these lines and this thinking, there must have been some inspirational stories and success stories and good stories to tell. So I can turn to all of you to share those good stories for our viewers of this panel. So I'll first turn to Professor Tania, to you, and please go ahead and share some of the inspiring stories with us.
I'd love to do so, and I'm hoping that they will enable me to share my screen. At the moment, I think it's still disabled, but I'm very happy to talk about how inspiring it is for our students, because their clinical experience takes place throughout their educational journey. As I said, in fourth year, they have this fabulous experience where they work within our clinical environment, and then in fifth year, they have external placement where they may work with commercial and other firms. And I think what's really exciting about that experience that the students certainly share with me is that they take that experience from fourth year and those earlier formative experiences, and those experiences encourage them to think about pro bono options throughout their entire life, even when they're, of course, working at more senior commercial firms. And I think that's really exciting. And for some of the students, what their reflections are really reflections on how they were unsure about what they would do in terms of their legal career. But the clinical experience really highlighted to them different pathways that they might not have otherwise experienced. And they are incredibly enthusiastic, I think, about these experiences and how they shape them. And if I can share the screen, which I still can't, I would share with you some of the reflections of our students who just finished their placement last week. I think the enthusiasm that they have about the law and the love of the law that the clinical experience creates, it just seeps through what their feedback is. And I know even when they graduate and I talk with their alumni, they always remember their clinical experiences. And what is so important about all of this is that they're able to put themselves, I think, in the shoes of their client, no matter where their client is. So if their client is government or if their client is a large corporation or whatever, they actually are better able to understand what their client is doing. And I think they leave with a much broader focus on societal benefit and what law as a profession can offer to our society. So I think that's exciting, and it's a wonderful area to be involved with and working with. So as you can see, I'm very proud of our students and very proud of our clinical program. So thank you, AJ.
It's so good to know, certainly. And we'll figure out how you can share your screen. I really don't know how that can happen, but I certainly request my IT people to help you with that. And I'll come back to you. So over to you, Professor Deepika, now to tell us of your stories of inspiration and what have your programs actually achieved in terms of the impact and what is the way forward. And we are really quite curious to understand and also explore how we can bring that impact that is so much needed. And in that sense, I would also point at the fact that when it comes to education, and that to legal education, and the larger problems that we see in the world, it seems that it's a failure. Somewhere at some points it seems like a failure, as if we have failed. Education has failed, and in that sense, I see a lot of hope in clinical programs. And I turn to you, Professor Deepika, to actually share your stories of inspiration and motivation. So over to you now.
Thank you so much, Professor Pandey. So I think one of the stories that I'd like to share is from my Law and Marginalization Clinic in 2017, where we offered a course called Gender, Law and Difference, in which we collaborated with International Commission of Jurists, HIV/AIDS Alliance, and MARG, which is a legal literacy organization in the country. So one of the challenges for our clinic has been that we've been looking at how do we center the community, learning with the community rather than learning on the community or learning for the community. So I think collaboration was one of the ways to do it. So the collaboration was done in a way that it was not just a project-based collaboration, but the entire year we taught together. It was collaborative teaching. And we basically decided to work on something that came from one of our friends from the transgender movement in the country, where they said that they would like a handbook which basically demystified the law, the Nalsa judgment, which had come in 2014, which recognized self-determination of transgender and gender non-conforming persons in India. So we worked on that for a year with the community. And after a year, we, with the help of Professor C. Rajkumar, we did what the community really wanted, which is a fully funded course on campus, which is called the Human Rights for Transgender Persons in India. And it was basically a course which was developed in collaboration with the movement, with our friends from the movement. And 70% of our faculty members who taught this course were also trans persons, scholars and activists. And we decided in this clinic to take a sort of a backseat, learn with the community and sort of make it very community centric. So 25 of our participants were grassroots activists, and it was a really successful clinic only because there was centering of community. And I felt like that was a very powerful experience and also a future direction for us to sort of pause and sort of reflect on how do we do this kind of work, and then sort of move forward with hope that this is possible through collaborative learning and taking a step back and engaging in reflective learning, where we also question not just what changes we can do, but how do we learn from our privileges, our locations, and our commitments, and sort of then sort of carve projects in collaboration with communities?
I think that's a wonderful example, and it's so inspiring. I often, as a person associated with clinical legal education for quite some time now, I often have this question that how to make law and its processes and its provisions and its language, its mechanisms, its structures, etc., real for people, real for masses. And I think one of the things that Deepika, you have done is really commendable, and that is participation of communities. You know how much we really enable communities to seek their participation, or is it no kind of one-way traffic? We go with a certain baggage. We approach communities. We know what to do with them. So our priorities, not really their priorities. And I think their priorities is so important, because law cannot happen without people. And that's the larger question that I always have. Law is something that cannot happen without people. And if it is devoid of people, if it is devoid of masses, it is not going to succeed. And perhaps we are in a state where law is not succeeding, right? To say the least. So now I turn to you now, Professor Vishal, for your experiences and stories of success and inspiration. Those 40 years.
So 40 years is a big thing for us. And just to say, when our law clinic started, we had one attorney sitting alone with one student. We had to fight for students to be part of that program, to be part of the curriculum. So I want to just say one of the successes is that in 2016, all law schools in South Africa was assessed by the Department of Higher Education here. And one of the things that they commended most of the law schools was for having law clinics and saying it should be compulsory for students to partake in those law clinics. So that's a huge step forward. I also want to say that law clinics in law faculties, and I'm not sure if this is the same experience with other colleagues, has been almost outside of legal education. It is something that a lot of professors say we teach them the theory, and then we send them off to you, do the practical things with them, take them out. And so for me, one of the things that I think we're trying to develop in South Africa, in particular within my institution, is a scholarship of clinical legal education. And I think that is where the sharing comes, because it is teaching. And often it's not seen as part of that legal education and curriculum. It's where they say, oh, they do the practical skills there. And the other professors who think they do the pure teaching, there's a disconnect between those two. And so for me, the strides moving forward is to see that integration and that scholarship of clinical legal education increasing. One of the successes that we've had as law clinics is that law clinics in itself, because we get funding is a problem for law clinics. We have to get funding from government and try and get donors and bursaries. So it's really dependent on that. And because you have that, you're often seen as a David and Goliath. So you have these large corporate law firms who often think, well, you know what, the law clinics and the law students, they do their little bit for society. But one of the successes we had is that we took the Department of Home Affairs in South Africa to court, because we had an indigent woman who came and she went to the Department of Home Affairs and found out that she was married to someone who she has never met. And so what this was a type of sham marriage where her identity, and the department then said, well, you need to get a divorce from a person, she has no idea who it is, and she has children attached to that. And this became a huge case. It went forward, but it was settled because the minister then came to our law clinic and said, thank you very much for the work that you've been doing. We're going to settle this matter. We understand that this is happening to many women out there. Now, you can imagine this woman has to go through a legal process of divorcing someone that she has no idea who it is. And so those were some of the successes that we've had at our law clinics as big ones. And then we have had small ones. But what I want to say about the student experience is that it's also given students motivation and confidence in themselves. And what it is it doesn't matter where they're going, whether it's that corporate large firm, which we say, or the public interest litigation that they go in, they take something with them around that experience in that law clinic. And often I have students that say, well, I'm thinking about business law and corporate law in a human rights way. I'm seeing it through that lens. And I'm saying, yay, so at least it is that community citizenship that's being instilled. And so in South Africa, we say it's Ubuntu. It is community. It's not just about the I, it's about the entire group. But moving forward, one of the disparities that we felt during COVID, and I want to raise this in terms of law clinics moving forward, was the inequality in access to justice using technology. And so when we moved to an online system where we couldn't see clients face to face, everyone was saying, well, you know what, put up a online system, put up a chatbot. That was not easy for communities in rural areas that don't have electricity, that don't have data, and that doesn't have a smartphone. So the reality of also moving into the fourth industrial revolution would be to try and understand how that will impact the work that law clinics do. And so what we had, couldn't see clients face to face, but we had them fill out a questionnaire. And everyone was saying, put the questionnaire online. Now, in South Africa, we also have different languages. So people don't only speak English. There's 11 official languages in South Africa. And so one of the things that we try to do is, so the questionnaires has to be in different languages. How would you create an online system to accommodate people actually being able to use it? And so when we have face-to-face consultations, we often say to the student, if you can speak Zulu or Xhosa and you've got a client like that, do that first engagement in that language. And so what we're trying to do is to say, well, that in itself makes law accessible because you're hearing it and understanding it in your own language. So we have multiple problems, I want to say, and issues in South Africa, but that's where the law clinics come in. And I do think that we as law clinics would have to think about how we then engage with this in fourth industrial revolution, how we engage in an online environment. One of the things that you asked was, what were the lessons? What worked excellently for us was going online in terms of the tutor sessions and engaging and get students to write and to do their motion of notice or whatever. And so that helped in testing that ability. So there were benefits. But my fear about the online system and even court systems going online is the inequality and disparity in a community. And so that's a concern for me.
Thank you very much, Professor. I think that is so important. Inequality and different ways of inequalities, new inequalities, inequalities in terms of accessing justice, legal aid, and all of those aspects. I think that's really important for a law school to be socially relevant. We have to really think of these questions very, very seriously. And of course, clinical legal education gives us that kind of scope. And I think that scope really needs to be understood and explored and utilized. I have started receiving questions from the audience, and let us take some time for these questions. So I'll come to you, Professor Jikong, and there's this question from the audience about interdisciplinarity. And of course, clinical legal education provides that avenue too, actually, of interdisciplinarity. So what is the impact? I mean, this is the question. What's the impact of interdisciplinarity on CLE?
Yeah, that's a very good question. It's a reflection of the new direction of legal education and development of legal science. I fully agree with you in terms of the belief that law and legal education should be socially involved. And our experience is that we need to broaden our vision and to incorporate more energy and expertise from outside of law school through the channels like clinical legal education. I give you an example. Our clinical legal education courses are not only taught by specially designated law professors. As I just mentioned, it's a transplanted system from the US. In typical US law schools, they hire some clinical law professors who are specializing in teaching clinical courses. But in China, we don't have such kind of position. And at the very beginning, some professors who are also act as part-time lawyers teach those courses. And now we turn to hire some part-time tutors or professors of legal practitioners to teach clinical law courses like banking disputes, mediation, and we have external expertise of lawyers, mediators, arbitrators who have multiple disciplinary background and knowledge. So it not only deepen our collaboration with practitioners, also it broadens the vision of students in terms of their perspectives from different subjects and disciplines. Yeah.
Thank you, Professor. I would actually ask others as well, if anyone else is interested to take this question. I think it's a very important question. Professor Vishal, please go ahead.
Yeah, I like that question of interdisciplinary because I see it in a different way. One of the things that we did this year was we had a work integrated learning. And so clinical legal education was almost work integrated learning. But one of the things that the students did, and was an initiative by the clinic, was to work with other students from other departments and faculties. So the whole idea of access to justice, they said, well, let's get some marketing students together, let's get some commerce students together, because we would have to work the budget and the project for this plan. So we got students from different faculties to work as a unit, as a team, to put a product forward. And I think that was very important. So that's where the interdisciplinarity happened, where the law students are not saying the work that I do in isolation. So that was also a very important part. So that's just one example. Thank you.
Thank you very much. Thank you. Yes, Professor Tanya, please go ahead.
Yeah, I totally agree with what Wasal has been saying about the importance of interdisciplinary clinics. And one of the great benefits that we have in one of our clinics is we have social work students and social worker staff, because many problems that are presented as legal problems actually have a number of other dimensions. Next year, we will start our tax law clinic, which is funded by the Australian government. And in that tax law clinic, we will, of course, be working with business students as well, which is wonderful because, again, for many clients, they also need financial planning advice and financial counselling. So having a range of services available is great for the clients, but it's fabulous for the law students who really learn to work outside of just working with other lawyers and to really ensure that they're able to support clients once they leave law school in a much more holistic manner. So I totally agree with your comments as well, Lisa.
Right. Yes, Professor Deepika. Yes, please go ahead.
Yes. Just agreeing with everyone and echoing what everybody said, I think interdisciplinarity is inevitable in a clinical project because, before we launch into the community work, it's really important for us to have some kind of framework for cultural literacy for our students. And one of the ways to do that is through interdisciplinary and holistic approaches to clinical legal education, which also allows for valuing of, like, for example, self-determination of indigenous communities throughout, or sharing knowledge of communities, histories, and places. So I think if you're doing a clinic in this, it has to be interdisciplinary.
Right. Yeah, I think that's certainly it's a very, very important point. And thankfully, clinical legal education actually provides the avenue for education to be interdisciplinary, which is again benefit that needs to be explored for legal education. There are a couple of other questions, and I think I would like to take one question which is about spreading awareness about legal clinics, and how can young people know more about legal clinics, and how can they be involved in clinical programs and things like that. So how do we actually, as we reach out to different stakeholders, communities, young scholars, people who want to work and get associated with clinic, collaborators, etc., how to actually achieve that, how to spread more and more awareness that can bring and more stakeholders, and of course that confidence that is also required, that people have that kind of confidence in law school clinics. So any thoughts, anyone on that? Anyone would like to pursue that question, not really answer, pursue? Yes, Professor Tanya, yes, go ahead.
Thanks so much, because I think this is a great question. I know what really makes the difference to our students when they graduate is that employers want to employ them because they've had that clinical experience. And that of itself creates a focus on clinical programs. So we know already from employers that they would much rather have a student that's had a really extensive clinical experience on the way through their law school. And so that drives interest amongst employers. Alumni certainly send that message, and we're not at the point that Wissal is with her 40 years, which is so incredible. We're at about 25 years for our clinic, but the alumni send the message as well. And so you've got both ends of the spectrum, or more than both, because the students are excited about it as well. When they compete with other students in their competitions, they win because they've got that clinical experience. They know how to interview, they know how to negotiate, and they know how to advocate. And so the interest in clinics is really supported at a number of different levels. And I think that's great for the students. And of course, there are these positive outcomes in terms of employment as well.
Thank you very much. There is a question that I think we should pursue, and that is in terms of the roadmap. We know the challenges, we know the different larger objectives that CLE has for itself. An example of India, if we look at our own law schools, Professor Vishal, you said that's 40 years that the law school is doing clinical programs. In India, clinical legal education is also, it's quite old actually. It's at least early 1970s. The universities came up with clinical programs and they started legal aid clinics, etc. However, we have yet not been that well developed that we can actually serve the purpose, right? So in terms of that roadmap, looking at what we want to really achieve, and of course there also has to be a sense of urgency in achieving what we want to achieve, because newer set of problems come up, and then we tend to to pay our attention to those problems. And then the problems of communities and the underprivileged sections of society, I mean, they become a matter of discussion only, not really, I mean, that kind of priority that comes from these quarters. So I think the question is that what is the kind of roadmap that we should be envisioning for clinical legal education to grow for deeper impact in society? Any thoughts, anyone? I mean, this is a question for everyone, and we have to also conclude. Now we are almost nearing the timeline that is given to us. So please go ahead. Professor Deepika, should I come to you, or? All right, please go ahead.
Yeah, I think this is a really important question and something that I have been deliberating on quite a bit because we're restructuring our clinical legal program at Geneva Global Law School. And I think there are a lot of factors that are really important for a clinic to be successful. For starters, we need political will and deep commitment from head of the institutions, which also requires a lot of funding, full-time faculty hiring, full-time faculty staff, giving credits to students. So there are some structural limitations why clinical programs don't work. And I think if there is going to be a collective thinking on that and institutional commitment, I think clinics can work and can do very well, as we've seen in many parts of the world. So I would think that it starts with the head of the institution being deeply committed to the idea of clinical legal education as social responsibility of any university.
Right. Professor Tania, any thoughts on that?
Oh, I just agree entirely. I mean, it really is about the values of the university, and all universities are here, I think, to serve their communities. And it needs to, I think, be very clear that that is part of why universities exist, not just to educate, not just to research, but actually to support the well-being of communities. So I agree entirely with what you say about that institutional leadership. It's so important.
Right. Professor Jigong, your thoughts?
Yeah, certainly I agree with the concern that we are taking a strong responsibility, social responsibility to serve the society, the community, and the country, as well as the world, particularly in this special period. And legal clinical education methodology, I think, could serve part of those roles in our curriculum and law schools. And I think in terms of the MAP road, I would suggest it should be incorporated with other curriculum and methods like age, like mood course, just as one of my colleagues mentioned, and other courses and PET and teaching method.
Great, thank you. Over to you, Professor Vishal, and then we have to wind up.
Okay, thank you. I'll try and be brief. I agree with everyone, but for me moving forward, I think it is clinical law clinics operate in a social justice environment, so that's very important. But for me moving forward, and I think about, okay, we 40 years, what's the next 40 years going to look like? I do think that we have to think about clinical legal education in the context of blended teaching and learning, in terms of the fourth industrial revolution, in terms of automated systems of what will our students no longer do. And for me, one of the most important things about the law clinics is, and I don't like using this word, but I'm going to use it, is the soft skills, the negotiation, the interaction, things that I would say is in the hidden curriculum. I think with moving into the fourth industrial revolution, the ability to have emotional intelligence is going to be essential. So that in a nutshell is some of my thoughts moving forward.
Well, thank you very much. Unfortunately, we have to close this session. I know this conversation is so important and I have learned a lot. And certainly, I mean, I do believe that the viewers and the listeners would have been benefited from this conversation. And I think this conversation should go on, and we should find ways to collaborate, to work together, to talk about some of these aspects. And I think it's really important. It's really important for a law school to give due emphasis to clinical legal education. It's really important. And you've talked about institutional leadership. It's really important that if we have to really certainly effectively address the disconnect, and it's huge and it's serious. It's really serious. I mean, if I'm to give the reference of the current Chief Justice of India, what he recently said, he said that the judicial system needs serious overhaul in terms of responding to the needs of communities, in terms of responding to the needs of people, access to justice, legal aid, and those aspects. So I'm going to thank everyone. Thank you very much for your immensely valuable inputs and your participation. And I close this session now. Thank you, everyone. Thank you, viewers, and thank you, all the panelists. Thank you very much.
So thank you very much, Professor Pandey. Thank you, all the distinguished speakers, and to all the audience who have been connected to us through our YouTube channel. Please stay tuned. In a few minutes, we'll start our next session, which is going to be a special dialogue, Greening Environmental Law, Role of Environmental Law, and the Rise of Environmental Consciousness. Please stay tuned. Thank you very much. I request the moderator to please start. We are on air.
Good evening, everyone. Haiwa Ilta Paiwa Buna Ziwa. A very good morning.
Bunai Siwa.
And it's a cold, foggy evening in Sonipat, Haryana, India. Greetings to all of you who've joined. Thank you very much for joining. This session, as you know, is on greening environmental law, role of environmental law, and rise of the environmental consciousness in and around the world, especially within the law students, the legal fraternity. So I'll start with a few things which generally come to my mind when I'm in my class. And whether it's Wordsworth's daffodils or Frost's lovely dark and deep woods, Bond's cherry tree or Blake's tiger, or indeed Rudyard Kipling's jungle, it will not be trite to say that environment and nature have played such an important part, and they keep on playing this important and significant part within our digital and COVID-infected and globally shared lives. However, much is the talk of environmental and climate change issues amongst the diverse fora, one cannot also deny that in the last century, with the scientific growth and development and the capitalist economic ideology, we have extracted resources in much unsustainable ways. We have taken for granted the limitations of planetary resources, and these, of course, have been posing a threat of linear extinction for the biodiversity, raising so many problems of environmental harm, harm to the planet. Along with that, globalization and development have in the last century also cast a burdensome toll. The loss of biodiversity, the imbalance in the ecosystems, climate change, erratic weather patterns have extolled its cost, a disproportionate cost on the human environment very, very dearly. The recent findings, as all of us are aware, of the UNEP, the IPCC, and the recent COP26 deliberations reiterate over and over a truly devastating picture, but there is this wake-up call, a call for action. And the choice has never been clearer. It demands the raising of environmental consciousness, application of nature-based solutions, or be it better governance policies and laws, recognition of the most vulnerable communities as the first respondents, and crafting, I think, of a duty-based normative global framework as our last chance to remedy the wrongs towards making our planet Earth better. It, of course, need not be emphasized or re-emphasized that this degraded environment has led to devastating results, which we are seeing in the form of displacement of refugees, island nations submerging, the energy crisis that we are facing, water scarcity, displacement within the states, environmental insecurities, and related threats. So it's absolutely unequivocally clear that we must put our heads together. We need to come up with sustainable solutions within the dominant ideology and also take into account the cognitive dissonance and recognize the diversity of beliefs and opinions. And we need to work upon environmental and natural resource governance and management within three rubrics: the urban, the rural, and the wilderness sectors. If one is looking at global studies, as we have in the yesterday and through the sessions that we have had today, for formation of curricular formation or formulation amongst law schools, especially law students, the reading of environmental law in its various facets, interdisciplinarity, comparative, global, it becomes naturally mandatory. So given the phenomenon of globalization, modernism, postmodernity, the empirical evidence that we have keeps on mounting that natural limits to growth are being overstepped. There has been an increase in this environmental arena, and various kinds of research, whether it is legal hermeneutical research, environmental epistemological research, socio-legal, socio-political, quantitative and qualitative, all such research, the methodologies might have informed the environmental discourse within both developed and developing countries, but much has to be done. It has also led to a search for answers, I suppose, of a different kind, including the emergent ethics based on ecocentric approach and what I said as a global duty-based ethics. So an argument which comes naturally for academics, for legal policymakers, is to make sure that lawyers that we train are equipped with the knowledge, with the methodology, with normative as well as the normative and the theoretical basis, and they are well sensitized to the challenges that we face vis-a-vis the environment. So how we train our lawyers, how we talk to the students, how we develop this global environmental law curricula, probably amongst us within the law schools across nations, we need to answer these questions and address the legal analysis probably maybe on that basis. So what sort of knowledge will will the environmental epistemological study possess, whether the students would take care of not thinking within compartments, within fragmented areas of law, but probably that when we are studying environmental law, as yesterday, Justice Governor Beasley was talking about, and Justice Geeta Mittal was talking about, they did emphasize comparative environmental law or comparative law studies. So that also becomes important within the legal analytical context. So today we bring forth experts from around the world to look at this specific shifting, fragmented world, which is somewhere it has found some common thread under the rubric of global legal studies, especially in respect of the environment. And one of the many things that we would like to discuss is how is it that lawyers, as lawyers, and the lawyers that we educate can contribute to a more sustainable future. And it is my pleasure then to introduce to you the expert panel. And just before that, I would just like to also talk about one quote which comes to mind, that it is, while we are doing this and while we are discussing it, it is more than a question of teaching techniques to the lawyers, teaching economic concepts to the lawyers or the students, but we need to teach them or make them more conversant with the reality of life, as well as the concept wherein we keep on having so many debates on justice, especially environmental justice, the sustainability within the ecosystems, and reimagination of working with the community. As I said, the communities which are vulnerable, the first respondents. So probably a holistic sense of dealing with environmental law should be emphasized. Probably, this is my opinion. And so this distinguished panel, therefore, is going to probably discuss the shift in the epistemic lens within this framework. And welcome once again. So let me introduce the speakers. I will start from Professor Timo Koivu-Rova. Professor Koivu-Rova is a research professor at the Arctic Center of the University of Lapland. He has also worked as the director of the Northern Institute of Environmental and Minority Law at Arctic Center since 2004, and he is also part of the Arctic Center, and he's been there until 2020. Professor Koivu-Rova is a member at the Social, Economic, and Cultural Expert Group of the Sustainable Development Working Group of the Arctic Council. He's also a docent of international law at the Faculty of Law, Economics and Business Administration at the University of Eastern Finland and at the Faculty of Law at the University of Turku. He specializes in various aspects of international law applicable in the Arctic and the Antarctic region, and his research work addresses the interplay between different levels of environmental law, legal status of indigenous peoples, law of the sea in the Arctic waters, integrated maritime policy of the EU, role of law in mitigating and adapting to climate change. Professor Koirova is also a board member in the Arctic Research Consortium of the United States. Welcome. Next on the panel is Professor Christiana Ochoa. I hope I'm pronouncing your name correctly, Christiana. Professor Ochoa. Ochoa, is it?
Ochoa.
Ochoa. I'm sorry. My apologies. Professor Ochoa has been recognized for her research, teaching, and service, and has held numerous administrative positions at the law school, campus, and at the university level. In 2018, she was named as an Indiana University class of 1950 Herman B. Wells Endowed Professor. Her research seeks to understand how economic activity impacts human and ecological well-being. Her theoretical and empirical research relies on international and comparative law, particularly in the fields of business and human rights, law and development, international finance, and FDIs, or the foreign direct investment. She brings her field of work as well as her practice experience at the global law firm Clifford Chance and with a number of human rights and humanitarian NGOs in Latin America to her research questions and her classroom teaching. Her scholarship in these areas has been variously published in a number of leading journals such as Yale, Harvard, Michigan, Duke's. Her work's also been published internationally, including in Germany, Colombia, and Korea. Apart from being such an eminent academician, she's also an accomplished film director and executive producer. And her first documentary, Otra Cosa No Hay, There's Nothing Else, was completed in 2014, and she received critical acclaim for this. Welcome, Professor Ochoa. Next on the panel is Professor Veronica Rebrenu. Professor Rebrenu holds the title of Doctor of Law at the Babeș-Bolyai University, Cluj-Napoca since 2001, Romania. From 1998 until now, she's been lecturer at the Faculty of Law of Babeș-Bolyai University, Cluj-Napoca, and lecturer in subjects theory, general law, special issues of theory of law and environmental law. From 1999 to 2002, she's been a part of the Socrates Erasmus program in Great Britain at the University of Exeter School of Law. In summer of 2004, she wrote the research program, Economic Development and Environment, and how to combine these two vital needs in the transition stage from development to integration. It was funded by the Rotary Organization, and for a program whose scientific coordinator has been appointed. She's also worked as a personal advisor to the Minister of Education and Research. She's been presenting a number of papers in a number of prestigious conferences. She holds many certificates of participation on academic cooperation and competitiveness. And she's from 2013 to 2019, she was the scientific coordinator of the student teams, which had participated in the International Youth Innovation Competition on Global Governance, organized by Fudan University. So welcome, Professor Rebrenu. And lastly, we have Professor Bharat Desai. Professor Bharat Desai holds a chair at JNU, that is the Jawaharlal Nehru University. He is a professor. He's been my professor as well, a friend and a colleague in international environmental law. And he's a professor of international law and chairman of the Center for International Legal Studies in the School of International Studies of the JNU, New Delhi. He serves as the editor-in-chief of the Yearbook of International Environmental Law, OUP, United Kingdom, and chairman of the Center for Advanced Study on Courts and Tribunals in India. Professor Desai has contributed tremendously, and his books are pretty popular amongst the students. His significant books include International Environment Code, A Legal Study of an Ideal. This was published by Boston Brillnioff 2018, International Environmental Governance and Multilateral Environmental Agreements, Legal Status of Secretariats, Institutionalizing International Environmental Law. He's mooted a proposal for much earlier, for the United Nations Environment Protection Organization, as well as the revival of the UN Trusteeship Council with the new mandate for environment and global commons, in an invited talk way back in 1999, January, at the legal department of the World Bank. And these have been published in important research papers in a number of journals all across. Professor Desai has been consulted by the various ministries within India, Union Ministry of Environment and Forest, Ministry of External Affairs, and he's initiated and coordinated a number of interdisciplinary and inter-university consortiums, especially on the themes of Himalayan cryosphere, atmospheric aerosols, and geospatial information systems as unique knowledge platforms to generate futuristic cutting-edge knowledge in the respective fields. So Professor Desai, welcome. So having given you a little bit about all of you, I welcome you all once again. And I would like to take the discussion forward by posing the very first question which came to mind, within the context which it might be fruitful to have this discussion, which places the importance of global environmental studies and the content with a focus on normative, analytical, experiential, and hermeneutical immersive learning. So I'm going to kick off with the first question for the entire panel, and you may take it from the order in which I spoke. So the first thing which I'd like that you could address would be the evolution in environmental epistemology. It basically started from the era of exploitation, then to conservation and preservation era, and finally to the ecocentric era, which is now being spoken of restoration. Has this change occurred organically out of the concern for the environment, or have we been compelled, forced to make them based upon the anthropocentric requirements in the face of the environmental adversities? Yes. Professor Koiruova?
Yeah, I can start. Thank you very much. And greetings from Finland, and greetings from the Lapland, from the Arctic Circle, so from the other side of the world. So I would first of all say that we haven't reached the ecocentric era of restoration. I think that we have to be kind of realistic as to where we are at the moment. We do not, in more broad terms, we do not kind of see the nature having an intrinsic value in most contexts. So irrespective of what human beings think of it. So I think that that's, for me, as a kind of general statement, is the kind of starting point. If we look at the way our society still work, it's very much on the basis of measuring GDPs and for instance, if we see the reactions to the financial crisis of 2008 or the current pandemic, which were kind of urgent crises, we also understand that we as a society and as a humanity, we can react very swiftly to these kind of urgent issues. But then we have severe problems when we are really confronting these long-term issues, climate change, etc. And I would say that also it is very much on the basis of these anthropocentric requirements. So we can tackle those environmental problems where we can clearly show what are the harmful consequences to human beings. And one kind of a successful example that we normally take up here is of course how we have tackled the ozone layer depletion. So with the Montreal Protocol. So yes, that would be my first take.
Thank you. Thank you, Timo. May I come to you, Christiana?
Yeah, absolutely. First, I just want to say thank you to Jindal for organizing this really great panel. I'm really excited for the conversation, and I really appreciate, Charu, your work in facilitating our gathering. So thank you so much. So I actually think this is a wonderful place to start the conversation because it lets us situate the conversation within the dialogue that's actually been going on for a very long time. So whether we look to what we know about environmental history or